Okay, good morning. Hearing Board, South Coast Air Quality Management District is now in session. Today is Thursday, November 14th, 2019. The time is almost 9:20 a.m. We are meeting in the Hearing Board room in Diamond Bar. Before I call the calendar, though, for today, I'm sad to announce that Mr. Hank Weida, who was the prior chairman emeritus of the governing board, has passed away. And Ms. Verdugo Peralta would like to say a few words. I understand that he was her mentor.
Thank you, Madam Chair. If any of you know who Hank Weida was, he served for many, many years here at the South Coast AQMD Governing Board and was also chairman and was retired as chairman emeritus, and I believe he's the one and only, but he's been a champion of clean air for decades and decades. And I got to know him as my city councilman in Yorba Linda, and later he became mayor. He was mayor several times, actually. And he's the one who really opened my eyes to what the fight for clean air really meant. And he was generous with his knowledge. He was generous with the amount of time that he took to mentor myself as well as many other people. And it's with a very heavy heart that I honor him today. And his passing, he passed away yesterday morning, and many of us here at the South Coast AQMD worked with him, shared a lot of battles for clean air with him, and he is really, truly a person to be honored. So thank you, Madam Chair.
Thank you for those words, Ms. Verdugo Peralta. And we're going to honor Hank Weida by adjourning today's hearing in his honor. So we will do that at the end. Okay, so we have one change to our calendar for today, and that is Goodman Manufacturing Company, case number 6155-1 for a regular product variance was rescheduled to December 18th, 2019, because, as we know, the governing board will be taking up a matter which might make that moot. And we have one matter to be heard today, and that is South Coast AQMD versus Climate Industries, Inc., doing business as Howard Industries, case number 6153-2. And today we are here for a status report, as was required in the order for abatement, and a potential modification to the order for abatement. And who is representing the executive officer today?
Mary Reichert on behalf of the executive officer.
Thank you. And who is representing Howard Industries?
Matt Williamson of Manat, Phelps & Phillips.
Okay, thank you. And we have several documents, and I want to try and shake these out so that we understand, as we're marking them, which ones we're marking. We have, let's start with the documents that are district documents. Board members and parties will see that we have one red line version, but that's redlined in black. And at the very bottom, red line in black. Red line is red line, isn't it? Right, but it's there's strikeouts and underlines. And at the very bottom of that, it will say stipulated proposed order for abatement, Howard Industries. And that red line version or strikeout version, whatever you want to call it, will be exhibit number 4.
And to be fair, I should have changed that from saying stipulated to petitioners, but that
It's
was
okay
just an
because the
error.
other one does say respondent.
Yeah.
So we can distinguish.
The clean.
Will be number 4.
Clean is-
The original one, not the one you just received. There's another one you just received. And that will be different. Does that?
It's the clean is for, sorry.
No, the red line one is.
Exhibit 4 is the one you will see on between line 21 and line 22. There's an underlined sentence that reads, report and modification of order for abatement was heard on November 12th. Okay, that red line or strikeout version is exhibit number 4. Then you'll see a clean version of the proposed order proposed modified order, and at the very bottom, on the footer, it says stipulated proposed order for abatement, Howard Industries. That will be exhibit number 5. Okay. We also received from the district an email to Sean Wang from Mike Camarena at ferguson.com on November 11th, and that will be exhibit number 6 for the district. And then finally, from the district, we received another red line version, but again, it's just strikeouts version. The strikeouts don't appear until page 3. And the footer says stipulated proposed order for abatement, Howard Industries. I'm sorry, actually, there is a strikeout on the first page of the word stipulated, and that will be exhibit number 7. And I understand that's the one that highlights the differences between the two parties today. Okay, we also received 2 documents from Howard Industries. This is actual redlining, so you'll see it's the red strikeout and added version, and in the footer it says respondents proposed order for abatement. We will mark this as exhibit A as an apple. And then there's a clean version, and the way to distinguish that, again, is to look at both the caption and the footer where it says respondents proposed order for abatement. And that will be exhibit B as in boy. And finally, we received 1 public comment, and this is an email to the clerk of the board from Mike Camarena at ferguson.com, and we will mark this as P-1, and I understand it is an update email of the one, I guess it's one of 1113. I think that's a different one than the one we read. Yeah, okay. So that will be marked as P, public exhibit. This one is received on November 13th. That's P-1. And then the one that was received on the 11th is Exhibit 6 for the district. Okay. We are going to have a number of... Did we get that today, or did I already get? We already got that, so I think it was already stamped. Let me see. Yeah, we received, the same as this? No. Yes. Okay. We received, you don't have the stamped version, huh? We received previously, it was stamped with the date November 12th, with letterhead Farella, Braun, and Martel, LLP, a letter from Robert Hines on behalf of Goodman, also has an Exhibit A. It was stamped. We don't have to mark it, but we could if you prefer to. We don't have to mark it. Do we have to mark it, Madam Clerk? No, we don't have to mark it because it was separately filed. But just we'll make note that we have that as well. We're going to have, I think I received 4 speaker cards. And I believe all of the speakers are from various manufacturers or other businesses. And so we'll hear from those speakers after we hear the evidence from today's status hearing. And with that, I'm going to begin with an opening from Ms. Reichert.
Could we have a quick 5-minute? In reviewing the proposed order from the district, there are changes since the last version that I saw, and I just want to make sure that I understand what the district is proposing before we start. Is that fine?
Yeah, well, we could take a 5 minutes, so we'll be good if we're on the same.
Will they share that with the members of the board? What's the significant difference, if any?
Well, that's what Exhibit 7 was designed to do. So if you look at what we've now marked as Exhibit 7, if you look at the strikeouts and the additions in there, that's as it was explained by Ms. Reichart. This document is the proposal by respondent, Howard Industries, and the district has marked its disagreement in strikeouts and additions. So this exhibit number 7 will highlight so far what our difference is. And I believe they,
Mark out copies as well.
sorry?
The district, this is not stipulated. You just proposed modified.
Everything we have that we've just marked, everyone has. We are now no longer dealing with the stipulated proposed modifications.
As they explain the difference between themselves, let them, I want to hear it in testimony, as evidence.
Well, they just want to understand they're on the same page with each other before we start.
I want to, let's talk about that difference. Let them tell us what one says and what,
Well, I assume they will.
hopefully.
Can we do this on the record, or would you prefer to do it off the record?
This is different, saying that because I made changes after the last version I sent him, but you have all of the most recent versions. He just wants to ask me questions.
Let's talk it on the record.
Well, I don't think council feels comfortable doing
No, I just want to have time to read the Exhibit 7 that was submitted into evidence, because
Because
as I
it has
was
some changes
skimming
to it?
I noticed that there were changes that weren't in the version that I saw last night, just so I'm prepared to address them all in my opening, for example.
Well, I think that makes sense. Let's take some time for just a review of exhibit number
I
7.
think at this point, I only probably need 3 more minutes, so.
Okay, good. We're off the record. We're back on the record, and before we begin with openings, I did neglect to swear in all of our witnesses. So anyone who wishes to give testimony today, and that includes all public witnesses, please rise to be sworn in at this time. Please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? Thank you. Okay, Ms. Reichert, your opening, please.
Thank you. Good morning, Madam Chair, members of the board. As you can see, there has been a lot of work and back and forth and a good deal of disagreement about where we should be with this order. So
As you'll hear from respondent, we understand that they have entered into a distribution agreement with a manufacturer. I don't know if they will be telling the name of the manufacturer, but I will not until they volunteer that, which is wonderful and great, and we are very happy about that. But there is a delay. We're not sure 100% what that delay will be in receiving the product. In the meantime, the district understands that a different distributor has offered to sell product to Howard that is immediately available and at their cost, to be able to begin selling that product right away, and Howard turned down that offer. And it's becoming increasingly apparent that it's not a necessity for Howard to continue to sell their non-compliant products, but they would like to do it out of convenience because they don't like the other options that have been presented to them. We do not have any information regarding how many units they would need to sell in order to stay financially viable. They've not provided any financial information. So the district has proposed limiting their monthly sales until they can get the products from the new manufacturer to 100 per month. And that number is based on a number of factors. First, as I mentioned, that we don't have any financial data to understand if, what number might be needed. We don't know anything about their reserves, what could keep them afloat in the meantime. But in any event, based on their report that was submitted to the district on the 7th, updating us on their sales as well as information submitted to us. We understand their current sales has been approximately 62 units that they can document since the order for abatement, and therefore it seems like 100 per month would be a reasonable limit based on what their sales are. Additionally, we understand that there has been an overall decrease in demand in the market. And we have heard from other distributors that they too have been seeing a decrease in sales. So we do not believe that Howard should be able to continue to sell at the level they had been selling for the last several years, when that is not what the market is dictating. And we're kind of creating an artificial market here, and we don't think that that should be at the same level. There was a bit of confusion, I believe, at the last hearing regarding where that 565 number came from. That was the number that we had set the monthly limit at the last hearing. And I believe that it was discussed that that was a decrease from historical sales. And that number was actually based on the historical monthly sales for the last 2 winter seasons. So from October 2017 through March 2018, as well as October 2018 through March 2019. The sales, average monthly sales for those periods were from 2017 to 2018 was 565, which is where we got that number, and from 2018 to 2019 was 536. So the number that it's currently set at directly reflects their monthly sales between the months of October and March on a historical basis. And since that does not seem to be the case in this market currently, we do not think that we should allow that trend that it was previously observed to continue. Based on this information, we think that that's a more than fair proposition. We think it will encourage Howard to request expediting of any furnaces they can get delivered from the manufacturer with which they've entered into an agreement. Also to actually reasonably consider any potential furnaces that they can obtain through other means. And we think it will ensure that there is not an advantage to Howard in the marketplace. That is the main difference that we see in the order. There's also a requirement that they continue to look for other sources of furnaces until they have a reasonable, or until they have enough furnaces from their manufacturer, as well as a cutoff that they'll stop selling the non-compliant furnaces once they have received 100 compliant furnaces. Additionally, we believe there's still a change that, a change between the parties, that respondent wished to delete the requirement that they reduce their inventory to 2,000 units no later than November 23rd. I understand respondent stated that actually their current inventory is 3,300 units, and they don't think they can make that deadline, which is surprising to me because I believe that we had testimony that they usually keep 150 days supply, and they were already, before the last hearing, working on reducing that to a 90-day supply. But 3,300 units, based on their historical sales, reflects about the same amount of furnaces that they sold over the 6-month period from October through March for the last 2 winter seasons. So from October 2017 through March 2018, they sold 3,387 units during that 180-day, 6-month period. From October 2018 through March 2019, they sold 3,218 units. So we're not sure why they still have at least 180 days supply currently, and why they haven't been additionally reducing their stock. But we don't think they should be relieved from their obligation to reduce their stock as they agreed to with the last order. We will be presenting evidence as to all of this information. And with that, we ask that the board modify the order as requested by the district. Thank you.
And as requested by the district as is reflected in Exhibits 4 and 5?
That is correct.
Okay, thank you. Mr. Williamson, your opening.
Good morning, everybody. So obviously, I am disappointed. I was hoping we were going to be coming here today.
I'm sorry, yes, Senator?
Those numbers, the district will introduce as evidence. I think they have the profile of the numbers you're talking about. Sale.
Senator, we're just in the opening statements. We're only in the opening
Well,
statements.
she said they'd be presented as evidence, so I need to let in advance notify her. I'd like to see the numbers and dates and sales, so I don't have to try to recall it.
Okay, but we're not going to be asking Ms. Reichart questions. We're going to be presented with evidence.
I don't want to have a copy of the report.
Copy of what report? Was there a report that you mentioned?
We received sales data from respondent, but I don't know if they feel comfortable putting that into the public record, so you'd have to ask them. We were just going to testify to the summaries that we received, or that we calculated based on the data.
And is that correct? Is that private and confidential for Howard Industries?
Yes, ma'am.
Okay, so Howard Industries would like to keep that private and confidential. So we'll hear summaries, but we will not be able to see the data.
Excuse me.
Because everything we receive is public, becomes public. Okay.
Back
Sorry,
at it.
Mr. Williamson.
Again, we would love to be appearing before the board today with a stipulated order, but the fact remains is that the district and Howard Industries remain very far apart on what is viable and reasonable as a path forward. As Ms. Reichert said, we have the good news to share that we placed an order. In fact, immediately upon leaving the hearing board on the 24th, last time we were here, we reached out to the manufacturer, who's Nortec. It was actually a new suggestion from the district that we should reach out to Nortec as well. And discussions actually moved very quickly with Nortec, and as of last week, we entered into a distribution agreement and placed an order for a significant volume of ultra-low NOx furnaces. The intention with that order, and what we were excited to report to the board, is that upon receiving that order, we were prepared to completely cease the sale of non-compliant units. That was actually above and beyond what was in the previous order. The previous order said that we were to cease the sales of comparable models. But, the conditions under the last order and we called it a penalty associated with the sale of each of those units, made it so that we incentivized Howard Industries to get into compliance. It was what we talked about the last time we were in front of you all. So we were very happy to report this to the board. and it quickly, or to the district, and it quickly became clear to us that we were not on the same page with the district. The district came back, I guess I should say, I don't know if it was said in the district's opening, the lead time for these furnaces, they are scheduled to arrive in the middle of January, so we're talking about 8 weeks from today is when we're going to receive the order from Nortec. The district, as they previewed in their opening, responded with two objections to our proposed path forward. The first objection was that they felt that we needed to, and they've referred to it as, come up with a stopgap source of ultra-low NOx furnaces that will supply or meet our clients' needs covering this next 8 weeks. In support of that position, they've cited to us two different options that they believe were available to us. The first, which the district previewed for you, was sub-distribution, and they specifically referenced this offer from one of our main competitors in the Southern California market, Ferguson. You're going to hear testimony, and I won't go through it exhaustively during the opening. Frankly, during the interim variance hearing we held back in, was that September? The district didn't contest my client's testimony that sub-distribution was not an economically viable option for a distributor.
Objection, that's a mischaracterization of my our testimony and my argument during that
And not
hearing.
complete, sustained, go ahead.
Well, I will be presenting evidence later today that confirms that the district did not dispute my client's conclusion that a sub-distribution agreement was not economically viable to this company. Regardless, my client reached out to Ferguson and had discussions, expressed concerns over the viability of a sub-distribution agreement, and Ferguson didn't disagree with those. As a result, the sub-distribution agreement from Ferguson was declined. The other option that the district had proposed to us quite aggressively was that they heard that ultra-low NOx furnaces were being provided to our distributor, Ingersoll Rand, and that they were en route. They were imminently arriving at Ingersoll Rand's facilities, and questioned why we hadn't had conversations with Ingersoll Rand in order to obtain those furnaces on a tighter time frame than what we were getting from Nortec. A phone call to Ingersoll Rand confirmed to us that that actually wasn't true. There were no furnaces that were imminent. They didn't yet have an agreement to obtain the ultra-low NOx furnaces. We understand the district had that same discussion with Ingersoll Rand, and so that is no longer an option. Stepping back, though, it's not just the two options that the district proposed to us. The district is asking us to explore a number of different stopgap measures and sources for this 8-week period of time. And this is, again, repeating some previous testimony, but the way this business works, distribution of furnaces, you have relationships with contractors. You're not just selling the furnace and saying goodbye to that contractor. It is a long-term relationship. You're providing service, you're providing parts, you're providing warranty services. So you're talking about 8 weeks of sales and a 20-plus year relationship with the manufacturer of that furnace in order to provide ongoing services over the lifetime of that furnace. That's a big commitment. The other half of it is on the front end. You don't just place an order, obtain a new furnace, start providing service to your customers in order to install that furnace in the attic or in the garage of a residential home without significant training. There's onboarding process for how this would work. So even if today we were to find somebody that was willing to offer us a furnace, which the district, I'm sure, is going to offer testimony, and some of these folks sitting behind us who are our competitors are going to say they're willing to offer us furnaces today, that's not going to go into the market tomorrow. It's going to be a couple weeks before we have our folks trained and ready to provide the service so that we can responsibly place these furnaces into residential homes. This is a safety issue for the ultimate customers who are buying our product. We're not just going to rush something into our inventory, place it into homes, and risk injuring somebody through a fire or otherwise. So again, what we're really looking at here, it's 8-week period of time between now and when we expect the Nortec furnaces to arrive. Maybe half of that time, if we're being very aggressive, we would be looking at 4, but really we're probably talking about 3 weeks of time that we're in disagreement with the district that we would be able to supply furnaces through some stopgap measure. And then that 3-week period of time, we would have to be then servicing this subset of furnaces for the next 20 years. Not to mention this is a small company, and we're also in the process of going through the onboarding process with our Nortec furnaces. So it's a big ask, and we feel that it is just not reasonable, rational, or viable option for us to pursue, that we should aggressively pursue the Nortec option, and that this stopgap proposal from the district just isn't based in reality. The next point is the change from the district that they're reducing our monthly sales from the 565 to the 100. Excuse me. I haven't seen the sales data. I haven't done a market study of what the Southern California furnace market is currently. But what I can tell you is that the suggestion that we reduce our sales to 100 based on the fact that that's been our sales for the past 2 weeks, or the first 2 weeks of the abatement order. Recall we were shut down. We had no supply of ultra-low NOx furnaces. We lost almost all or all of our customers. So the first 2 weeks we have been aggressively trying to get back those customers. We have seen some success and we have seen sales increase, but to base our going forward sales off of the first 2 weeks of the abatement order is just not based in reality. And the district then contends that that is a sufficient number of units for us to stay in business and to remain financially viable. That's based on nothing. They have no information. They haven't requested any information to support that figure. In the district's opening, they attempted to push the burden on us to somehow prove that it's not financially viable. But this is the district is asking to impose that burden. And they have presented no evidence to show that at 100 units, my client can remain financially viable. The other line, and this is a new one, I didn't know it was going to come up today, but the claim that the market has somewhat depressed. 100 units is something around I think 17 or 18% of my client's historical sales during that period. So I don't see how a depression in the market, and we see numbers in Exhibit P1 of 8 to 12% depression, and that there's been over a period of time even a 50% depression. Those numbers certainly don't support a reduction down to 100. A final point, and this was a new one, and it's one of the reasons I asked for a couple minutes to review the order before we started, and it was where the district ended with their closing, is this discussion of inventory. We made a mistake. We went to the district and we informed them of the mistake when we realized that we reported our inventory at the last hearing. It was much lower than what the actual inventory was. Last night, apparently, the district has decided to reinstitute our old inventory limit down to 2,000 units. We're at approximately 3,300 units right now. I don't know, if you adopt the district's proposed language here, you're setting up Howard Industries for failure, because we can only sell 100 units per month, and we need to somehow in the next 7 days get rid of 1,300 units. So that's an impossibility. I don't know how we would propose to impose impossible conditions on Howard Industries. So again, I think we'll walk through in more detail the proposed changes from Howard Industries in the testimony. I certainly think that there, is based in the facts and the evidence and the reality of the situation that this client is facing. We are extremely happy to report that we have a source of ultra-low NOx compliant furnaces that will be arriving in 8 weeks, and that we will cease the sale of non-compliant units at that point. Unfortunately, we do not agree on a path forward with the district, and I am afraid we're going to be here for a while today hashing through those differences. Thank you.
Thank you. Let's begin, Ms. Reichart, with your first witness.
Thank you. The district calls Sean Wang.
And can I just, I'm sorry, I just, listening to the introductory comments, I just wanted to make sure we understand the three major issues that you are not in agreement with is what happens before this new distributorship takes place in January, how many monthly units will be the limit moving forward, and the inventory numbers and getting down to the 2,000 as was already in the order. Is that correct? The major issues?
Yes.
Okay, thank you.
Mr. Wang, can you please state and spell your name for the record?
First name Sean, S-H-A-W-N. Last name Wang, W-A-N-G.
And did you take the oath this morning?
Yes, I did.
And what's your position here at the district?
Air quality specialist.
Okay, thank you. Based on the sales data that Howard gave us, what were the total sales in the district for the 6-month period between October 2017 through March 2018?
3,387.
And what was the monthly average for the sales during that same period, October 2017 through March 2018?
565.
And based on that same data, what were the total sales in the district for the 6-month period from October 2018 through March 2019?
3,218.
And therefore, what was the monthly average for the sales during that same 6-month period?
536.
Okay, thank you. Did you receive an email from Mike Camarina from Ferguson Enterprises on Monday, November 11th?
Yes, I did.
And is that the same email that was marked as exhibit number 6?
Yes.
Okay. Who is Ferguson Enterprises?
Ferguson is a distributor of furnaces of various brands, ranging from Train, Day and Night, which is a Carrier brand, and Rude, which is a Rheem brand.
Okay. And Train is Ingersoll Rand, the same supplier as Howard, is that correct?
That is correct.
Okay. And what did the email from Mr. Camarena state?
The email from Mr. Mike Camarina states that Ferguson has offered Howard a sub-distribution agreement at the cost of at the price which is Ferguson's cost, and that Mr. Winters from Howard Industries declined the offer.
Okay. And do you have any information, or I don't know if it states, whether they are immediately able to provide that supply to Howard? Oh, yeah, if you can look at the last sentence in the first paragraph.
Right. So in the email, Ferguson has noted that they have significant local inventory of compliant 80% ultra-low NOx furnaces.
And that they would be able to offer Howard immediate access to buy those units?
Yes, that is correct. They did mention in the last sentence of the first paragraph that Ferguson has offered Howard Industries immediate access to buy at their true market cost.
Okay, thank you. And based on your knowledge of their business, Ferguson is in fact selling those same furnaces right now, is that correct?
That is correct.
Okay, because they do not have access to compliant Train furnaces.
That is correct.
Okay, thank you. Have you reviewed the November 13th email that has been marked as Exhibit P1?
Yes.
And what does that email describe regarding furnace sales in Southern California right now?
This email states that the Southern California HVAC industry has been experiencing an year-over-year business decline of between 8 to 12%.
Okay. And what does that email describe in terms of impacts to Ferguson's specific business since October 1st, 2019?
Ferguson states that they have experienced decline of more than 50% compared to last October's historical sales.
Okay, thank you. And have you heard from any other distributors regarding how this order with Howard may be impacting their sales and customers' decisions?
Yes, I have. I have heard from at least one other distributor noting that they have been losing business to Howard.
And did they describe anything regarding what the impact of the fact that there's a rebate on the compliant units and how that would impact a contractor's decision as to which unit to purchase?
They have noted that the homeowner rebate is not necessarily a factor when it comes to the contractor's buying decisions.
So in other words, the contractor may choose to buy a cheaper, non-compliant unit, even though after you take into account the rebate, the units may be similarly priced.
I'm going to object that assumes facts, that the non-compliant units are cheaper.
Based on the information, I'll rephrase, based on the information you received from this additional distributor, without the rebate, are non-compliant units cheaper than the compliant versions?
I'm going to object that's an incomplete hypothetical.
Would you like to rephrase it as in general? I don't, I think it's,
Did the-
well, what part is incomplete? I'm not sure.
She's still just trying to get around the fact that it's cheaper, but she's offering a incomplete hypothetical. Not included, not limited to the fact that she's eliminating the rebate from the question.
Did the distributor give you an example of a unit that the non-compliant version was cheaper than the compliant version when you did not include the aftermarket rebate?
Yes, this contractor or this distributor did give me a specific price example. He noted that Howard quoted a furnace including all additional fees totaling $1,230, whereas the compliant furnace of equivalent type would be priced at $1,620.
Okay. And did he indicate that that price difference at the moment of purchase by the contractor at the distributor could influence the contractor's purchasing decision?
Can you ask that question
Yes.
one more time?
Did he indicate how that price difference could impact the contractor's purchasing decision?
He did.
I'm also, before he answers, I'm going to just object here generally. I appreciate we're before the board, but this is a lot of testimony about a conversation with a third party, so I'm going to object on the ground that it's hearsay.
Yes, but under our rules, we may accept hearsay. We just cannot base our total findings on hearsay.
Okay, thank you. Let me rephrase just to clarify. Did the distributor indicate which unit a contractor would be more likely to buy based on the prices he gave you?
This distributor did mention that they do not feel that it creates enough of a disincentive due to the price difference of the compliant unit versus the non-compliant unit. So this distributor implied that the contractor will go towards the lower price.
Even though, once you take into account the rebate, that may reduce the price, but that the contractor is not looking at the rebate when making its decisions.
That is correct. They did note that the homeowner rebate is not always a factor when it comes to the contractor's buying decisions.
I'm also going to object that this lacks foundation, is that we're getting testimony that is hearsay about a discussion with a distributor about what a contractor is basing a decision on. It just is, this is very dangerous testimony.
I don't, it's, the witness is testifying as to a conversation that he had. It's hearsay, we may accept it, and that conversation is what he's testifying as to.
I guess the lack of foundation is what is the basis of the distributor's foundation for knowledge about decisions being made by a contractor? It's either double hearsay, it probably is double hearsay, and it also lacks
If-
foundation, I guess.
Okay, so if that
Can we
objection.
have the distributor
d-
do this testimony?
If the objection is such, then perhaps the distributor in this case should not be testifying to what contractors may or may not do. Does Howard feel that?
I have no objection to his opinion about what a contractor could do, but this is not an opinion. This is a concrete discussion. That's all, that's my objection.
I have,
I'm not understanding the basis for the objection beyond the fact that it's hearsay and he's recounting the conversation that he had. And again, hearsay, we understand why generally in courts of law, hearsay is not allowed is because we cannot cross-examine the person, either the other person on the other side of that discussion who we're hearing.
this is the end. I'm not asking any more questions, so if that is sufficient. I'm
I
just
still
gonna-
would like the objection to be on the record, is the
You may place-
foundation, we appreciate the foundation of Mr. Wang's knowledge of his discussion with the distributor is that Mr. Wang had a conversation with the distributor. There has been no foundation set for how the distributor has any knowledge of what this undisclosed or unidentified contractor told him. Was it a conversation? Do we have any confirmation of where how this knowledge was gained? Certainly is not his, he's
Madam Chair,
Yes, Senator.
typically, the witness have to show, make a foundation before they can discuss the issue.
Okay. This is not what you're thinking about. Usually,
understand what
yes, he did set a foundation. The foundation is he was speaking with,
That's not a foundation, is it?
yes, it is a foundation, and he is testifying as to what was said in that conversation. And we can take it and weigh it however we want to weigh it. Each individual member of this board will weigh each piece of evidence as he or she sees fit. However, the foundation for the conversation has been laid, and the conversation is simply being relayed to this board.
That foundation can be,
It's no different than any
It could be
conversation that has
presidential.
been testified to in this hearing room since I've been on the board for 10 years.
well, it could be 11 years, the same difference.
Okay, I'm not going to argue. I'm a legal member, and I'm making a decision that we are accepting it, and we will weigh it, because our rules say we may take hearsay. This is not a court of law, it's the hearing board.
That's why we have appeal courts. Sometimes they're right, sometimes they're wrong.
Okay, we're gonna finish up this testimony, and I'm gonna pull the rule that allows hearsay.
Okay, thank you. And I'm moving on. Are you aware how long Nortec has had compliant products that have been certified and commercially available?
I don't have that information in front of me.
Do you know if they had units available by October 1st,
They
2019?
did have units available, commercially available by October 1st.
Okay, thank you. That's all the questions I have for this witness.
Thank you. Mr. Williamson, do you have questions?
Yes, give me 1 minute, though, to organize my thoughts. It'll make my cross a lot faster. Hey, how's it going? Mr. Wang, you testified to, basically you just reread into the record the contents of P1, which is the email from Ferguson to yourself, I guess the clerk of the board copying yourself, discussing a decline in sales in the district, correct? Anywhere in this email, does it attribute that decrease in sales to Howard Industries?
No, it did not refer to Howard Industries.
What does the email specifically cite to as the cause of this decline?
So I'm just going to read straight from the email. The Southern California HVAC industry has been experiencing a year-over-year business decline of 8 to 12%, due in part to consumer economic concerns and unseasonably mild weather conditions.
And then go into the last two sentences, or the last two sentences of the email as well.
And to quote from the email, "This decline may be attributed in part to an abrupt new product introduction, contractor installation training requirements, and consumer concerns. We anticipate a marginal sales correction as the industry adopts new production technology."
So nowhere in this email do they allege that Howard Industries' abatement order is resulting in a reduction in sales, correct?
As based on this email, it did not mention anything about Howard Industries.
Okay, and you testified that you would talk to one or more distributor without identifying them that had claimed that Howard Industries' abatement order was leading to a reduction in sales. Who were those distributors?
I'm not at liberty to discuss.
I mean, I would move to strike the testimony then if I don't have the right to cross-examine a witness on who he was talking to. I can't. Under what, I guess, so I'll ask the question. Under what right does he have to refuse to testify about part of a conversation but then not identify who the conversation was with?
I would have to say it's under the same privilege that either manufacturer or contractor has that Howard Industries has. Howard Industries does not, we have heard the competitive nature of this industry, and we've heard that Howard Industries does not want to put into evidence information.
Our detailed sales information, certainly, I think that has a business confidentiality, but
You
merely.
can ask, was this a confidential conversation? And you can ask, what kind of, does this business do, does this company do business in the South Coast? You can ask questions about that, but first we should ask, is it confidential, and can you, but I
Well,
think that's been answered.
In what circumstance would the identity of a person you're having a conversation with be confidential in this context? It's ultimately going to be a ruling that you are going to be making, right?
I can't make that ruling. I have not been briefed on it, and I do not know the nature under which. All I know is that Mr. Wang is saying he's not
Okay,
at
so
liberty to say.
we have an unidentified competitor who is claiming that we sell, as Ms. Reichert said, 62 units into the market and somehow are impacting their sales, and we have no right to find out who that person is.
I'm not sure. Are you,
They're
that
probably
the
sitting back here. I
testimony?
guess I could just ask all of them when they get up and testify
was
later
that
this
the
afternoon.
testimony? I'm not sure that
I'm-
was.
No,
That was
he's
not, Mr. Williamson, that's not the testimony I heard. I heard Mr. Wang
Well, no, we haven't
simply.
had testimony on it. It was in Ms. Reichert's opening. There will be testimony on it subsequently.
Okay, when we get there,
okay,
we'll
okay.
find out more about that. As of
Okay,
right now.
then I will avoid for the time being, but we'll certainly revisit this when the distributors are making public comments. Mr. Wang, how many different distributors did you hear that information from?
Can you,
information is-
objection to vague?
Yes, can you say what that means?
How many different distributors did you hear claim that Howard Industries' order for abatement was, materially impacting their sales?
I have heard from at least one. I have in-depth discussions with one distributor, and a second distributor, we kind of had this conversation during another conversation, so I don't recollect the specifics of that.
How many different distributors have you discussed the Howard Industries abatement order with?
Let me have 1 second to discuss with counsel.
Confidential.
Only one distributor conversation was specifically about Howard Industries.
Okay. Can you identify who that distributor was?
I cannot.
Given the sales that you're aware of the total sales that Howard Industries has made to date approximately under the abatement order, correct?
Correct.
What is that number?
1 second while we pull up the.
Yeah, I don't know that he was on the email that received that information, so if you want to provide him with that information. But that was only until the end of the month, so. If you would like to provide him with that information, he can testify to it.
We'll skip it. It doesn't matter if he doesn't
Okay.
know. You testified about the overall sales decline that Ferguson has experienced. Did you talk to any other distributors about their sales over the last month?
I've only gotten it from Ferguson.
Only from Ferguson? Okay. Hang on. And did you do anything to confirm the statistics that were reported to you from Ferguson?
Are you referring to the public exhibit P1?
Yes, yes.
No.
And you're aware that Ferguson is a big competitor of Howard Industries, correct?
If you have knowledge. You can answer to your knowledge.
To my knowledge, they occupy the same market. I don't know how big of a competitor they are, but I can confirm that they are a competitor.
So you just are providing to the district sales data from a competitor without asking any question on the veracity of that data?
Objection,
correct?
he just was testifying to the contents of the email that was sent directly to the board.
So you have no reason to believe that this data is correct?
Objection, argumentative.
Have you done anything to confirm that this data is correct, Mr. Wang?
No.
Okay, no further questions.
Thank you. Before we ask questions, I just wanted to read our rules with regard to our acceptance of evidence. And I want to remind the hearing board members, everyone has a right to weigh evidence that you hear for your own satisfaction and weigh it yourself. But essentially under our evidence rule 9B3, the hearing shall not be conducted according to technical rules relating to evidence and witnesses, except for rules relating to privilege as set forth in California Evidence Code, et cetera. Any relevant evidence shall be admitted if it is the sort of evidence on which responsible persons are accustomed to rely in the conduct of serious affairs, regardless of the existence of any common law or statutory rule which might make improper the admission of such evidence over objection in civil actions. Hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but shall not be sufficient in and of itself to support a finding. And again, today our finding is good cause, unless it would be admissible over objection in civil action, et cetera, et cetera. Okay, so with that, I had two questions, because I know there was a lot of questions with regard to what is hearsay evidence, which is your discussion, Mr. Wang, and your recitation of your conversation with regards to ultra-low NOx compliant models being more expensive and non-compliant being less expensive. I believe it was in this case, but if not, let me ask you now. In your experience, do you know whether or not compliant ultra-low NOx models, model for model, are generally more expensive than non-compliant models?
From our discussions with all the manufacturers, that is the case. Compliant ultra-low NOx models are generally more expensive than the non-compliant 40 nanogram per joule models.
And do you recall, I don't know if you were here at the last hearing, but there was a lot of discussion about mitigation fees and penalties, and to your knowledge, was that discussion, were you here? I don't recall.
Are you referring to the last order for abatement?
That's right.
Yes, I was here.
Okay, sorry, Mr. Wang, I know we've seen you a lot, so I can't remember which case. That there was a significant discussion about ensuring that mitigation fees and penalties would make it so that it is not less expensive or it is not more expensive, no, less expensive to sell non-compliant. Is that correct?
Could you just clarify, are you?
Sorry. I know there was a lot of discussion at the last, I believe it was at the last hearing on the order for abatement, with regard to the fact that non-compliant models are less expensive. And is that the reason why we discussed, or is that the reason why a mitigation fee might be imposed, to your knowledge? Is that making sense?
To my knowledge.
Yeah, you can answer if you understand the question.
So to my knowledge, the mitigation fee was added to bring the two prices closer together.
Okay, thank you. That was the question. It was not very artfully stated. Okay. The other thing I wanted to understand, you were asked to read the last two sentences on P1, that email, regarding the decline, which was the furnace sales decline of over 50%, which was reported by this person from Ferguson. Compared to October's prior year historical sales, this decline may be attributed in part to an abrupt new product introduction, contractor installation training requirements, and consumer concerns. To your knowledge, are those consumer concerns and new product introduction, does that refer to do you understand that to refer to ultra-low NOx furnaces?
Just so I can better understand the question, can you restate it once more?
Yes. So I'm reading that sentence. So this sentence, I believe, is describing the 50% decline that is reported. This decline may be attributed in part to an abrupt new product introduction. To your knowledge or to your understanding, is that the ultra-low NOx furnaces? Do you know if that's what Mr. Camarena is referring to here?
Yeah.
And he goes on to say, we anticipate a marginal sales correction as the industry adopts the new product technology. So is your understanding that this is referring to the introduction of ultra-low NOx?
Yeah, yes, to my understanding it is.
Okay, so the 50% reduction or decline they're seeing, according to your understanding, is of this ultra-low, because the ultra-low NOx. Okay, I won't, let me stop there. Is Howard Industries currently selling ultra-low NOx?
Howard Industries is not selling ultra-low NOx.
Okay, thank you. Those are my questions. Ms. Verdugo-Peralta.
Thank you, Madam Chair. Mr. Wang, in reference to Exhibit P1 and all of the documentation that is on here regarding the decline of 8 to 12%, as well as the second paragraph, experienced a furnace sales decline of over 50%. Did this person, Mr. Camarena, cite the source? Did he say where he was getting this information from?
And just to confirm, citing the source of the over 50% decline.
Both the comments that I asked regarding the year-over-year business decline of 8 to 12% in the first paragraph, as well as the second paragraph, second sentence, or second line where it says, experienced a furnace sales decline of over 50%. Did you ask him where he was getting that information?
Can you split those two up? Because one is market, one is the full market, one is individual.
Fine.
Okay. So if we could talk about maybe the first paragraph first, the 8 to 12% decline.
Right.
Do you understand the question?
Yes, I
Okay.
do understand the question. I can only cite from this email, which states that these market conditions are sourced from several HVAC industry trade reporting organizations.
Okay, but you did not follow up and verify that?
Now, this email was sent yesterday at 9:50 p.m., so there wasn't much time to follow up on the statements.
What about the second paragraph?
The second paragraph, when Mr. Camarena stated over sales decline of over 50%, I believe that they are talking about their internal sales data.
Okay. Also, there was discussion in reference to the conversations that you have had with distributor or distributors. Who states that those conversations are confidential? Is it stated within the phone conversation when you're speaking to them, or is it standard practice?
Before this hearing, just to confirm with this distributor, I did make a call and had a phone conversation with this distributor. And that is when I was informed that this distributor would like to remain confidential.
Okay, thank you.
Mr. Balagopalan?
Mr. Wang, Nortec, it's the first time hearing the name. So they are a distributor or a manufacturer?
Nortec is a manufacturer. I believe they sell under the brands Maytag, Frigidaire. Those are the only two that come to mind, but there are others.
I'm looking at the list of, that was pulled from the website on the certified, qualified furnace list. Are they on that list?
They are currently not. The reason they are not on the list as of yet is because they have gone through some model number revisions, and we are waiting for the application to be processed before adding the corrected model numbers onto the list. We are in discussions with Nortec about
So
that.
they're not supposed, are they allowed to sell until they're on the list?
The models are originally certified. They are just making a short modification to the model number to correct for a couple changes in their nomenclature. I had discussions with the Nortec representative, and it's a certification modification, not a new certification.
But my question is, for the public and the contractors, this is where they're supposed to go, right, to the website?
Correct.
To look at certified?
To clarify, yeah, the website, please clarify about what the website is for.
The website states that which models are available for rebate. They are available for sale when they are certified.
And the certification by whom, so the list only then is listing those models that are available for rebate?
So just to clarify, I'll give a quick background about our process between the certification and the way that before it reaches the rebate website. Manufacturers would oftentimes certify more models than they have commercially available. And it is up to the manufacturer to inform us which model numbers that are certified are available for commercial purchase and sale. And at that point, those were the model numbers that are added to the list. We do not add all model numbers that are certified. And during this discussion, Nortec informed us that they would like to make some changes to the model numbers in their certification for the commercially available units. And that is why there is the delay from the time that they were certified versus the time that we put them on the website.
So how long do you anticipate before it gets on the website?
I anticipate within, if not by the end of this week, beginning of next week.
Okay, so that they'll be on the website. And these are those that are on the website, I'm just kind of trying to make sure they are available for rebate then, once they're on the website also?
Correct.
Manufacturer's rebate.
Correct.
So if I were a homeowner or a contractor, where's my source of finding out which furnaces are, certified by AQMD and are compliant with the rule? Where does one go besides this AQMD website for this furnace list?
In the short interim period where they are available for sale but not on the list, the manufacturers would have marketing materials or information of the unit that does state that they are certified to 14 nanogram per joule.
Okay. And they have exclusive distribution agreements? Do you know if they have, because they're the manufacturers and so they have distributors in the district?
I'm sorry, could you just clarify your question?
No, because Nortec is a manufacturer, right?
Yes, Nortec is a manufacturer.
And they have, they have been selling the 40 nanogram previously in the district?
I believe so.
And they have distributors that they have in the district?
To your knowledge.
Yeah.
To my knowledge, my discussions between the district and Nortec has been mainly the certification process. We haven't really discussed with them about their supply chain in the district. But from other manufacturers, distribution, I guess their supply chain, it's safe to assume so. But I haven't had direct discussion with Nortec about their supply chain.
And have you been provided information on to what height or what their certification is for, 5,000 feet? Is it for high altitude, low altitude? What levels are they certified for? If you know.
I don't recall Nortec specifically.
Okay, thank you.
Senator, do you have questions?
In my voice, I can hold that, yes. You asked early on the manufacturer that you spoke to, and you were citing some of the comments you had with that person. And you said it was confidential, is that correct?
Objection, he was referring to a distributor.
A distributor, all right. Same thing. You couldn't disclose because it was confidential?
My conversations with the distributor is that they would like to remain anonymous, but I can relay the information, the pricing information to you.
Did you discuss those issues with any other company other than Ferguson?
Which issues?
The issues that you've been addressing regarding the sales, et cetera.
There have been several different issues that were relayed by Mr. Wang, so could you specify, are you looking at the percentage decline from
Yeah, well,
P1?
yeah,
Are you looking at the conversation that you had?
Decline, yeah.
Specifically, the decline referenced in P1?
P1.
Yes, the decline referenced in P1 was only with Ferguson.
Do you discuss any other decline with any other distributor?
No.
Do you have reason to believe that the 12% decline is accurate, is valid, is proven, can be established?
Do you have any, to your knowledge?
Can I speak with Mary? I just needed Mary's help to phrase it more eloquently.
Well, you do very well on your own.
I did not do a third part. I did not verify these data, so there's no reason for me to believe one way or the other.
In your mind, honestly speaking, we're not stacking the deck for or against anyone. Do you think that this email from Mike Camarena would influence the decision that we make here today? You think that's the purpose for which it was given?
I'm sorry, wait, that's very speculative, and all Mr. Wang can testify to is what was sent to him and what's the content, and his understanding of it, not the motive behind it. We get public comments all the time.
But he spoke from Exhibit P-1, and he's quoted from P-1, and that obviously could influence based on the sales.
Well, let me just say, Senator, I would assume that the intent behind anyone submitting public comments in any of our matters is to influence one way or the other by providing information. So I don't, that's very speculative, and Mr. Wang would have no knowledge of the motivation behind someone's public comments.
If you answer for him, then he can't answer.
I object to that as speculative. He can't speculate on the.
And I would sustain that. That's too speculative. Mr. Wang would have no
It
knowledge.
says here, and he quoted already, he wrote it, Southern California HV industry has been experiencing an year-over-year business decline from 8 to 12%. I think that's what you read from earlier, is that correct?
Yes.
But you have not been able to verify that. That is a true statement.
As I stated before, I did not verify this, so there's no reason for me to believe it to be one way or the other.
Well, you stated as if it were, you're supportive of it.
Objective, mischaracterizing his testimony.
I'm only listening to what he said when he responded to your question. You went on to say, however, that the consumer economic concern and unreasonably mild weather conditions reduce the sales. These market conditions are sources from the high-vac industry reporting organization. Did you check the high-vac industry?
I believe that he already testified that this came in at 9:50 p.m. and he has not had a chance to do any independent.
But the statement was, I have not verified this, and so.
If you would like, I can ask the witness on a break to see if he can uncover any independent information regarding this.
All right, well, he still testified to it, but let me just say this. He testified to something, then it becomes hearsay if he can't verify it.
We don't
And-
dispute that it is hearsay.
It is hearsay, and it is accepted, and you may give it whatever weight you wish.
Okay. But you also say that the decline may be attributed in part to an abrupt new product introduction. And then it requires training, requirements, consumer concern. We anticipate a marginal sale correction as the industry adopt the new product technology. And what they're saying when they come up with a new product is a lot of things that have to be considered before you can finalize its use. That's what this thing is, that's what it's saying. So it contradicts itself. You think Howard Industries is responsible for this decline?
I'm sorry, can you restate the
Howard
question?
Industry, it didn't say here that Howard Industries is responsible for the decline in sales.
That's been asked and answered.
I'm talking to him.
Yeah, I'm saying that the witness has been asked that question by Respondent's Counsel, and he answered the question.
I'm reflecting on the earlier testimony where a lot of emphasis was put on this P1 by the witness, which would suggest to me otherwise, if I was not being inquisitive, that it was supportive of what they're saying here in terms of the argument. That's what I think. I think that I'm just trying to establish a fairness doctrine.
Okay, any other questions? Yes, Mr. Balagopalan. Oh, did you want to take a break?
No, I had a couple of follow-up questions.
Yeah, if we don't have too many other do we have other questions? Yeah, why don't we go ahead and then we'll take a break. Mr. Balagopalan.
Mr. Wang, I had some questions on the price differential that was quoted to you. Did they give you detail on it was a like-to-like, the same type of furnace, with a variable speed or just non-variable speed, or it had other, features, bells and whistles, so one versus the other?
Yes, in our discussions with this distributor, it is a like-for-like comparison.
Like, now, when we adopted the order the last time, the board, and I think, at least for myself, speaking for myself, I know we looked at the mitigation fee and the penalty fee added to the cost of the furnace as being sort of not giving an advantage to Howard. While we knew that the new units, the compliant units, we heard testimony that were more expensive. So by agreeing to the additional fees, the mitigation fee and the penalty fee, which we don't know how much it is, so you're saying that is still causing, in your opinion, causing a gap, that giving an unfair advantage for Howard?
The price comparison that I gave in my earlier testimony is factors in the mitigation fee and additional fees.
But there's nothing preventing, just because the contractor chose not to look into the mitigation fee, but the homeowner is entitled to the rebate, right?
That is correct.
And you're saying in this case, the contractor didn't take that into account?
Based off of the conversations I had with the distributor, the rebate does not necessarily factor into the contractor's decision on picking which furnace to buy.
And do you know why that is?
I do not.
Because that's one of the factors we also used in making that determination the last time. Just a question, I know you may not know, and we can ask Howard Industry on this. How familiar are you with what the marketplace is? As far as, I think in the staff report, it says about 180,000 units are sold a year approximately, correct? And do you know if the sales are mainly, if it's broken down, is it replacement? Or, there's some portion I'm assuming is going for new construction, new homes and so forth. And the others are, and do you have any breakdown on what's for new construction versus replacement?
I don't have the concrete data in front of me, but I believe the new construction is roughly 10% of annual sales.
So the majority in that case would be when replacements due to potentially failure of the unit, correct? I mean,
To the extent,
To the extent of my knowledge,
yeah,
yes.
because if it's a lifespan of 20 to 30 years, in fact, I was asked this question by the gentleman who came to service my unit last week. Are you going to go to the new unit? I said, no, because mine is working fine. So it's only when a unit fails that somebody will look at getting a replacement, correct?
Yes, I believe so.
And in that situation, while cost is a factor, there's an urgent need for and most of the time the failure is catastrophic that you need to replace it right away. It's not like oh, I got a newer model, I'm going to switch to a newer model because, that's a lower emission. Is that correct?
To my knowledge, yes, that is correct.
Okay, thank you.
Any other questions, or should we take our break? Break, okay. All right, let's take a, did you want, can we
Right,
take a,
I'm sorry.
well, do you have a number of questions? Should we take our break and then come back and
Take a break
ask
and
questions?
come back.
Or do you, if you have just one question, we can get it, you can get it out now.
Fine. Exhibit 6, did you have any comment on Exhibit 6? Nothing's been introduced as evidence yet.
he did discuss Exhibit 6.
And they were saying that Howard declined. To what extent did you discuss it? I don't recall.
Did you want me to
Yeah, reiterate
solicit the testimony?
what he just stated.
Can you please state your understanding of this email received on, in Exhibit 6, received by Mike Camarina of Ferguson on November 11th?
So Exhibit 6, which is the email from Mike Camarina dated Monday, November 11th, 2019, states, starting from the second sentence, currently, Ferguson has significant local inventory of SCAQMD compliant 80% AFUE ultra-low NOx furnaces in stock. And in cooperation with carrier leadership, Ferguson today has offered Howard Industries immediate access to buy at our true market cost and to resell said 80% AFUE ultra-low NOx day and night furnaces. And day and night is the brand.
And then if you want to read the last
Go ahead.
sentence.
Oh, and the email concludes stating Jeff Winters of Howard Industries has declined the offer to buy and resell day and night ultra-low NOx furnaces from Ferguson HVAC.
Did you talk to Mr. Camarena regarding this Exhibit 6?
I don't recall specifically speaking with Mr. Camarena. I have had phone discussions with another individual at Ferguson.
At Ferguson? Did they tell you reason why Howard declined?
No, I was not part of that conversation.
So you have no reason to know why they declined?
To my knowledge, I don't know why they declined.
And Senator, we may ask, we'll have an opportunity to ask Howard Industries as well.
All right, thank you. Sorry, I can't talk that good.
Okay, any other questions before we take a break? Okay, let's take let's take a little less than a 15-minute break, if that's okay with everyone, since we have nothing to do over the break other than take a break. So at 5 we'll reconvene, please. We're off the record. Okay, we are back on the record. Thanks, everyone, for being prompt. I abruptly took that overdue break. Does anyone, since Mr. Wang is still here, does anyone have any questions that we missed for Mr. Wang? Okay. Thank you very much, Mr. Wang. Ms. Frykart, did you have another witness you wish to
Nope,
present?
no further witnesses.
Okay. Mr. Williamson, then let us turn to you and to your witness.
First witness is Jeff Winter. Mr. Winter, can you state and spell your name for the record, please?
Jeffrey Winter, Jeffrey, Winter.
And you took the oath this morning, correct?
I did.
So I want to start with, we've jumped into the modification portion of this hearing, but not forgetting that it is a status report to the board as well. I want to walk through the update to the board on the status of your progress of obtaining a source of a compliant ultra-low NOx furnace. Can you provide the board with the current status of your efforts?
Indeed. So to fill into the board where we left off, at the meeting on the 24th, the district was very kind to provide us with 6 names. There was a new addition to the list of Nortec. And so I approached Sean Wang at a break and asked him to provide me with the name and contact number because I didn't have it and never had access to them. And it was kind of a surprise to me, the new addition. Sean provided it immediately. And as soon as I left the meeting, I contacted them, as well as continuing dialogue with the other people on the list.
So let's focus on Nortec. After you made initial contact on the afternoon of the 24th, what happened next?
I contacted the name on that referral. He referred me to a sales manager who contacted me the next day. We spoke a bit, and I got a NDA, which is a non-disclosure agreement. We went through it and made some changes to it. One of the changes being that we could talk to the board because that was excluded. And they were very gracious about that as well. We were able to turn the NDA around very, very quickly within a couple of days. We provided that, I provided that to our council to provide it to the district, showing them our progress. Next step was the distributor agreement. We went through that as well, made the changes accordingly that needed to be made. And then we moved on to an order and placed an order expeditiously. And so I would say that from the time we left the district to the time we signed on and placed an order was within a week, I believe. Yes, sir.
And one thing flagging for everyone, I guess, that's going to be asking questions is there is an NDA in place with Nortec. They have agreed to allow us to provide a status update to the board, but there very well could be questions that come up today, especially if we get into specific details where we're going to have to refrain from answering due to the NDA, unfortunately.
So then, Mr. Winter, just please defer to counsel, to Mr. Williamson. And Mr. Williamson, please jump in if you feel we're going beyond.
I will. Thank you. So, Mr. Winter, you'd mentioned that let's finish off with Nortec. What is the timing? What is the lead time for arrival of the units that you've placed?
So we believe that there'll be, our shipments will occur somewhere around the second week of January. We'll have, we won't have all of our order, but it will begin coming in, and we will have ample inventories about at that time.
And at the time when the order arrives, Howard Industries is prepared to cease the sale of all non-compliant furnaces within the district, correct?
That's correct.
Okay. I want to go back to the order, as everybody knows, required Howard Industries to pursue multiple different manufacturers and other options for to acquire ultra-low NOx furnaces. Can you walk through, we'll start with Goodman, who, when we were last in front of the board, you were having discussions about an NDA with. What happened with your discussions with Goodman?
So we contacted Goodman. We had actually corrections to an NDA before our previous meeting on the 24th. We contacted them twice after that. They came back to us and said, well, let's speak offline, so to speak, outside the NDA, and then we'll make the corrections in the NDA should you want to move further. And we said, okay, what is that? And they said, well, you need to give up American Standard in order to do business with us. So that was a non-go-forward situation because we weren't prepared to terminate a 30-year relationship and the basis of our business to a new and unknown brand.
And when we were last in front of the board, we were also in discussions with Lennox about the pursuing further discussions via first an NDA. What happened in your discussions with Lennox?
From what I know about Lennox, they kind of gone very, very silent. Dave Winningham, who came and spoke to the board, reached out and contacted our counsel, and our counsel asked them for the NDA, which is where we left off in Lennox's testimony. At the first contact, I believe, Mr. Winningham said he would work on sending the NDA, and then our counsel followed up again with Lennox because it was through our counsel that Lennox made the approach. And Lennox said that they're still reviewing and that they probably will not be sending an NDA, and that was the end of that. So I would count Lennox out for the count.
And the third manufacturer who we had substantive discussions with at the time that we were before the hearing board last time, and in fact offered testimony at our last hearing, was Carrier. What happened in your discussions with Carrier?
So Carrier, we were reviewing their distributor agreement where we left off. We were also paralleling at the same time the Nortec offer. We had the opportunity and the time to be able to, in that week's time, to be able to evaluate the Nortec product and the offer, as well as contact our customers and Carrier or all their brands customers who we share in the industry, and they were very unhappy with the product. They didn't like the product. They felt it was poor, and so we decided that Nortec, which uses somewhat of a different technology, would be a better opportunity to go forward with, and that's why we went with Nortec.
And then we're also, I guess, two, and this was condition. I'm looking at the wrong exhibit, apologies. Condition 2B in the previous order required you to continue your outreach to two manufacturers, JCI and Rheem, who Howard Industries had previously attempted to contact but hadn't responded. Did you continue outreach to those two manufacturers as well?
We did, and they were still non-responsive.
Okay. We've heard a lot today, and it's referenced in the, not referenced, it's a condition in the order is, I believe it was 1C, to continue outreach to referrals for sub-distribution or opportunities for sub-distribution. Can you provide an update to the board about the diligence and outreach that Howard Industries did in pursuit of potential sub-distribution agreements?
So in the previous meeting to the district, we spoke about sub-distribution, and we spoke to Carrier about sub-distribution initially. We expressed to them and to anyone else that for us, for any distributor, legitimate distributor in the industry, they would need technical factory access to the knowledge base and support of the product from the factory on an ongoing basis. They would need ongoing replacement parts to service their customers for the life of the warranty, certainly of the unit. And then that would typically be about 10 years, and ongoing replacement parts and inventory, bless you. And so Carrier, in an email to us, when we did emails back and forth, told us that they agreed that sub-distribution is not appropriate for us and offered us the distribution of their product. We didn't go forward with it because of the quality of the product, so that was a separate issue. But we did get a call for sub-distributing through one of their sister brands, Ferguson, who's a $20 billion competitor with 35,000 worldwide employees, a net income of $1.267 billion. They gave us a call and offered to sell us asked us to sub-distribute their products. That occurred on Monday, November 11th at about 12:30 p.m. out of the blue through a gentleman by the name of Steve Adams. And I explained to Steve Adams these 3 to 4 issues. He agreed with me completely. So we got into a 1-hour conversation, so Steve, what's bringing you to me and why are we having this conversation? And he said, well, I am the head of train at Ferguson. And I said, that's fine. I said, but you have 2 other lines of product. You have Rude and you have Day and Night. Yeah, but I have train. I said, but listen, you have 2 lines of furnaces and I have none. So on October 1st, my phone stopped ringing and yours continued to ring. Yeah, but I have train and I don't have a furnace. And I said to him, but when I get Nortec, my American Standard loyal customers are going to be using Nortec furnaces with their American Standard condensing units, and that's all okay.
So Jeff, focusing in on the discussions you had with Ferguson on the sub-distribution, let's focus on that.
We declined their sub-distribution for the reasons that I stated.
And so what were the reasons that you communicated to Ferguson that you were declining the offer?
The technical and factory access that we would need to have through Carrier, the ongoing and replacement parts access that we would need to have, and the ongoing relationship for a period of at least 10 years, and that basically we would be surrendering our customers to them because if we sold the day and night product, everybody knows that we'd be buying it from Ferguson, so why in the world should they be buying it from us? They would go straight there. And he agreed completely. I mean, there's no doubt in his mind that it was appropriate for me to decline. The effort was made just so that he would legitimize his visit. He intended to visit and protest our order for abatement.
So we've also had, stepping back from sub-distribution specifically, and we know that the district is requesting ongoing work to try to identify a stopgap source for ultra-low NOx furnaces over the next 8 weeks. Can you testify about let's start with what are the difficulties that you would face with trying to have that type of short-term relationship? Ignoring the sub-distribution, just a normal distributor type agreement, why is that not feasible or reasonable to enter into for Howard Industries?
So let's take the Nortec model by example. We signed on with them within a week. We have technical support assistants, 3 of them, that are requiring training, and they will have that training. It's already set up for December 3rd, by example. So we placed the order 2 weeks ago. No, I'm sorry. Between the time we placed the order just now, but December 3rd is the first date we can get for tech support for our 3 tech assistants who provide assistance to contractors. We also need to train up our contractors on the installation processes of this furnace because they haven't had any experience with it. They've only had access to the American Standard product, which is the low NOx, not ultra low NOx. So there's a lack of familiarity, there's a lack of tech support, there's a lack of knowledge completely, and there's the wind up in the pitch. So you've got to be able to train people up and get them going. I mean, even Ferguson said that they're having a lull because of this training and so on and so forth. It's no different for us. We would have to go through the same process. We'd have to bring in replacement parts. We'd have to have access to their knowledge base, whomever that mystery person might be, and even getting in inventory and so on and so forth. I mean, Carrier testified, I believe, that if we wanted to be a distributor, it would take them about something like 6 weeks, was to my recollection, 5-6 weeks to get product. So we're within a week or 2 of that range. It doesn't seem like there's any difference between the 2. So if we eliminate sub-distribution, which is very appropriate to be eliminated, then we're talking about something of exactly the same ilk as Nortec's situation right now.
And what are your concerns if you are in a position where you're trying to hustle in a new product line in order to get it into market before all of those that ramp up is completed?
We have an engineer here on the board, and he understands completely. This is a life safety issue. We're putting something I call it a missile, into people's homes because it operates at a much higher temperature than the previous furnace. and offers considerably more risk, in my opinion. I'm putting our family and our reputation online. God forbid something should happen to somebody. Folks need to be trained. They need to understand what they're getting themselves into, and they need to appropriately install product. Not that I would put one of these in my own home. That's not the issue or the question. That goes without saying I wouldn't, but that's not where we're at. But whatever does get installed has to be installed appropriately and safely, and there can't be any loss of life or anyone getting injured because of it.
And after you would go through this, we'll say generous 4 to 6 week period of time between when you would be able to start selling this as of yet unidentified stopgap source of ultra-low NOx furnaces and the arrival of your ultra-low NOx furnaces from Nortec, does the relationship just end with this as of yet unknown party, or is this going to have to be a continuing relationship into the future as well?
We'd have to continue a relationship, but it's doomed to failure because, and I don't know who would ever engage us in a relationship that they'd have to continue to give us tech support and parts, and we wouldn't be buying any product from them again. So they'd sell us a couple of units for a very short period of time. It's economically unsound for anybody to get involved in such a relationship. And I don't know any sane person who would want to, but all I have are people stacked up who want us not to have the order for abatement, but not giving us solutions.
And another suggestion that the board had raised for a immediate supply of furnaces in conversation over the past week was to obtain ultra-low NOx inventory from American Standard. Can you explain what the proposal was that the district thought we should be pursuing?
So yesterday, we were preparing for this meeting, and I got a frantic call from council that they had just heard from the district that, again, I believe it was Ferguson, had reported that Ingersoll Rand had ultra-low NOx product for sale. So while council was on the phone, I called up Ingersoll Rand and I said, I'd like to place an order for furnaces. And they said, well, you can't place an order for furnaces. And I said, well, we were told you have furnaces. And they said, firstly, we don't have a contract signed with a vendor. Secondly, we don't have it set up in our system. So there's nowhere to go with this. I said, well, I did leave the conversation with, once you do, please let me know, because I do wish to place an order for ultra-low NOx furnaces from you when you have it. And that is correct, because I wish to continue our relationship with Ingersoll Rand.
So based on your conversation directly with Ingersoll Rand, the information we obtained from the district was not correct, right?
Whoever reported it to the district was inaccurate.
Okay, thank you. Let's move on to the monthly sales cap. We know that the district is proposing to reduce the monthly sales limit from the 565 that was previously stipulated to in the order for abatement from October, and is now reducing that, requesting that monthly sales limit be reduced to 100 furnaces. And we heard the district talking about the fact that that number is justified because that is consistent with the first couple of weeks of sales under of your sales following the issuance of the order for abatement. What is your response to that?
Well, firstly, I can't honestly agree with Ferguson's letter to the 10 p.m. letter to the district, in that before October 1st, we were doing extremely well and we weren't seeing the sales decline that they're referring to. So I can't relate to that.
Jeff, let's answer the question that was asked, and we'll work our way through to those other issues. So starting back with the basing your sales going forward off of the first couple of weeks of sales that you had under the order for abatement.
So we were shut down on October 1st. We had, within a few days of October 1st, we lost our customers. The phone stopped ringing. I told that to Ferguson when he called me the other day. I had no business at all. and as I reported to the district, or as I reported to this council, this board. Our customers sign contracts with homeowners. They schedule their jobs. They have to report model numbers of what they're going to install and brands that they're going to install. They change their marketing patterns because they didn't know if we would have product to sell. It was a very, very bad time and a very tenuous time, and we're very appreciative to the board that they gave us this order for abatement. But it's not a light switch. So just because we got an order for abatement doesn't mean that all of a sudden everything crawls back the next day, because we were doing extremely well before October 1st. It's starting to come back in a very comfortable way. We also acted in an extremely responsible manner to see to it that we did not poach our competitors. We were interested in getting our customers back. We were not interested in aggressively approaching others. As well, our price was no great killer. I mean, our customers would be happy to have our product back, but I do not see an economic benefit price-wise to buy our furnace over our competitors. With the fee and the penalty on top of it, we analyzed the numbers.
Jeff, I want to keep it focused because you're bouncing around a bit. We will get back to the pricing issue, but I wanted to get clarification on one point that you raised about the delay and ramp up in sales. You referenced the fact that your customers had entered into agreements with the homeowners to install furnaces from other distributors. How does that impact the delay and the ramp up of your sales?
So even if I would have a furnace on the 24th, which was Thursday, so we didn't communicate it to our own people until the 25th, which was a Friday, and there isn't much left to the month of October after that. And Friday, not a very busy day, so let's call it Monday now. So it's 25, 26, 28th is really the first kind of business day that we could get the word out. Folks have a backlog in their contracts and in their sales calls and in getting themselves back into the American Standard fold. I would say there's a good week to 2 weeks just for them to be able to just replace us back into their portfolio.
And that's because in the interim, in the period where you were without an order for abatement, those contractors were purchasing from other distributors, correct?
Purchasing from our competitors, that's correct.
Okay. And what have you seen more recently with your sales? Have you seen them increase? What are you seeing out there?
They're starting to ramp itself back up again. We expect them to get back to their normal numbers, and then once the ultra low NOx kicks in, I mean, it should just be a straight up transition. There should be, and we'll train our people up in the interim. It should be just a natural progression from the low to the ultra low, and so on and so forth. It should be just very smooth, and we see that as the case going forward.
And when you say your normal sales rate, it's consistent with the district's testimony, which was that 565 units per month over the next couple of months?
It is a little bit slower now because of the weather. It's been a little bit warmer. I don't think that it's going to stay warm. I think we will get some cold weather. We are weather-based a bit, and we do have somewhat of a funny sine wave depending upon the weather. The comings and goings of demand has a lot to do with cold weather because we're in the replacement business. We're not in the new construction business. So as the weather gets colder, furnace sales do tick up dramatically.
And another point raised by the district in their opening was that 100 furnaces is sufficient to keep Howard in business until the arrival of the Nortec units. Can you respond to that?
Well, I kind of thought that it was the district's negotiating tactic. If they say 100 and then I say, first of all, I don't even know why the number's being touched. To me, it makes no sense at all. It makes no sense at all. The number
But Jeff, again, back to the question, what is going to happen to your business if you're capped at 100 units per month until January?
you're basically shutting me off again, because you have 5 locations at 100 furnaces, that's 20 furnaces per location per month. Anyone does the math, that's 1 furnace a day. The number makes no sense. I can't even begin to try to understand. I can understand where I feel they think it's coming from because of where we started from on the 25th, but that has no reflection in any sort of reality. So I don't know. I can't speak to it. It makes no sense logistically or anything else.
Okay, and then I wanted to touch on the claim from the unknown or unidentified distributor that this order for abatement and the furnace sales you're making under the order for abatement is harming that distributor. What has your total sales volume been since the issuance of the order for abatement?
So we do have a little bit of a lag, but let's just assume 65 units. We feel that that's a reasonable number for the month of October. Or let me see, I can't even.
And again, Jeff, we're not talking about the month of October. I was asking for from October 24th until today. And I appreciate that you don't have exact numbers, but an approximate number.
Okay, so let's say 60, 70 units. So as the doctor was saying on the board, so if the market is indeed 180,000 units, and you divide it by 12 and you have an average of 15,000 units per month, and I sold 65, so I did the math here very quickly. That comes out to 0.4%. I honestly don't believe I could hurt anybody at 0.4% of market share.
Was the answer to the question 67 units?
That's a guesstimate. And even if it was double that number, ma'am, I think it becomes 0.6%.
And you can testify according to questions asked by your counsel. I wanted to make sure, because the question asked was how many, so I wanted to make sure I understood the answer.
Indeed.
And that was October 24th to the present?
Yes. But to qualify, there are lags in our system, which I explained to the district, which because I'm so distracted with these constant comings to the board.
Hang on, Jeff, there's no question outstanding right now, so let's. Okay. And I'm trying to go through and focus on the 3 issues, and just so the board knows, I was planning on just walking through Exhibit 7, showing the changes between the 2 orders in some more granular detail, but I wanted to touch this on a high level first. The third, big dispute we have as far as the modified order is the district's request that the inventory be reduced by November 23rd to 2,000 units. What is your current estimate of your inventory of non-compliant units within the district?
I believe I reported 3,300 at the beginning of the order. So if we knock off, just round numbers, 200 units, which I believe is a fair number, so it's probably 3,100 units.
And at the time of the previous stipulated order for abatement, when you agreed to this inventory limit of 22,000 units, did you believe that your inventory was lower than 3,300 units?
I believe I added it up here, so.
I guess I'll ask this. Was the agreement to, when you agreed to 2,000 units by November 23rd, was that based on a mistaken assessment of your current inventory?
No, it was based upon 568 units for 2 months, so you take 568 twice and subtract it from the 3,300, and that would leave me with 2,000 and some units, assuming that I would sell everything that I was allowed to sell within my order for abatement.
But Jeff, there's only a month that passed between the order for abatement and your date when you needed to reach 2,000 units.
So there, that's truth is right. San Diego would sell and also Ventura would sell, but it just hasn't happened.
So again, the agreement to reduce inventory to 2,000, I will just frame it more generally, was based on some faulty assumptions that you made at the time of the order.
Yes, and we were not going to aggressively sell furnaces and hurt competition and so on and so forth. The idea was to sell through our customer base and not dump, which was our intention. And we were kind of hoping the board wouldn't get any sort of complaint about our behavior. It's very surprising.
And is there any way for you, given what the district is asking for in this order of limiting monthly sales to 1,000 units per month, to comply with their simultaneous demand that you get inventory down to 2,000 units by November 23rd?
You mean 100?
100. Get your inventory down to 2,000.
The two numbers don't work. I can't accomplish.
Okay, we're, just so we're clear, that, right, that we're talking about the provision of the original order, which is 3A, is that
Yes.
correct?
Yes.
We're talking about 3A, so maybe you want to have it in front of you so you're not conflating the two. It's not the limit, which is in 3B. It's 3A, which is the inventory restriction to 2,000 units by November 23rd.
Indeed, but they are related because I can only reduce the inventory by selling them. But I didn't view the order for abatement as a sell-off. I never viewed it as a sell-off, ever. So they really shouldn't be tied to each other. They really shouldn't be related, and reducing the inventory shouldn't be there. It makes no sense, and I don't know why. I don't know how it got, we agreed to something, and I don't disagree with that, but what I'm saying is that without relating sales to inventory levels, there's no in-between.
And the final topic I wanted to touch on is the issue of pricing. And we heard testimony from the district about, again, a discussion with a distributor, and a particular example, I believe it was one model, where the pricing for a Howard Industries furnace was $500 lower than a comparable compliant unit. Obviously not taking into account the rebate. Have you done any market research on the different pricing between comparable models between Howard Industries and your competitors?
We reported our costs to the district.
And Jeff, I'm talking specifically about since the order for abatement was issued and with your new pricing under the order for abatement.
I don't see how that's possible. I don't see how someone is more expensive than us for a similar product with the penalty for which is basically the old mitigation plus added penalties. I don't see how the pricing is more favorable for myself over my competition, and I don't have any data to work with. It's just, meaning I didn't see what they're talking about specifically. I don't know what model they're talking about, but I seriously doubt the veracity of that statement.
But have you compared pricing between Howard Industries and any of your competitors?
I compared it against, we did compare it against AC Pro pricing, and we were substantially higher.
Okay. Anybody else?
No.
Okay. So let's look at Exhibit 7, if you have it in front of you. This is the,
Mr. Williamson, you said 3 issues. I'm just wondering, you touched on reducing inventory pricing. What was the third issue, or is that already?
no, it was the stopgap source in this 8-week period between now and when we, and then, and we get Nortec inventory and the monthly cap to 100 from the previous 565.
Okay, thank you.
I believe those are consistent with the 3 main issues that the chairwoman outlined at the beginning.
Based on your openings?
Yeah.
Yes.
Do you have Exhibit 7, Jeff?
Is this 7? Is this 7?
We can share. Oh, you do? Thank you. And this will be fast because a lot of this we've already touched on, but I just want to make sure as the board is reviewing that they have your testimony on all these points. Okay, so if we look at, on page 3, condition 1 on lines 23 through 26, the district is requesting, this is a new ask, so this is one of the issues that came up, the new language from the district last night.
Can I clarify? This was language that was taken from the stipulated facts, and then, because they did not agree to it, was moved to be a condition. I just want to clarify, this is not brand new.
It is, again, it's a new condition. I don't disagree with Ms. Reichert's testimony otherwise, or testimony, statement. So the district is asking Howard Industries to continue working with its current furnace manufacturer, American Standard, who anticipates having commercially available ultra-low NOx furnaces available beginning in early 2020. Do you have any reason to believe that American Standard is going to have ultra-low NOx furnaces at an earlier date than the furnaces that are scheduled to arrive from Nortec?
Their own? If the question is their
Any
own,
furnaces at all?
Well, if they're successful in their negotiations, but I don't believe they'll have it any faster than ourselves, no.
Okay. And then if the board wants to make note, we have no objection to the second sentence in paragraph 1. We think it is currently, we've agreed to do it, and it was an inadvertent strikeout from a previous draft that we had submitted. Paragraph 2 deals with the conducting investigations of sub-distribution or other stopgap measures, which we have already covered Howard's objections to. Paragraph 3 is only relevant to the discussions that would happen pursuant to paragraph 2. So paragraph 3 is objectionable for the same reason that paragraph 2 is objectionable. Paragraph, is it 4? Yeah. At page 4, lines 14 through 22, again, the additional language from the district at the top of paragraph 4 is tangential to the requirements under paragraph 2, so it's objectionable for the same reason again. And then one of the additional reporting that the district is asking for units sold pursuant to the order for abatement is that we identify from which warehouse the unit was sold. How much work would that take?
It's huge. We don't have a system that can be modified to do the things that they're asking us to do in short order. I mean, a lot of what we're going to do for the current reporting for the district is all manual, so hand to hand. We have to cross-certify everything that was sold. Currently, we have to cross-certify everything that was sold, and it's extremely onerous to do it in a timely fashion. We only have 7 days from the end of the month to do the reporting to the district, so.
Okay, then moving on to paragraph 5, 5A, deals with the reduction in inventory to 2,000 units, which you've already testified to the problems with that. 5B is the district's requirement that, or request that we reduce units, or monthly unit sales to 100 units per month, which you have already testified regarding. Paragraph 6, line 18 through 23 on page 5, requires Howard Industries to place a order for commercially available ultra-low NOx furnaces within a 24-hour period of time to Howard Industries. That again is tangential to the requirements to conduct additional investigation for a stopgap measure under paragraph 2. And so Howard Industries objected to that language for the same reason as paragraph 2. Paragraph 7, line 26 through 28, modifies the previous order for abatement requirement that we stop selling comparable models, same size and type, once we get a comparable ultra-low NOx furnace. The district is now requesting that once we receive 100 models that we cease selling all non-compliant furnaces. I again want to remind the board of your testimony earlier that once the orders arrive from Nortec, you have no intention of selling any models and that change can be incorporated into the final order. But what is the objection to the language that the district has included here?
Once respondent has received 100 units, so I'm hoping we already established that 100 units amongst 5 locations is an unacceptable quantity in any sort of discussion, so.
And then this is not going to be testimony. This is coming from the lawyer. The version that I sent to Mary had a margin comment in it on dates. That was my fault.
I thought that you had
mistakenly left that, I didn't.
Yeah. We also, and we could certainly discuss this, we think that because we object to doing additional investigation for an option that we believe is not a viable option, it isn't reasonable to ask Howard Industries to pursue that investigation, that the status conference on December 17th would be unnecessary, and we would propose a return date in January where we would have more concrete information on the status of the Nortec order and be able to hopefully set a very short termination for the order for abatement.
Are you then saying that you are not seeking to have the order terminated when you're expecting the Nortec?
No, that's exactly what I'm proposing, is that it
So
would.
I don't know why we would need a comeback date then, according to what you're
Well,
saying.
I think the thinking was is that
According
the
to your
date
argument.
wasn't totally certain, and so we would come back for a quick status update in early January to set the termination date based on.
To then request an additional extension?
No, it would not be an extension. It would probably be.
I don't know why it would be necessary.
Well, we can also just leave I actually think I made the same argument to the district, is because we've agreed to stop selling furnaces, we don't need a return
Okay, well,
date.
I'm just saying according to what you would like
I
to see in the order.
think I agree with you.
Not what the board is going
Yes.
to do. I have a question, I just wanted to let everyone know the timing. It seems we may lose district council as well as one member of the board at 2 o'clock. I just going to ask Mr. Williamson, are you almost done, or are you done with your direct questions for
I am
Mr.
done.
Winter? Okay, do you have any other witnesses you're going to be presenting today?
It depends
we
on
get
what
an idea of timing.
the cross is, but right now, no.
Okay, and we do have members of the public I definitely want to get to as well.
To be fair, I don't have to leave at 2.
Okay.
I will lose my witness, but we've already taken him, so.
Okay. All right, so let's try to shoot for 2 if we can. However, we will lose a member. Unfortunately, we could continue going, and we just couldn't vote today or deliberate, and that member would then have to view the proceedings, and then we'd come back. But I'd like not to do that. Or we could just go forward and vote, and if it's a split vote, then we come back. So we'll see how we go from here. But with that, let's just keep that in mind. Okay, so Ms. Reichart, your questions for Mr. Winter.
Okay, thank you.
I just wonder, Mr. Williamson, are you going to go through your proposed conditions?
I did it in
by
I did it
negating-
indirectly through Exhibit 7, which is, I think, the best way of doing it. I'm happy to go through,
Exhibit 7 is their a proposal redlined by the district to show the differences.
And they're saying they object to all of those.
Those are the things that there is no agreement between the party, everything that was just highlighted.
there were very few changes that we agreed to, so I think I covered all of our changes. In fact, I know I covered all of our changes through, walking through Exhibit number 7.
Okay.
Okay, Ms. Reichart, your questions?
Okay, thank you. I want to just start going over the sales data that you have. So we'll just do it week by week. Can you give us the sales from that first week, the 24th through October 31st?
Oh, I see. Okay, so 4, 11. We show 32 units for the month of October, but we have a lag from the 25th through the 31st of charge sales. So these are the non-charge sales. So we suspect that it's an equal number.
You have 32 sales in the month of October, the whole month of October, or from after the order for abatement?
Clearly only for the order of abatement.
Okay, because you reported to the district that you only had 13 sales within the district.
Correct. So again, the time lag. So at the time that I reported that to you, that's what was in our system 13. As invoices are transacted and completed, and I run a new report daily, so I was running the information to council on an ongoing and regular basis. So we have a responsibility to report at a certain date. We reported that date, and then, of course, the number can change from day to day after that as the systems are completed. As the invoices are completed through our system. And we have a lag from the 26th through the 31st.
Okay, so how long does that lag last?
So it depends. This month, we're 2 weeks behind because I've been preparing for these meetings. So it's at least 2 weeks right now, and if I can get back to work, then we'll be able to cut that back, and it'll be probably within a week or less that I'll have that information for you.
You're 2 weeks behind?
Yes, ma'am.
Okay, so the numbers that you reported to us on November 7th, how did you have any numbers if you were 2 weeks behind?
Because those are the cash sales transactions that go through the system without going through charge sales.
Okay, what percentage of your sales are cash sales versus charge sales?
I can't speak to it, but we can follow I can't speak to it. I can't tell you specifically.
Approximately?
I can't tell you. I never analyzed it.
Mr. Winter, is your microphone on?
Oh, I'm sorry. It just doesn't, the arm doesn't go so far.
Okay, thank you.
So you have no idea what percentage is cash and what percentage is charge?
No, it varies. There's no rule of thumb.
I understand that it varies. Does it vary between 30 and 60%? Does it vary between 10 and 90%? Does it vary between 45 and 50% is charge? Like, can you give me a range of the percentage of charge sales?
I never analyzed it. I would be,
Can you get that information for us?
not really.
Why not?
It would take, I'm sure, someone to sit there and calculate it from month to month and week to week and day to day and branch to branch. Not easily.
So you had testified at the last hearing that it takes a few days for charge sales to be entered into the computer.
Indeed.
So since the last hearing to today, that amount of time has increased to 2 weeks?
That's, in this situation, that is correct.
And there's nobody, you're the one that does the entering of the charge sales into the computer?
No, I'm not the one who does it, but our close for the month of October was delayed by me because I'm the one who goes through the job quotes, and my job quotes were delayed because of this order for abatement and all the time I need to spend with council and dealing with all the minutia that goes right along with it. And yes, it's been extremely destabilizing for our company.
Okay, so your current number of sales from October 24th to October 31st is how much? You said 30-something?
I didn't write it down. Give me just a moment, please. 11, 25, 27, 28. 32.
Okay. And you reported to the district 13?
At that time.
Okay. So then, based on 32 sales, then for the last 2 weeks, you're looking at about 35 sales, based on the number you gave us earlier of 67?
So under the same circumstances, so November 1st through, this report was run yesterday on the 13th, under the same conditions, so again, no charge sales were entered at all because the month hadn't closed for October yet, so there's no charge sales in the system for the month of November. 21, 40, 42.
Okay, because you just gave us a number of 67. So now you're saying, wait, 42 for the first week?
No, I ran this report last night, dated 11/13, from November 1st to 11/13, non-charge sales, just across-the-counter sales, were 42 units. So a total of 74 from the beginning of the order in non-charge sales.
Okay, but you have that's not an actual representation of how many sales you've had.
Agreed, it's not a representation, total representation. It's certainly a number greater than that, and I told that to the district through council.
Okay, the agreement with Nortec, so you said you'd never heard of them until the order for abatement?
I did not know they had a ultra-low NOx furnace until the district added them to the list of manufacturers and presented it to us on October 24th.
You don't remember me asking you about Nortec at the interim variance hearing?
No.
Okay. When did you first call Nortec?
I'm getting back to that other question. I believe they were discounted actually at the variance hearing, but I believe that they weren't considered. I think that there was one of our meetings, or maybe it was the June meeting, the district said that they were a non-player, so something along those lines. I apologize. Your next question?
When did you first contact Nortec?
The same day of the hearing, so 10/24.
And when did you sign the agreement?
Which agreement? The NDA?
The agreement, the distributor agreement.
Distributor agreement.
Jeff, just if you approximate.
It was approximately a week after our contact.
Okay, because as of November 4th, council told me you had not yet signed it. So is your testimony it was before then, but you hadn't relayed it to council?
No, I gave it to council right away. I don't have the date, but it was approximately a week after my contact with them.
So you're saying it was before November 4th?
No?
Misstates testimony, he said approximately.
Approximately a week. Okay, but November 4th is almost 2 weeks after the 24th. So I'm just trying to understand
I'm not
when.
counting. I apologize.
Okay, so can you get that information for us?
Certainly.
Okay. When did you place your order?
I signed the distributor agreement. They told me they needed 1 day to set up my account number, but I should submit my order anyway, so I would say it would be approximately the day after I signed the distributor agreement.
But you don't know what date?
I didn't bring the documents with me, I apologize.
But you can find that out on a break?
I certainly can.
Okay. And how many units did you order?
I believe it was 760.
760 units?
Correct.
Okay. And when did they state was the earliest date they could get you product?
I haven't received a confirmation from them on the order, but verbally, it was approximately the middle of January.
So they haven't, you've placed the order at least a week ago, if not 2 weeks ago, and you haven't received a confirmation of that order?
Right, I have verbal confirmation on it.
Okay, what's the typical process for receiving confirmation of an order?
Well, considering I'm a new customer and they set me up into the system, but they'll work out production, I would say that this would be pretty typical. but I'm counting on their word. They've been very stand-up.
When do you expect to get confirmation of your order?
I'll have to ask them for that.
You have to ask them. They won't just give you confirmation?
Well, they will, but the district is asking me about an expeditious confirmation. I didn't ask them for that. I was most interested in getting the product, not in the confirmation.
Okay, but until there's a confirmation, do you know for sure that that order is being processed?
I know with certainty that the order is being processed.
Okay. So did you ask them if you could pay extra or to do anything to expedite the order?
No.
Did they state that they could get you any product before the middle of January?
What I asked for was for a continuous flow of product, not a 2 or 3 units and then a shut. That would do us no good, that we wouldn't be able to transition. Our goal is to get off the order for abatement and be able to sell product ongoing.
Did they indicate they would be able to get you a lesser amount sooner than the middle of January?
I'm sorry, I have to step in because this is way beyond the scope of what we have authorization to talk about under the NDA with our discussions with Nortec, so I'm going to instruct Jeff not to answer.
I'm sorry, can you repeat the question to me? 'Cause-
If they indicated that they could get you any portion of that order earlier than mid-January?
And we can't know that? The
We're
board?
we're past what we should be talking about. We crossed the line a couple questions ago. I'm just making me very nervous that we're where we are. I should have interjected
Because the
2
board will
questions
have
ago.
similar questions.
No, and I appreciate that. I mean, our problem is that I can't have my client violate the NDA that he has with Nordic. I mean, I'm happy to discuss it
That's
with
fine,
him.
but you'll have to understand that the board can't base an order on if we don't have the proper information.
Again, the question is that whether there was an avenue to get product earlier from Nortec?
And that is one of my questions as well.
Go ahead and answer that question, Jeff. But again, we're going down, and if we're diving down into the details of discussions with Nortec, it's putting, especially if it's going to adversely impact Jeff, it's putting him into a very difficult position between a contractual obligation and the hearing board, so.
Understood. I just want to say, similar to what I said about Mr. Wang's inability to identify the distributor,
Yeah.
the board members will have to weigh that.
Certainly,
And if the board members cannot get the sufficient evidence to support one side or another, the board has to go with what evidence it has.
Understood.
Sure.
Senator?
Well, we have already suggested what a delivery schedule would be for the total amount that you're going to buy in January, the date, middle of January. That's a fair question. Can you get get an earlier delivery on any portion of that?
Thank you. And I think Mr. Williamson has said that Mr. Winter can answer that question.
Yeah. I know that one model they aren't even making yet. There's 3 models that we ordered, a 50, a 70, and a 100. And 2 of those models, they're currently starting to produce, 2 out of 3. They're starting to produce, not at any great speed, but I can ask them if there's anything they can do sooner. But we were looking for a continuous flow. Remember, we're not going back to sell. The original order for abatement reads that as we receive models, then we will discontinue like models of Lonox. Our goal is to get off of Lonox completely, no comparable or not comparable, but get out of it completely and sell only ultra Lonox. And so the mid-January date was a guarantee that we would be off the order for abatement at that time, and that was our goal. So our goal
Okay.
wasn't to stay on the order, but to get off the order.
Okay, so you said you will ask them if you can get product earlier. Have you asked them that?
Yes, I asked them if I can get product earlier, but I also added to that conversation what I told you, what I said, I apologize, what I said, which was, I'm getting off this order, and I need there to be ample product for me to be able to get off the order. So there was some conversation here about 10 of this or 20 of that, or even a total of 100. All those things are unacceptable. We need a proper supply of product, as every other distributor will have, And the district's guesstimations that 2 or 3 or 5 is sufficient is not sufficient.
Okay, so you told them, correct me if I'm wrong, that you don't want any product until they can get you how much?
Well, according to the order for abatement, our current order for abatement reads,
Can you, I'm sorry, you can add to the answer, but can you please answer me that? Did you tell them you don't want any product until it reaches a certain threshold, yes or no?
no, I didn't say that.
Okay, what did you tell them about possibly getting product earlier than mid-January?
So the order for abatement
No, could you
reads-
answer that and then talk about the order for abatement?
Yes, please. Well, you can discuss with your counsel, but please answer the questions asked.
Okay, can you repeat the question?
What did you say to them, to Nortec, about receiving product earlier than mid-January?
I told them I do not wish to receive 5 and 2 and 10 and 3 furnaces at a time. I wish to receive an ample supply of furnaces.
Did you
That would
define
be-
ample supply?
Can you let him answer the
I'm
question,
sorry,
please?
That would be an inducement to them, because they are a manufacturer, to ship me a lot of product and sooner. So when we say the second week of January or thereabouts, that's not a guaranteed date. We're hoping that they ship it sooner, but I'm not going to come here and say to the district that they will ship it sooner and guarantee something that I am not in control of. So
Did you define ample supply?
I said to them, actually not ample, I said continuous flow of product is the words that I used.
Okay, what do you consider to be an ample or a continuous supply?
Not less than truckloads would
How
be
much
an
is
ample
it?
supply.
Can you give me a number? I don't know what truckload means.
Well, our order is 6 truckloads. Okay, so 760 divided by 6, so that would be about 110 furnaces per truckload.
Okay, so you would say 110 units would be an ample supply?
Now, I would say a continuous flow is what I said to them. So 1 truckload is not sufficient. Now, if they gave me 1 truckload per week, that would be sufficient.
Well, I'm
they gave
asking,
me-
I'm sorry, I didn't know you were, go ahead.
I'm done.
Okay, you said a continuous supply, and you defined that as 1 truckload per week?
I said continuous supply, and I'm telling you that 110 furnaces minimally per week in my 2 locations that I take product into, which is Culver City and Riverside, would be sufficient. So 110 furnaces in Culver City, 110 furnaces in Riverside, that would be over a 3-week period, that would be sufficient.
Okay, I wanted to go, you did those states here that you did not want to accept furnaces unless it was an ample supply. So how would you define in numbers what an ample supply is?
So if they ship me 220 furnaces per week, that to me would be an ample supply.
Okay, so if they, as soon as you've received 220 furnaces, would that constitute that ample supply if they have told you, we will continue to ship to you?
Only if I had absolute assurances from them that the rest of it was following the next week and so on and so forth, that I had the 700 and some odd units, 760 units is a month's supply to be backed up with additional orders on an ongoing and continuing basis forever. So I need the 760 units for the month. So if I got the 220 units per week, I would be satisfied as long as I was guaranteed and assured, and that's where the hiccup came in the conversation, guaranteed and assured that I would have that flow on an ongoing basis.
Okay, so you told them you did not want to have any product until there was a continuous supply, is that correct?
No, I did not say that.
Okay, so what did you say?
I said that I need to have an ongoing and continuous flow of product. You asked me what that would be. I said minimally a truckload to my 2 distribution points. We speculated that's about 110 furnaces per truck, 2 trucks, 220 furnaces per week. That would get me where I need to go.
So did they offer you something less than a continuous supply?
They actually speculated, but they offered something. They didn't actually make an offer. They just opined. They did not have any sort of a specific they could point to. They said they're just starting to manufacture product. They don't know exactly. They've had some production. This is where you get into NDA.
So don't go there.
So did they opine on a number they could get you sooner than mid-January?
Not specifically, no.
What about generally?
They did not even have a load that they could even commit to. They did not have a load they could commit to.
A low?
A load is 110, we established that right
Okay.
now. 'Cause
No, I thought you were saying low, L-O-W, so I was, okay, so they could not commit to a truckload
Correct.
of product?
Correct.
Could they commit to something less than a truckload?
I was not able to use less than a truckload because I would be discontinuing my low NOx for ultra low NOx, and I would not be able to survive.
I understand that that's not acceptable to you. Did they offer a delivery of something less than a truckload before mid-January?
Random lots. So random lots is 5 and 10, and I said I cannot operate on 5 and 10 furnaces.
And when did they say they could get you 5 and 10 furnaces?
December, mid to end of December.
Okay, so they offered you to have at least some compliant furnaces in mid to late December, but in small lots.
In useless quantities.
Useless quantity because
Because it doesn't do the order or us any good.
you could sell them, right?
Not really, because I can't really introduce 5 and 10 furnaces to 5 locations. You know, not all furnaces are the same size. So you have 3 furnaces and 5 locations. That means minimally you need 15 furnaces to provide 1 to location. The numbers don't work. It doesn't make any sense. When you say furnace, furnace is a very broad term. It could be of any size.
When you say it doesn't make any sense, it's not the ideal situation? I mean, you would have product, right?
No, we're not talking about paintbrushes that are all 2 inches wide. We're talking about either a 50, 70, or 100,000 BTU furnace in 5 locations. So you need minimally, to have 1 furnace per location, you would need what? 15, minimally, to have 1 per location. 1 is useless. We put 1 on display.
Madam
Okay,
Chair,
so we're going to turn to,
Yes, Senator.
Chair, in my view, with this line of questioning, we rewriting the order, the abatement order, which states they go out and get someone to supply, and then they give us a schedule.
I suggest you stop there, Senator, and
That's what-
perhaps
that's what it says.
read the order. And what's being,
Modifying the order.
that is not correct. And by the way, what they're asking to do is modify the order. So this is very relevant information. So we need to allow it because it's very relevant.
okay, I'm going to move on to the issue of potential sub-distribution agreement. You stated that a sub-distribution agreement was not economically viable, is that correct?
I didn't say it was not economically viable, I said it was not viable.
Okay, so what's the difference?
Well, economics has to do with money, and viable has to do with efficacy. So it's not viable. It has nothing to do with economics. It's not a money issue.
So why did you agree to continue to pursue and investigate sub-distribution agreements in the previous order?
I didn't put it, I saw it, I mean, I didn't see it till later. We discussed distribution at the last meeting. I think the district shoved it in there, but we established very clearly that sub-distribution was not something that was able to be done.
I just want to stop us here. When we're talking about the order that this board granted, no one stuck anything in here. So we're talking about the order that this board discussed, deliberated, and ordered, which is now essentially a rule of the district. So if you can answer the questions based on what's in the order and what was agreed to, please keep it to the order that was granted by this board.
To be fair, the district is asking in their question is why was a provision agreed to in the stipulated order? And I think that my client's testimony is that he wasn't aware, and obviously is that he
We
wasn't
were
aware.
at the hearing and it was discussed. So orders need to be read, and they need to be read before and they need to be read after. And let's just move from that, please, move
So
forward.
are you stating that you were not aware the order contained a sub-distribution, a requirement to investigate sub-distribution agreements?
I'm saying that we were all of us being the district and ourselves, had moved past sub-distribution and were very focused on distribution with the 6 names that the district gave me.
Could you just answer the question?
What was the question?
were you or were you not aware that the requirement to investigate sub-distribution agreements was in the previous order issued by this board?
Objection to ambiguous as to timing. Are you talking about the time that the
At the
order
time
was
he
issued?
stipulated to it.
I don't remember.
Okay. So I wrote down economically viable, but you're saying that that was not your testimony. I don't, we'd have to look at the video. Why was Ferguson's offer to sell you product not viable?
They made their offer. The offer was made by Steve Adams, who I think is a sales manager of sorts at Ferguson. After he made his offer, which was to sell us day-night product at his cost, I said to him, Steve, you know that we need technical and factory access for knowledge and support of the product. We need an ongoing relationship for replacement parts with the factory. You know we need an ongoing relationship through the warranty period for 10 years. We need inventory on an ongoing basis. And he said, yes, I know. And I said, and a little bit of a chuckle. Then I said, so Steve, why are we here?
Okay, so those are the needs that you have. Did he say that he would not be able to provide you with those?
He agreed that this is not appropriate for a distributor, as did Carrier before that.
Okay. Did he state that he would not agree to supply you with the ongoing items that you stated you needed?
He's not a factory. He could lose the line tomorrow. He's not in command. He's a distributor.
Okay, could you just answer the question?
I did answer the question.
Did he state that he would not be able to supply you with the access to technical support, the ongoing parts, all of the things that you listed? Did he state he would not be able to supply you with those?
He's not capable of giving me that information,
What information?
the information that you just mentioned.
It's not information. It's, you said support and items and supply. So maybe let's go one by one, because I don't have them all the way you've stated them.
I think the confusion is that you're asking him whether he stated something. That's what Jeff is referring to as information. I don't think we'll waste our time if we go one by one.
Okay. Did Ferguson state they'd be able to support the items that provide technical support for the items that they sold you?
He didn't respond to that.
He did not respond.
He did not.
Did you ask him that question?
I mentioned all 4 items to him. He heard me out, he laughed, and he said, yes, I agree with you.
Okay. So did you ask if he would be able to provide those things? You listed them, but did you ask?
Why should I ask if he didn't believe in it?
Can you just answer the question?
I didn't ask him.
Okay. So you stated that there's concerns about having to provide all of this ongoing support, but then you also said that you'd have to refer customers perhaps back to Ferguson to receive this support if you couldn't do it yourself. Is that an accurate representation?
He knew, as we discussed it, that I am in no, since a sub-distributor is nothing more than a sub-distributor, meaning not in control of any destiny, I would be at his whim. If he behaved, that would be fine, and if he decided to discontinue, my customers would have to go to him for the support that they would need.
Okay. But we're just talking about a couple-month period here, correct?
Well, no, we're talking about a lifetime, virtually.
But the customers would be going to them, you said, for support.
My customers would have to go to him
For support.
for support.
Not purchasing of the unit. They would have come to you for that unit.
Well, that too. They wouldn't come to me for the unit. They knew I'd be buying it from him
How would they know that?
because he sells day and night exclusively.
But how would the customers know if you had entered into a separate agreement with Carrier?
I didn't enter a separate agreement in Carrier.
But how would go ahead.
He sells day and night, and only he sells day and night.
Okay. But your customers wouldn't know whether you had entered into an agreement with Carrier or an agreement with Ferguson, correct?
You mean some kind of deceit?
No, why would they know that?
Why would they know that, I'm just repeating the question to understand it. How would they know that I'm not a Carrier because I'd only be selling furnaces. I wouldn't be selling their condensing units or their package units or their air handlers or their heat pumps or anything else. So it would be just furnaces. So that I entered into an agreement for the day and night line, which Ferguson has exclusively, would make no sense for that to happen.
Are you purchasing all of those other items from Nortec?
I am absolutely working with them on all those items. Yes, ma'am.
Are those going to be coming in mid-January?
Not January.
Okay. So for the time being, as soon as you get the furnaces, you'll only be selling Nortec furnaces?
That may not necessarily be the case. We're meeting next week.
Okay. So in any event, you could have had access to day and night furnaces to sell commencing immediately, and then you would have had compliant units to sell. Is that correct?
So we're back to the same discussion. Technical and factory access for knowledge and support, ongoing replacement parts, ongoing relationships with the manufacturer, and ongoing product.
Right, which you did not ask Ferguson if they would be able to supply you with that.
Well, when he laughed at the whole discussion, ma'am,
But you didn't ask.
he didn't take it seriously. Why in the world should I?
Okay, so I'll take that as a no. And did you contact Carrier to find out if you could have direct access from them?
We already had that out there as an opportunity. They gave us a distributor agreement.
Okay, so they would have supported you because they already said they would in a sub-distribution agreement.
That assumes facts.
He just said they already stated they would.
For a
That
distributor,
assumes facts that the offer was still on the table.
Okay, so did you contact Carrier to find out if they would be able to supply you with that support if you entered into a sub-distribution agreement with Ferguson?
Carrier's agreement was distribution, not sub-distribution.
But you had heard from Carrier regarding a sub-distribution agreement with a different distributor.
They set that aside. They said this sub-distribution wouldn't work. They themselves said that, and
Okay,
they
I'm just-
offered us a distribution agreement.
After you heard from Ferguson, did you contact Carrier to find out if they would provide that, all of the support that you've referenced in a sub-distribution agreement with Ferguson, yes or no?
I don't need to do that.
Did you,
This
yes
is
or
not
no?
gonna be
You
a
can
yes or no.
qualify it, can you
No,
answer
I'm
the
not gonna be
question?
tricked into- I'm not gonna be tricked
Can we
into it.
please, I feel that we're not going to get anywhere if we're not directly answering questions. Just, if you could answer the question, and then if you would like to explain it a little more after you answer the question, I think we can move this along a lot more quickly.
If I can explain afterwards, I appreciate that.
Okay, but to the extent that it is related to the question, please.
Okay, did you contact Carrier after you had received a sub-distribution offer from Ferguson to find out if they would offer the type of support that you are listing that you require in a sub-distribution agreement?
No.
Okay, thank you. You stated that you had lost sales, that your customers, which are the contractors, have gone elsewhere to get products between October 1st and the order being issued on the 24th. Is that correct?
That's correct.
And so these contractors, have they always sold other products, other brands? Or were they exclusively American Standard and now they've had to switch over to a different brand?
They were,
I'm sorry, what contractors are we talking about?
Any contractors that you stated you've lost business from?
they were either exclusive or at least 80% customers.
Okay. Those that were exclusive or primary customers, do they have to undergo training in order to start installing other brands of furnaces?
Yes,
Okay. And who provided that training?
the other distributors.
Okay. So which brands did your contractors receive training in?
Anyone who had an ultra-low NOx.
So all of them?
To the best of my knowledge, they
Okay.
didn't check in with me.
So if you were to have day and night furnaces available, your customers would have already undergone the training for day and night?
That misstates testimony.
I'm asking the question.
We would be held responsible to support what it is that we sell.
You stated that your contractors had undergone training to be able to sell all of the other brands of compliant furnaces that were available, correct?
That's correct.
And that includes Carrier, correct?
That is correct.
Sorry, that misstates testimony. And
Well, he
we-
stated that it was
Just-
correct.
Well, he just answered.
Second, hold on a minute.
We could go, we're going to spend 10 minutes on this.
Let's spend the 10 minutes.
Okay, go.
So if your contractors have already been trained to install carrier products, if you started to sell carrier products, those contractors would already have the appropriate training. Is that correct?
I'm sorry, that assumes facts, not in evidence.
Well, I'm asking him the question.
And I'm just saying your question assumes facts, not in evidence.
What facts does it assume?
That all of his contractors have had
I
carrier training.
didn't say that. I said if your contractors, can you answer the question?
I'm going to answer your question.
No, I was asking, did you need me to
No,
rephrase
I have
it?
your question. All of our contractors are trained on an ongoing basis. I'm certain that all the other brands are trained as well. We have tech support folks out there because all installations and typical installations require additional tech support. We don't know what their level of expertise is. We don't know what their level of training is, and our tech support people are not trained at all in that product. So that takes time.
Did you contact Carrier to find out when they could offer your tech support people training on those products?
I wasn't pursuing distribution with them, so I did not do that.
Okay, but once you had an offer for sub-distribution, you still did not contact them, correct?
The sub-distribution was not a viable option.
Okay, so the answer is no?
Please answer the question.
That would be the case.
Thank you.
Okay, thank you.
I think, do you have a lot more questions, Ms.
Yes.
Reichart? Okay, so I think we're going to need to take a lunch. We're definitely not going to work through till 2 o'clock. That's not going to happen. So let's take a lunch. And when we come back, let's try to make this work. I don't know how to say it any other way. Let's try to make this work more fluidly by trying to just answer the questions. If there's redirect that's needed from your counsel, you can have redirect. But let's just try to answer the questions, and the hearing board is going to go through the same process. It'll move everything along much more quickly. So I think we need to take at least a 50-minute break. So let's come back at 5 after. Will that be, it's a little less than 50 minutes.
That's fine with me.
Okay.
Madam Chair.
Yes, but let's all make sure we please are back by 5 after. We have a lot to go through.
Madam Chair, as you stated early on, we have to make an independent decision. We make an independent decision based on evidence that's submitted, and we try to review it and decide accordingly. But these questions and answered and questioned takes up a lot of time.
That's how we get evidence. Thank you very much. Okay, we're off the record until 5 after. We are back on the record. We left off with Ms. Reichart, who is cross-examining Mr. Winter, and I know you had a lot more questions to ask.
Yes.
And again, just with the hope that we can hasten the question and answering by having direct answers to questions asked.
Okay, thank you. I wanted to,
Yes, Senator.
Well, the purpose of this portion of the hearing is my understanding that we're going to hear from possible modification and the status report, correct?
Yes, there are two different competing modifications that are being requested. And so what we need to do is elicit the evidence necessary to make a determination as to what to do.
Or we're also asking for a status report?
That's part of,
Your amendment to my motion. When I made the motion to accept
the status report has been part of the testimony as well. It's what we've heard so far on the efforts to procure compliant furnaces to sell and distribute, et cetera. And also all the conditions of the existing order.
the existing order, status report of the existing order, and then the possible modification if necessary.
That's correct. And so that is what we're hearing.
Anything else inside the order?
Okay, everything we have been hearing so far is completely relevant to both status and also to the competing modifications that have been proposed. And I would like to just propose that we move forward with it rather than continuing to argue about it so that we can try to get this done today.
okay, thank you. Excuse me. So you testified, you estimated your inventory at the October 24th hearing to be approximately 3,300 units, is that correct?
Yes,
And today you estimate it to be 3,100 units?
off the top of my head, yes, ma'am.
Okay, so we've accounted for about 72 or 74 units. Where did the rest of the 200 units go?
We sell furnaces out of Escondido and Ventura and so on and so forth, so it'd be out-of-district sales.
Okay, so that's a lot of units to be sold in Escondido when your historical sales have been very low. Did you have a large increase in sales out of Escondido?
We have additional sales representative there.
Okay, do you have an estimate of how many products you've sold out of Escondido since the last hearing?
No,
Okay, I believe that was part of what you were supposed to report back on.
I believe that it was Escondido sold into the district, not Escondido sold independently in the San Diego area.
Okay. So at the October 24th hearing, you had expected to be able to reduce your inventory to 2,000 units by November 23rd, is that correct?
That's the way the order reads. Yes,
Okay.
yes.
And so that would be a reduction of 1,300 units? Is that correct?
It seems so.
So with a monthly sales limit of 565 units, where were you expecting to sell the remaining 645 units?
That'll be a reduction of 1,300, so 565 twice is almost 1,100 units, and then 200 out of San Diego. It seems reasonable.
Well, you only had 1 month between October 24th and November 23rd, so that would have allowed you 565 units sold in the district, which is a shortfall of approximately 645 units. So what was your plan to sell the rest of those units?
Give me just a moment. I believe my mathematics is correct. For the month of October, it would be 565 according to the order or thereabouts. That carried into October, plus October's 565. That's about 1,100 units plus 200, so that seems reasonable.
From October 24th to November 23rd is 1 month, correct?
No, that's not the way the order reads, I think. May I look again?
I think it would be good to have the order open so that you can refer to it. If you need to read it, just please let Ms. Reichart know.
Oh, give me just a moment.
Maybe I can just clarify this. Was it your reading that you thought, even though there was only a week left of October, you could sell 565 units in October as well as 565 units in November? And that's how you were going to get to that?
Yes.
Okay. What do you consider to be a 150-day supply of products?
My inventory level of 3,000 units was 150
Is
days.
150? And what do you consider to be a 90-day supply of units?
Let's see, take 3,000 divided by. $90 days, was that the
Correct.
question? 1,980.
Okay, so when you had testified at the last hearing that you had already begun reducing your stock from a 150-day supply of units to 90-day supply of units, how can you justify that you still had 3,300 units?
I ceased ordering furnaces and cut myself down to 90. So if I still had 60 days worth of inventory, additional 60 days till I sell it off, but I'm not replenishing it, I maintain 150 rolling days of inventory.
So at the last hearing, though, you had not begun to reduce your inventory from 150 to 90.
I did. I stopped ordering.
But if 150-day supply is 3,000 and you had more than that, then how had you been reducing?
Stop ordering.
But you hadn't actually decreased the amount of units you had in stock?
Well, I have to sell off the difference, but I would no longer maintain 150 days of inventory.
Okay. When is the last time you ordered non-compliant products from Ingersoll Rand?
I can't even remember. It's been quite some time. Before September, to the best of my knowledge, I mean,
Before September?
yeah, I believe so.
Okay, and how many products did you order?
I don't have that information on me.
Can you get that information?
Certainly.
Okay. Can somebody work on that while we're?
Oh, no, I'm the one who does the buying. I could give it to you tomorrow.
There's no access to a?
I
I
buy.
understand. I understand that you buy, but you cannot obtain that information
No.
during this hearing?
No.
You had mentioned that you could get the dates of when you signed the distribution agreement. Did you get that information on the break? Do you want to look that up? I can move on to the next question while we're waiting. Okay. If the order is issued as the district requests limiting your, oh, okay, go ahead.
November 5th.
Okay, and then when did you place your order? Is this going to take much more time?
It would have been a day or two later,
Okay, so the 6th or the 7th?
to the best of my knowledge, recollection.
Okay, if this order is issued the way the district requests, limiting your sales to 100 units per month, which I guess we should specify would be, I guess, in any 30-day period, to be clear, would you continue to sell beyond those 100 units per month?
I don't understand the question.
Would you violate the order and sell beyond 100 units per month?
Heavens, no.
And if the order were to be terminated today, would you continue to sell non-compliant units?
No.
How many units would you need to sell to keep from going out of business?
So, how do I explain? So I would tell my customers I don't know how I would be able to process that question.
Do you know how many units you need to sell in order to maintain the viability of your business?
No. If you told me what the weather was going to be like and so on and so forth, maybe I'd be able to get closer to the answer to that question. We're a weather
I'm not sure how
business.
I'm sorry, I'm not sure how the weather is relevant.
We sell more furnaces when it gets colder, we sell fewer when it's warmer, and we sell a lot when it gets hot.
I understand that, but if, regardless of the weather, if it's 100 if you're allowed to sell 100 units versus 500 units, where in there is the level where you need in order to maintain your business for the next 2 months?
We analyzed that when we got our initial offer from the district, which was, we actually needed 620, I believe it is, and we agreed to 580 with a reduction of 5% a month. I would say we were unhappily satisfied with that number.
So even though your historic sales during October through March is 565, in order to keep you from going out of business, you would need to sell 600 and over 600?
The 600 number came from, I believe, we added, I provided to the district a rolling 3 years of data. So I believe, maybe, I don't have that in front of me, but the district took the number, divided it by 12, and added it equally month to month, which is not appropriate because the winter months are busier, the summer months are busier, and there are months in between that are not as busy.
I understand, but the winter months of October through March, when we took that data, we had, Mr. Wang testified that the average was actually for one season, 536 units, and for another season, 565 units. And then you stated that you would need more than that to stay in business, but then how are you staying in business over that period of time if you're selling fewer than that amount of units?
I don't know what he's done. I can't, it's his testimony, not mine. I would look to see what I sold in November specifically. Maybe you have that information, what I sold in December, what I sold in January. Averages don't work. So, I mean, it's very nice for forecasting, but that's why I don't carry 30 days of inventory alone.
So it's your testimony to keep from going out of business, you would need to sell more than 600 units per month?
I would say that the 585 that we were originally given with a reduction of 5% per month would be appropriate, and that's what was originally done by the district, and that was acceptable to us, even though it was a reduced number.
I'm asking for what the bare minimum number of units you need to sell per month, per 30-day period, to remain in business, to keep you from shutting your doors.
I would say that the 585 that the district
It's
initially offered-
565, so
585 or 65?
565.
It's 560.
It's
Apologize,
565.
565.
I mean, this has been asked and answered that he doesn't know the answer sitting here. We could ask the question 10 times, but
Well, he did answer and said it was more than 600 and that he would go out of business, but then that means under any order we've proposed, he would go out of business.
that was under pressure after his original response of, I don't know, wasn't necessarily accepted. So if you can answer the question, go ahead, but
I know that I cannot tell my customers to come for the first 2 weeks of the month and disappear for the second 2 weeks of the month, or call me to see if I can sell them furnaces that day. I really don't think that that's the way you operate a business. I don't think anyone can operate a business under those conditions, and I don't believe the district would suggest that.
So you don't know how many units you need to sell to stay in business?
I
Is that
can't-
correct? Yes or no?
Yes, but you don't know either.
Of course I don't. I don't run your business. What are your cash reserves?
That's not your business.
Okay, so we have no basis of knowing whether you have sufficient cash reserves to stay in business for 2 months until you have product available?
I'm sorry, I didn't understand that question.
I think we should take a moment and perhaps go off the record, because I know, Mr. Williamson, in your opening, you mentioned that the burden falls completely on the district, and I want to disabuse you of that and understand that when we have an order for abatement, the district, if it's not stipulated, the district needs to prove a violation. However, for these conditions, it's not, the burden is not completely on the district. And so we need this information in order to have the evidence we need in order to mold the proper order. And so my hope is that we are more forthcoming with anything that is not completely confidential so that the board can make the appropriate decision. And if you need a moment.
I would propose that if this would have been brought up to us so we could have a confidential discussion with the district off the record and not in the hearing board, it would have been much more productive. But to suggest that my client is going to disclose, business confidential financial information about what he needs to survive with all of his competitors sitting in the room or watching that's a hard ask. Maybe we could go off the record and have a discussion with the district about it.
Ms. Reichart, do you
I
feel
mean,
that
I
would be?
would, I would take that, but that doesn't give the board information that they need to.
Well, but again, we could potentially minimize some of the back and forth and reach an agreement on what is going to be publicly disclosed.
I mean, we all the time, when we are dealing with orders for abatement, and we have to weigh keeping a business in business.
Certainly.
And the violation of rules. It's very important for this board to have a very firm understanding of what is necessary. And we're not even getting ballpark information. And so I just want you to know it's not going to leave this hearing board with a lot of ability to craft the order that you want.
But I guess to be clear, that my client is not hiding behind confidentiality and not being able to answer Ms. Reichert's question about what are the minimum number of units he requires to stay in business. He just doesn't know sitting here today.
Okay.
I mean, that
Well,
question has not been asked prior to this.
that
this
question
line
was
of
going to be
questioning.
asked by this board member, so I'll let you know it's very important.
Yes, I appreciate that, but the point of my commentary here is that just Jeff sitting here today cannot crunch that number and provide it to you. If, again,
Okay, I'm not, again, I can't debate you. I just wanted to let you know, and this is an ongoing hearing, okay? That information should be available. But, and when it's a status conference, status hearing, we expect to have some information. But regardless, I just wanted to have that disclaimer out there because I know you mentioned earlier on that it is not your burden to prove what is viable or not viable, and I just wanted to, again, let you know that it is equally your burden so that this board is informed.
I mean, my point about the burden is that the district has a burden to satisfy the board that their 100 number they're asking for is appropriate. That was where the burden comment came from.
Okay, thank you.
Madam Chair,
Yes, Senator.
as a member of the board, I don't need to know how much money you got in the bank. That's disclosing confidential information for sure with your competitors sitting in the room.
I'm
How long-
sorry then.
The
I'm
question
sorry.
was, how long can you stay in business if you have a certain X number of dollars in the bank?
And we're not getting that
That's
information.
not fair.
We're not getting that information.
I know, that's.
And that's really important.
Nobody said he could not answer.
We're not getting the
He
information.
he did not answer, but I'm just saying, you, Madam Chair, it's the conditions of the order that was voted on early on are set forth in the order. An amendment was accepted to have an early status report date. Had I known it was going to come to this,
And modification hearing.
said status, didn't say modification at the time.
Yes, it did. We can, Senator, I asked to read the,
I mean, I would not have accepted the amendment.
okay.
Okay.
Well, it was voted on. Anyway, we're going to go back into the hearing.
All right, have you looked into any other options to sustain your business in the 2 months until you can receive product from Nortec? Loans or other options to boost your financial viability?
No, I have not.
Okay. You mentioned that you compared your pricing to AC Pro's pricing. Are you aware of how that pricing compares to other ultra-low NOx furnaces in the market?
No,
You don't know if they're high or low or in the middle?
no.
Okay. Is your agreement with Nortec exclusive, or will you be able to continue to sell American Standard products once compliant units are available?
Non-exclusive.
Okay, so then why aren't you agreeing to condition number 1, requiring you to continue to work with Ingersoll Rand to obtain compliant product?
I didn't say I wasn't doing that.
Council said that you weren't going to, and you didn't agree to.
It actually mischaracterizes the argument, but if he can answer, he can.
I think I testified to the fact that I contacted Ingersoll Rand and asked them to let me know when they do have ultra-low NOx, but they did tell me that it wouldn't be any faster than what I have with Nortec at this time.
Okay. Did you, so would you, can you agree to a condition that states respondent shall continue to work with its current furnace manufacturer, American Standard, who anticipates having commercially available ULN furnaces available beginning in early 2020?
Yes. Hold on, 1 second.
Oh, go ahead, go ahead.
Yes. Yes.
Okay. Did Ingersoll Rand, when you contacted them about a potential shipment coming in with their regarding their agreement with a third-party manufacturer, did they tell you they already had received a shipment of compliant units to their Las Vegas distribution center?
They did not.
They did not tell you that?
No.
And did you ask them when those products may become available to you?
They told me they do not have an agreement.
And they also did not give you a date or an estimated date?
They don't have an agreement.
I'm sorry, when you answer differently, I don't know if you're answering my question or being evasive. So they did not give you a date, is that correct?
What type of date?
A date by which approximately they may be able to supply you with compliant units?
Yes, they did. They told me it will not be any sooner than my Nortec order.
Okay, so what date did they give you?
I told them that I had a Nortec order roughly the middle of January.
And so they said it would be no sooner than the middle of January?
Correct.
Will you also be ordering from Ingersoll Rand starting in the middle of January?
I'll place the order as soon as it's available for me to order.
Okay. After the October 24th order was issued, what steps did you take to notify your customers that you were selling units again?
We sent out an email.
And what was that list based on? The email list? Where did you get the emails?
A customer list.
Okay. And are those customers who have ever purchased from you or within a certain time frame?
Our dealers,
What do you consider to be your dealers?
American Standard dealers.
Okay. And so are those customers who've ever purchased an American Standard product from you?
No, just the current American Standard dealers.
What do you consider to be current American Standard dealers?
For buying from us currently before October 1st.
What do you consider buying from you currently? Is that within the last year, 5 years, 10 years?
They were signed up as an American Standard dealer in 2019.
So in 29, what does it mean to sign up with you?
Every dealer typically signs up with a distributor for the product line.
Okay, so they signed up with you sometime in 2019?
Correct.
Okay. Did you state that you would restrict your sales of non-compliant furnaces solely to complete systems?
We did,
Okay, why did you make that decision?
so that we wouldn't impose on our competitors.
Can you explain that?
We didn't want to get into our competitors' way. We didn't want people, non-customers of ours beating a path to us because they thought that they would get a low NOx furnace. We didn't want to interrupt the industry. We wanted to do more and act above and beyond what the order of abatement asked us to do. We wanted to be good citizens.
Why would restricting your sales to complete systems not interfere with your competitors versus just selling furnaces?
Because if someone was a Lennox or a Rheem or a Day-Night or a Carrier or any brand you think of contractor and they weren't happy, as most are not, with the ultra-low NOx furnace, that they would buy a low NOx from me and install a outdoor unit of another brand.
So can you mix and match furnaces with condensers from different brands?
That's what I'm doing. I'm selling Nortec furnaces with American Standard condensing units.
Okay. And so those have been exclusive of your sales, have been complete systems with furnaces and condensers? That's all the sales that you've made since the order for abatement?
I'm sure there have been exceptions to it if someone stated a hardship and we knew that they weren't playing that game of using someone else's product.
You stated that there was a backlog in contract sales calls of 1 to 2 weeks.
Typically, contractors have a 1 to 2 week backlog.
What is that based on?
Just what they tell us.
So typically, my understanding is when someone needs to replace a furnace, they need it right away, right?
No, remember, we're talking about full systems, as you said a moment ago, right?
Well, I'm just asking, when somebody needs to replace, if they're replacing something that is broken, right, they need to replace it right away, is that right?
If it's cold outside and it's a life safety issue, or if it's very hot outside and it's a life safety issue, but if it's a planned replacement in this mild weather, then there's going to be somewhat of a lead.
When do they have planned when do people have planned replacements?
Well, if your furnace went out today, by example, and it's 75 degrees outside, that wouldn't be, to me, an emergency. So they would, I believe the law has 24 hours of rescission, so they would sign a contract. They would have to wait the 24 hours. Depending on the day of the week, they would begin the job. Maybe there'd be asbestos that has to be removed. There's processes that occur.
Okay. You stated that you do believe that there was a slowdown in the sales because of weather. What would you estimate to be that decrease in sales?
Oh, it's been dramatic for everybody because it hasn't been cold and it hasn't been wet and miserable. So this time of year, typically November, we usually get some rains and it usually gets cold. This year is particularly warm.
So
or
what would you
mild.
estimate that decrease in sales to be attributed to weather?
How much percentage?
Yeah.
A lot. More than 50%.
So this season's down by 50% anyway?
But that could flip on a dime. So if it got cold tomorrow, all bets off. It'll ramp up instantly.
Nortec is doing your training on December 3rd, is that correct?
That's correct.
And who is that training for?
Our field service representatives, I'll be participating, and we have managers who'll be participating as
So
well.
these are all, I'm sorry, these are all people that are employed by Howard?
Correct.
Okay. And then who trains the contractors?
Typically, we do.
So Nortec trains you and then you train your contractors?
Correct.
And then when are you going to hold that training?
After we get our training, we'll hold that training.
Have you scheduled those?
We do. It'll be obviously a rush emergency situation, but we need proper literature to do that. They've already sent us tech support literature and slides, and so we're already developing the training package.
Okay. Have you set any dates for training?
Not yet.
Okay.
We will.
Okay. No further questions at this time.
Thank you. A lot of my questions ended up being answered, but let me go through what I had. I do want to understand, I think that for me, one of the biggest issues is what you're calling the stopgap, but it's the between now and January when you expect to have Nortec. And mostly I'm concerned about that because when this was first introduced to us, we were introduced as a very unique situation where there was no hope on the horizon of having any compliant products. And so I definitely supported the order. But I want to understand, and a little bit more than just what we've heard so far where it's just not viable. I want to understand, so if you were to sell, just go with me on my hypothetical, you were to sell a compliant furnace through a sub-distribution agreement at the same price that the other distributor got it for at that cost, you could sell it, correct, and make money on the sale. Could you do that? And let's just take the first thing, all the compliant other equipment. Could somebody purchase a furnace from you and purchase other equipment that go with it from a different distributor?
I would lose my customer to my competitor because he would say, oh, you're buying it from so-and-so. Why don't I just go buy it from him?
I understand
I would
that.
lose credibility in the marketplace.
Okay, so I'm understanding, because in a perfect world, I understand that, and I understand why. Howard Industries wouldn't want anything to change, between now and when you could change distributors. But the board, because a rule is at issue and compliance with that rule is at issue, needs to consider, what, it might not be ideal, but something sub-ideal, something that would bring in money to Howard Industries in the interim to keep it afloat so that we don't have to make a decision between upholding a rule and destroying a business. So you're saying they wouldn't even purchase? And if you're saying that, would they purchase the furnace from you, or are you speculating that they would not?
That would permanently damage our reputation. That would be with certainty. We'd lose our credibility. We wouldn't be able to properly support the product going forward. And we have the Nortec product coming in, so I don't see why we should go through all that damage in a very short run. It makes no sense.
Between October 1st and the 24th, you were closed. And are you saying, have you realized the damage? Like, have you not realized the damage? Have you undone the damage that was done between October 1st, when you had to stop selling furnaces, and October 24th, when you were allowed under the order?
It was actually very damaging. I didn't actually know the gravity of the damage because the damage was not just external with customers, but internal with morale. So, and I was actually surprised at it. So it's very difficult to quantify in the way that you're asking. Has it been undone? I would say that it's improving. It's certainly not undone because we were let's just say operating at 100% before October 1st, and we're nowhere near 100% at this time. There's a lot of, the order is not a panacea. A lot of consumers don't want to buy the furnace anyway because they doubt the order. Typical homeowner can't read through all of the legalese of the order. They're suspicious of it. So maybe that attributes to the reduced number of sales. Order for abatement is not a cakewalk, and anyone who asks me about it, I tell them so. So.
Okay, but wait, let me, we've heard different numbers, and I understand there's a lag in your record keeping, but we've heard anywhere from 67 units to, doing the quick math, 70-something units that you've accounted for so far that have been sold in the less than a month, but since October 24th. Is that, and the 67 was the first number you gave us, and then you said 32 units from the 24th to the 31st of October, and November 1st to the 13th, about 42 units, so that's about 74.
So I would say that it's probably, that's probably, and I told that to the district, or to my council, that's probably less than half the number of what was sold, would be my personal guess.
Okay. Okay, so assuming that, have you had to lay off any employees during that time?
We've never laid off. We cut hours, but we've never laid off.
Okay. Have you had to significantly cut hours?
Not significantly.
Okay. Have you had trouble with the company, and if you wish to answer, with cash flow or any of the indicators of being able to stay afloat?
No, we have not had a problem with cash flow.
Okay.
I mean, cash flow meaning paying bills?
Paying bills, yeah.
Right, no.
Okay. The inventory, okay, I want to go to, if you could look at it, that would be helpful. In the existing order, page 5, so we're talking about the reduction of the inventory to 2,000 units by November 23rd, so that's 3A. Did you understand when this order was granted and adopted by the board that all of these conditions were required? Compliance was required with each of these?
Well, I believe that the November 23rd was obtainable.
Okay. So you understood that it was, and so what you're asking for today is a modification of that. Is that correct?
Well, based upon, I think, the way we've performed and behaved responsibly, I don't think that that restriction should exist.
Well, let me ask you this. I know we heard a lot of testimony early on that all the distributors had some amount of inventory of non-compliant units. So short of selling it, isn't there a way that, don't they have to get rid of it some other way? How else could you reduce the inventory?
So the other folks had branch locations outside of the district, lots of them. In some cases, these are national corporations. They just have to load it on a truck and move it out.
You know that's true of everyone?
Not, yes, to the best of my knowledge.
Everyone else had places to send them.
Unless the district is aware of someone who specifically had a problem.
So you were not going to comply, was it not your intention to comply with the 2,000 units by November 23rd unless you sold all the units that you had above 2,000?
So the discussion, first of all, this is not about a sell-off. It never was about a sell-off, and if ever, it never was about a sell-off.
I understand, but I'm trying to understand why today there's a question as to whether that can be attained, and then the only testimony that I heard was that you were counting on selling. And if this order was not ever in place, say, or the order was just stop selling non-compliant units, what would you do with those
We'd
with
have to
those
sell
units?
them out of the district, San Diego or Ventura or whatever other areas there are, and it would be slow and it would take years to sell them. But that would be our only option.
Okay.
But this wasn't about a sell-off, and I repeat that completely.
I'm just asking questions. I'm not trying to say that it's a sell-off in any way. Just trying to understand why we're in that situation. And then, okay, could you receive, I want to understand, so there was another question asked with regard to the Ferguson, I think they're Carrier products, the furnaces that Ferguson was offering, is that correct?
Carrier Corporation, but it's made by ICP, yes.
Okay. And one of the reasons was that you have not been trained in that, is that correct?
No, the reason for sub-distribution of any particular brand, so I spoke globally about sub-distribution in general. And then we'd have to take a step back and discuss why it is that we didn't take the Carrier offer. But if we're just going to talk about sub-distribution in general, then it was because of training, parts, continuing relationship, tech support, and so forth. For someone to give us that type of access in the long run is not typically what would be, a manufacturer typically wouldn't give someone that type of access for a month or 2 or 3 weeks or whatever short time. It's certainly nothing in it for them to do that. Now that's sub-distribution in general. And then with Carrier and specifically, why we didn't accept that offer, that was a different question. So please parse the two.
Okay. I took notes on that you were mentioning the training that would need to be done, and you said it's the same process that everyone else is going through. And so I just didn't understand why you wouldn't undertake that process of training if that would mean that you could be able to sell compliant furnaces between now and January.
Right. So if there was a situation where we had a manufacturer who was willing to open his doors and sell us for, at this point in time, 8 weeks or less, and provide a product to us, not as a sub-distributor, but as a manufacturer, we would have to do the same thing we're doing for Nortec, bring ourselves up, ramp it up, parts, replacements, relationships, and so on and so forth. And that's not a 2-day episode. That would take, you could see by the Nortec design, that would take us a couple of weeks to do, plus we'd have to train up our own folks. And now, I'm making an assumption, as the district asked me, are our contractors trained? I can only assume that they're trained in what it is that they're installing. I can't speak to it. I didn't ask them.
Right, no, that wasn't the question I was asking. I'm just really trying to understand why the stopgap measure can't be put in place. Oh, one other question. You had mentioned, okay, I want to try to get some numbers down. So the October 24th to 31st sales, you reported to the district on, I think it was November 4th, you had said, the number was 13. And I believe you had testified that that was cash sales. And then you said that there's a 2-week lag. So today is November 14th. So the 32 units that you told us today, should that be final for that period of time?
No, because the transactions from the 26th to the 31st of the month have not yet, the charge sales have not yet been processed because the month of October hasn't been closed. So it's
So it's more than a
delayed.
2-week lag?
Well, yes, ma'am. As I'm here testifying, work is not happening at the other end.
Okay, you're here testifying because
I know.
you need that.
But I'm just saying,
Okay.
the other end isn't happening.
Gotcha. Thank you. Ms. Verdugo Peralta and then Mr. Balagopalan.
Thank you, Madam Chair. Going back to the sub-distribution situation involving Carrier and Ferguson, and forgive me for maybe if I don't describe it correctly, but tell me if I am. Based on my training also on HVAC systems through Edison, we endured weeks, not just days, weeks of training to understand the different HVAC systems and exactly what you're saying in regards to the technical knowledge of the units and the parts, et cetera. So if we were to picture this, would it be more or less like a contained cylinder that each manufacturer has of what that would take? The manufacturer, the distribution, the sales, all of that goes into that one brand. Is it more or less columnized like that? Is that what you're trying to describe to us? Do you understand what my question is, more or
Not
less?
completely.
If you were to put all the brands of the different manufacturers, let's say across, or even on a spreadsheet, would the technical knowledge, the training, the parts, the 10-year relationship, which I really do value there, would it be in like a column for each? I understand that you are right now using two components together that are two different brands, but historically, is it normally like that they are all in a column and they don't cross?
Right, good question. So by example, from what we've heard from IR, their product is very different than the Nortec product. So in answering your question, it would actually be complete different trainings. Nortec has their process, which is completely different than the IR process. Is Carrier like someone else's? I don't know. I'm not familiar with theirs. But yes, in this case with the ULN furnaces, it is very different. Those two are very different.
Okay, thank you. And also, when it comes to training, how long is your training? How many days
Internally,
internally?
I don't know exactly how it's going to go with the Nortec. I know that there's already been, we're already talking to them in a non-formal classroom way for the last couple of days. They sent us a unit that they've been testing, so it's not a brand new unit, but it's one that's been kicked around a bit. And we've been playing with it, disassembling, reassembling, and just tinkering around with it and asking questions on it. We have two of those. We have one in Culver City and one in Riverside, and we're messing with it, so to speak, and asking and building a class with Nortec. And the December 3rd should cap off what we need in order to transmit that information to our customers.
But how many days do you estimate?
So if it was, I would say, if you took all of those sub discussions, and I would say it's probably 3 days.
3 days for your field reps to be able to be knowledgeable enough to go out in the field and install and service?
If it was all day, if they were like, it would encapsulate into 3 full-day sessions, and then we would be knowledgeable enough to answer tech support questions. We're not training contractors how to install a furnace, but how to deal with this furnace.
Would there be any other additional training that would be required from the manufacturer down, in addition to what you're going to be training your field reps for?
Well, they're counting on us transmitting the information, so if
Okay,
we
so it's
find-
train the trainer.
Yes,
Okay, so for
Yes.
you to get trained on that prior to you training your employees, how many days does that take?
well, that was the 3 days I was referring to.
Okay, and then you're going to turn around and train your people, so that's an additional how many days?
I would say, since we have the resource in our own people, those 3 folks, so I'd say that's an additional day, and then training the contractor is an additional day. So it's,
Another
but
two.
you have to schedule it and get everyone in the
Right,
same room at
yeah.
the same time. And so if you have, in our case, you have 5 locations, so if it's a day in each location, so that's 5 days, which is a week. Assuming that you have access to everyone at the same time, it's a process. It'll take a couple of weeks, but we'll get there.
Okay. The other question, and I want to be clear, and please correct me if I'm wrong on this. You stated that that it was 0.4% that your increased market share would be based on the 65 units from October 24th to the present. Is that correct?
So if my sales were, what I was saying is, the district has said that the furnace market in the AQMD district is 180,000 units. Okay? That's what it was of low NOx. Low NOx was 180,000 units, and they testified to that in the last hearing. So if you took a straight, divided that by 12, it's 15,000 units per month of low NOx. And then if you take my 65 unit sale, or even if you want to take 130, but let's just take 65 as we're talking right now, then an anonymous caller had told the district that we're taking business away from them, and we were just responding, I was responding to, I don't know how much business I could take away from someone if my 65 units relates to 0.4%. How much could I have taken away from a third party?
Okay. Let's see, I had another question. All right, so in a perfect world, what are you seeing as the number that you want us to change it to, if we were to agree?
So the only constraint that we had 2 constraints. Our first constraint, just to preface the answer to your question, the first constraint was we were shut, the light switch was off, everyone was gone, and we hit the switch back on again, and the ramp for folks to come back to us was slow, considering, as the district knew, and I'm glad that they did know, that we were very restrictive about how we sold our furnaces to not interfere with other people's businesses. We did not wish to come back to the district to have exactly the phone call that the district said, which was, you've taken business away from us. So we didn't want that to happen. So we even penalized, I guess, our own customers. Maybe that wasn't a wise thing to do. Maybe I made the wrong decision, but I said it would be system-only sales and not furnace-alone sales. Okay, so I probably lost a certain amount of business, but I wanted to not just follow the order for abatement, but I wanted to follow the spirit of the order. And maybe I failed at that.
What, was the question,
Well,
what are you asking for?
No?
No, it's quantity.
I understand the explanation.
So we didn't ramp up quickly enough, okay? So if had I known that I was going to be measured, my 565 number was going to be measured by how quickly I could get my number back up again and sell as much as I possibly could, I would have been, just going crazy the minute I left this place. But I didn't. But now that business is coming back again, and I could see it, daily it's coming back. I don't see why I should be punished with a number less than the agreed upon number because I acted responsibly. So I believe that we need the 565 less 5% a month, which is what we agreed to. It wasn't easy to get that number. We were not comfortable with the 565. I mean, I ordered 760 to cover me for the month of January. That's the number I'm comfortable with, and that's the order that I placed. So 565.
Okay, but you place, I'm sorry to interrupt you.
I'm sorry.
I just want to interject there. So even though you knew that it was supposed to be 565 less the 5%, you still ordered 700?
I ordered 700 from Nordtech for my January needs.
Those are ultra-low NOx furnaces.
That's
Ultra-low
the
NOx.
compliant ones.
I understand that.
Ones, yeah, sorry.
Okay, so,
I mean, this was a shock to me. This 100 thing came up, was it yesterday? I'm sorry.
I just meant to get a little bit further into what your planning was, what you're estimating, and how you got to those conclusions. I do understand the seasonal thing. I get that you do need them in a larger amount during the wintertime and then also during the peak of the summer, and that there's a lull on each side of that. I understand that. However, if we're trying to find a happy medium here between what the order of abatement stated and what your situation is now, that's what I want to know from you. What do you see working?
Why don't we talk internally and talk with the company, and we can come back with, revisit this after we're gonna have an afternoon break at some point, I assume. We can give you a more concrete answer on the number. I see clearly that the board would like us to have more information to share here. But again, it's tough with Jeff sitting here. Excuse me. It's tough with Jeff sitting here without being able to consult to provide an answer. So I think.
I didn't mean to interrupt you, but I also don't want to ask you any confidential information that is going to put you in any jeopardy with your competitors. I get that. But I think for the board to understand where you're coming from, we need that information. And if you need to do that when you take the afternoon break, I'm okay with that.
Well, what I was saying was, I don't have, I'm lacking, and even if I took a break, I'm lacking the complete data because it's been distorted because of what happened on October 1st. So business is coming back, but I can't give you an absolute, although that's what you folks are looking for and probably reasonably asking. So if I threw a number and said to you, well, I guess I could take 10% less, but that's just arbitrary as much as 100 is arbitrary, and I didn't want to get into, but why doesn't my good citizenship and good record speak to itself? And I don't know why it is that I need to visit, and it's not a question to the board, it's just my own wonderment. What's bringing this on to change the number? I didn't do anything wrong that the number should be changed.
We are under an order for abatement, which is an order that says there is a violation of a rule, and we are required to bring you into compliance as quickly as possible. So are you complete with your questions, Ms. Verdugo-Prato?
Let's see. I appreciate that interjection there because I think all of us need to be on the same page, and I'm not sure that we are. And that's why I'm asking the question that I did in regards to what do you see working with the district of what the right number would be to get this going and to get you out of non-compliance. And if that needs a discussion with the attorney, fine, but I think we need to know what we're looking at. What are we comparing here? That's my question.
So
Thank
if it's the number, then I don't think I would be able to be effectively operating with a number that was less than the 500 number, a 500 number.
Thank you.
And you can say that even though the question before was, are you able to pay bills? Have you had to significantly reduce your workforce hours with the lower sales? The answer was no, you have not. And yes, you've been able to pay the bills, and no, you haven't been able to. So there must be a number less than what you historically do versus what will keep you afloat. And I think that's what Ms. Reichart was trying to get at with her questions. But if there's a possibility to, on a break, to get closer to that number, we'll hold those questions for that. I know Mr. Balagopalan had questions, and I think the senator then has questions. And Ms. Verdugo-Prato, you were done, correct? Okay. Oh, did you want to?
No. I had a few questions, Mr. Witness. I think you mentioned that you have exclusive distribution rights with Nortec?
No,
Not, okay. It's not an exclusive,
no, it's not.
okay. Is it long-term?
I'm hoping so.
Okay. And do you know if they have other distributors in the basin, in the district?
They do.
They do. Do you know how many, or
No, I don't.
you don't? Okay. And those furnaces that they have, do you know that they are certified for what altitude?
Not for high altitude.
Not for, and which is above 5,000, or what do you consider high altitude?
I understand that folks are out there at 4,500 and below, so
Now, keeping the same number, the 500 less 5% reduction a month until, so once you get the Nortec supply early January, then it's done, basically, yeah.
Done.
Now, what are you going to do with the excess inventory?
we'll have to sell it through San Diego and Northern California just ever so slowly, and eventually we'll get rid of it.
Now, I think you mentioned the last, and you are aware of the proposed amendment to the rule. I think there's a hearing going on right now, and some of the members.
I'm sorry, I apologize. We're going to take a short break because Ms. Verdugo Peralta was looking to see if it's possible to stay past the 2 o'clock time or not, so we're going to take just why don't we take our break? Why don't we take our break, which would allow discussion between Mr. Williamson and Mr. Winter, and let's do a 15-minute break to 20 after, and we'll be back on a 20 after. Okay, we're off the record. We're back on the record. We actually are now a 4-member board. We did lose Ms. Verdugo Peralta, but we're still a quorum, so we can continue to move forward in the hearing. I understand that there are some members of the public who wanted to be heard who may need to leave, and I think I'll give, and some that left for a workshop, which I did not realize was going to take all the people out of the room. Okay, so those who wish to be heard, who are here, I just want to make sure I have the right card. So if you want to come to the, got to remember. Okay, we have, I know we have Michael Springer, okay, and Carl Pomeroy. Let me, okay. Okay, so we'll take Mr. Pomeroy first, and then. One of the gentlemen was using the bathroom. Oh, and we come back in. Okay, well, okay, is this the gentleman? Yeah, that's it. Okay. And what, sir, what, are you, did you put in a speaker card, sir? I did. And what's your name? Sean Malty. Okay. Okay. All right, so we have 3 of the 4. That's great. Okay, so we're going to start with Mr. Pomeroy. And we're going to, you'll have 3 minutes. And if you can first, before that time starts, just state and spell your name for the record and tell us who you are and indicate that you took the oath this morning when I administered it.
My name is Carl Pomeroy, K-A-R-L-P-O-M-E-R-O-Y. I'm with Goodman Manufacturing. I'm the division president for the Western Division. Of Goodman Manufacturing. So western half of the United States.
And you took the oath
And I
today?
took the oath this morning.
Thank you. You may proceed.
Thank you, Madam Chair. Goodman Manufacturing has serious concerns over the stipulated order and the competitive advantage that we believe that it provides to Howard Industries and in turn American Standard. We believe that the order of abatement allows them to sell product that is non-compliant, that is beyond the scope of what we've been able to produce and bring to market, and that competitive advantage would allow them to go back and sell furnaces in higher efficiency, variable speed, things of that nature that would, in fact, put them in a position, regardless of even the mitigation fee and the civil penalty that provides a competitive advantage. We, along with a number of other manufacturers, have spent, we stated, I think, publicly in our last hearing, over $5 million in a number of years developing these products. We were able to meet the date of production and bringing the product to market, but the reality is we brought a very limited product offering to market. We have today one 80% efficiency furnace line and one 90% efficient furnace line. That really limited what we have to offer by probably 5 or 6 furnace lines in total in terms of the number of different models we used to sell. By nature of the stipulated order, Howard immediately goes back to having their entire product line to sell, where we don't. If this order is allowed, they're able to go to dealers in the marketplace and, in fact, offer them products that we can't compete against. And we accept that we're at a disadvantage against a couple of our competitors. Lennox specifically has a very broad product line, and we understand we have to live with that, but at least we're competing there fairly against compliant product. That's the first part, and that, I believe, was in the letter that we submitted. I also heard in the testimony earlier today about an email that was sent on the 25th and that it was only sent to internal Howard customers. We would strongly disagree with that. We have customers that have come through our regional sales leaders and told them that that our dealers actually received that email. It may very well be a matter of shared dealers in the marketplace, that they sell some product to somebody, as do we. But when an email like that goes out that says, we have our products back in these things, it significantly affects your business. So that is the comments that we would like to make.
Thank you very much. Ms. Reichart, do you have any questions?
No questions.
Mr. Williamson, do you have any questions?
Quickly, and I'll go in reverse order. How many furnaces does Goodman sell into the SCAQMD on a monthly basis?
We'll reserve to keep that confidential business information.
Okay, is the number significantly larger than 100?
I'll say that it's significantly larger, 100, but I don't care to comment on confidential information beyond that.
Okay, and you heard the testimony earlier today that, you know, Howard Industries' best estimate is that they've sold 100 units under the abatement order to date, correct?
I heard a lot of numbers today. I'm not sure I really but I heard numbers around that, so yes.
Okay, do you think that 100 units versus your much larger distribution in the district, that really is going to significantly impact your organization's sales within the district?
I think it has an immediate impact on our business because
And how
I'm
so?
talking to employees who are telling me that customers that they've been talking to are now moving back that direction because, and I think it was said earlier by your client, that a number of dealers still have a preference for the old furnace. So when they have that available, they absolutely move back that way.
Okay, but there's still is a very small volume of sales
If I
coming
lose
out of
one
Howard,
dealer,
correct?
it's important to me.
Okay. You also intermixed in your testimony American Standard and Howard Industries, but they're not the same entity, correct?
They are not the same entity.
Okay, and you were claiming that American Standard has a competitive advantage now as a result of this order for abatement, correct?
They do.
But the order for abatement is to Howard Industries.
And by way of that, the product American Standard is what's being sold, so my competitor American Standard gains an advantage.
Okay. Did Howard Industries have any control over the manufacture of a compliant ultra-low NOx furnace that you're aware of?
I don't know what discussions they had with their manufacturer, but I would say that our distributors have tremendous input into our development of product.
Is Howard Industries a manufacturer of furnaces?
They are not.
Do you have any reason to believe that they were involved in the manufacture of
I
ultra-low
would
NOx
sure hope they were
furnaces?
involved in the planning for the product.
Do you have any knowledge to
not.
infer that they were? Any control over that process?
Howard's no, but my distributors, yes.
Okay. I have no further questions.
Thank you.
I apologize. Could I ask a couple of questions? Thank you. There was some discussion about conflating Howard Industries and American Standard. Is it your understanding that Howard Industries is the exclusive dealer for American Standard, or, I'm sorry, exclusive distributor of American Standard in the South Coast AQMD jurisdiction?
That's my understanding.
Okay, thank you. And can you give us any idea of the prices for compliant versus non-compliant furnaces?
Yeah, I heard the discussion, and again, in the scope of confidential business information, I don't want to get into specifics, but I will say this, that for someone to say that there is not a competitive advantage in terms of dollar cost difference between compliant and non-compliant, our furnaces that, and I can comment what we sell to a distributor at, are above the full mitigation fee.
Okay.
So there's no way a distributor, without dramatically lowering their margins, could sell that product today.
Okay, and then are you aware of AC Pro, who that distributor is?
I'm aware of them, yes.
Okay, and are you aware of where their prices of ultra-low NOx furnaces fall in the spectrum?
I would say that in general terms at this point, pricing around ultra-low NOx furnaces is, for lack of a better word, murky because it's so new. You know, AC Pro, as part of this change, really began to move more of their products to one of the Lennox off brands as well as part of this. So I think that has caused some confusion as well with where their price point is. So don't really have any specifics.
Okay, thank you. No further questions.
Have you heard the testimony today with regard to the decline in the market for furnaces year over year? I think it was 8 to 12% due to mild weather.
I heard that.
Have you experienced that at Goodman?
I'd prefer to keep confidential business information confidential.
Do you know if you've experienced any decline?
I'd prefer not to comment.
Okay. Do you know if there's been a decline? We heard 50%, I think, even from Mr. Winter with regard to this winter season over maybe October to date.
I would be shocked if it was 50% furnace decline, but I would say in general terms, it's certainly been a little bit of a softer October, but generally speaking, we would not have seen the declines that I was hearing.
And then finally, you heard the question of would 100 furnaces hurt Goodman's business or your distributor's business, what about 565 a month?
I believe that would have a meaningful impact, particularly because, as I said in my testimony, that gives them the ability to go back and sell these higher efficiency, variable speed products that we don't have.
I want to understand that. So you're not saying that there are no compliant furnaces at those varying speed, higher efficiency. It's just that you don't have any and other manufacturers don't, and so there's a more limited product line by many manufacturers.
The very nature of what it took us to get to compliance has us on a schedule, much like we talked about a few weeks ago on high altitude. All those things are in the product plan, but to try to get all of them released by October 1st was not even an opportunity. We're now going back and we have, a year from now, we will have our entire furnace line back, but today we don't. And the problem you get is some dealers really want to sell those higher efficiency products. And so what can happen to us is a dealer of ours catches wind that Howard now has that ability to sell that and then goes to them for those products. We lose a dealer who's now selling non-compliant furnaces that would have been selling our compliant furnaces.
What about in the short term? So, Mr. Winter had testified, I'm trying to remember in the context, I believe it was if they had to sell a compliant furnace, but they didn't have the whole package of training, and so a customer would go elsewhere. What if customers, as you're saying, chose to go to Howard instead of to a Goodman distributor because of a lower price, because they could get non-compliant units? I don't know if you heard how Mr. Winter testified, how that would hurt the business. Would you expect to see a similar harm to distributors and/or Goodman?
I don't tend to think that a dealer that will go to a distributor for one item versus another, I think they will typically buy their whole system and accessories from one distributor.
Okay, so then if 565, are sold and that impacts the market for Goodman, you're saying that would have a similar substantial impact on future relations?
The problem is it's not the 565 for the next 3 months. It's the customer that I lose for 5 years. And so while I'm sympathetic to a window of time where they have a problem, if they gain a competitive advantage for that window of time, I don't lose for the next year. I lose for the next 5 years while I fight to get that customer back.
Thank you.
Thank you.
Mr. Balagopalan.
Mr. Pomeroy, I'm looking at the letter from the attorney on behalf of Goodman. And so the issue that was highlighted here was that it says Howard should not be allowed to sell non-compliant variable speed furnaces because you don't plan to have that available until April 2020. So, and does anybody carry that variable speed?
I believe today there are potentially, and we have a carrier representative that will follow us, I believe they might have a second line out now, and I believe, I know Lennox does, but there are most people were more similar to us that they launched a base model of product to get started.
So if a customer needs a variable speed, because that goes with the whole system, right? Because the air conditioning and everything.
We have a way with our product that you can use the higher variable speed air conditioners with our compliant product through some relay kits and such.
Okay, so you can do that?
Yes.
Okay. So, that was the issue, that they should not be allowed to sell compliant variable speed, but, because you won't have your product till 2020.
Correct.
And you know that this order is just for a very short period of time. And it looks like from the testimony we heard, Howard has somebody in line already, and early January they're going to be selling compliant product, so that will cease once they sell that.
Correct, and I spoke to Mr. Winter as we were instructed, I believe by the order of abatement, about the possibility as well, as I think he testified this morning, so yes. But we still consider it, we consider that them having those additional products to sell are a serious issue for our business.
Because you may lose them.
We may lose
I mean, you
customers
lose
to
a
them.
When you say customers, you're talking about the
Meaning
distributor.
dealers.
The
Dealers, really,
yeah,
dealers.
dealers, sorry, yeah. Okay.
Thank
you. What is your proposal here then?
We would absolutely like to see them at least curtailed back to having just the one base model of 80 and one base model of 90 entry-level efficiency furnaces, which is what most manufacturers, I believe, in the market have today.
But can they do that if they're doing the full system?
Sure.
Without having the variables?
We're doing it today.
You're doing that today, but is that the best approach for the customer?
It's a better approach than my business and my customers leaving me for them.
I mean, I'm talking about the end consumer,
No, I think we have solutions. There are at least two other manufacturers' solutions in the market for a consumer that desires that. And so I do believe that there is customer choice if they want to go to those type of systems. I think we all accept that what we're trying to do here to be compliant within the 14 nanogram per joule, I think that very situation has made this a tough market, and I'm sympathetic because we have to live it. But the reality is I don't believe anybody should be given an advantage.
Okay, thank you.
Thank you.
Other questions, board members? Senator?
Your concerns about Howard doing business in this district with these furnaces, have you discussed it with the district other than here?
We have. We've had numerous conversations.
Have you put anything in writing to the district?
We have. Well, I believe we have the letter that you have in front of you here as an exhibit that was sent to the district, and I know we've had several around the letter that's the exhibit.
Goodman had filed their letter on November 12th, on Tuesday. And so we didn't mark it, but it was part of what was given to us 2 days ago.
And I would say, I don't know how many conversations, but a number of conversations with district staff.
I'm sorry, I talk of you. It was a letter from Mr. Robert Hines, who we know from another hearing represents Goodman on November 8th. And it also has as Exhibit A a letter of October 29th attached to it.
The question was asked of you, how many units have you sold at certain periods of time? And your answer was?
I think I said it was confidential business information.
Right. You were in the room.
Yes, sir.
When the district was posing the question to Howard. In fact, they stated what Howard had reported that they sold, which otherwise would have been confidential information. If they were asked, they would say, it's confidential. But that information was revealed to you. Did they give you an advantage?
I don't necessarily think of it that way. What I do think about is that I'm not the one here asking for a stipulated order to be able to sell non-compliant product. If I was, I suspect I'd be telling you how many furnaces I sold.
Well, I'm just asking your opinion. Is that an advantage, yes or no?
Not a significant one. It helps me understand what their market share might be, but that's the extent of it.
If you knowing what the business that they've done, it's not an advantage. Why would think it'd be an advantage if you tell them what you've done?
I think that we choose not to provide what we consider confidential information around revenue and those type of numbers if we can avoid it, unless we absolutely have to. And in this case, I believe we're not the ones asking for the order. That's why we choose not to.
Does Goodman have compliant ultra-low NOx furnaces that are available for sale?
Readily available today.
Are you selling non-compliant?
No.
Thank you.
Well, did Howard approach you, the Goodman,
Yes.
to buy?
Yes, they did.
And what, according to the order, Section 1A, and you said yes or no, what happened?
I had two conversations with Jeremy Winter. In the first, we discussed a number of different topics, what the product lineup was. We talked about how many products that we had available readily, of which we told him that we could ship immediately. Not thousands of furnaces, but certainly north of hundreds of furnaces immediately. We discussed a number of the issues that we have as requirements to become a distributor of our products. And he spent a couple of days, thought about it, followed up with a conversation with me a couple of days later, and basically said they weren't really prepared to move forward at that point, that they were talking to another manufacturer.
Why weren't they prepared to move forward?
Because I believe they probably signed something with Nortec.
I think there was, I believe there was testimony as to that
There was, I think, this morning.
earlier by Mr. Winter. Correct. Mr. Winter testified earlier that I believe he gave up, he would have had to have given up American Standard products, selling American Standard products. That was his testimony.
Well, you're a distributor also, aren't you?
We are a manufacturer, and we sell to a number of distributors in the marketplace.
But you don't,
I work for the manufacturer.
and you don't provide, your company does not provide distributions to,
We have a series of distribution locations that are owned by the company, correct? Separate
so
corporation.
that's, in a sense, that's competition, isn't it?
When you say competition, I don't know the context.
Well, you're a distributor, Howard is a distributor.
And I also sell to 2 other independent distributors in the market as well.
Is it their opinion that you're in competition with them as distributors?
Our other distributors? No, I don't think they see it that way, to be honest. I think we certainly compete in a marketplace because that's the way it works, but that sells our product is put on a level playing field, and they work to go earn their business.
Is the level playing field, the price is the same?
Yes?
Whether the manufacturer sells it or the distributor sells it?
Yep.
No advantage there.
No.
All right, thank you.
Thank you.
Any other questions for, did you have questions, Dr. Bernstein?
Yes, ma'am, thank you. Mr. Palmer, I just want to clarify for my own edification. Testimony was given earlier by Mr. Winter regarding the potential for a relationship with your company. And he testified that he was told that he would have to give up carrying American Standard products before he would enter into that relationship. Is that something that you would argue with, or is that something that would be part of that negotiation?
We talked about the fact that, and again, we talked about a lot of things in a fairly short conversation, but we talked about the number of different brands because, as I think we talked about when we were here last time, we sell under numerous brand labels. And what I talked about with him was that the different brands have different requirements. But as a general statement, that we have what we classify as a competitive goods clause, which is our distributors sell our products.
So the answer was yes?
Yes, I will
Okay.
give you yes.
Yeah, thank you.
Yep.
Any other questions for Mr. Pomeroy? Okay, thank you very much, Mr. Pomeroy, for your testimony. Let's call Mr. Michael Springer.
We lost our other one, by the way.
I'm sorry?
We lost our other one. I'm not sure.
Oh, okay, okay.
Good afternoon. My name is Michael Sprenger. I'm with Carrier Corporation, last name Sprenger, and yes, I have taken the oath. If you remember last time I was here speaking about the abatement order, our big concern was that the obstacles that was preventing Howard Industries from purchasing ultra-low NOx units were essentially obstacles that he put in his own way. We were concerned about feet dragging, and we were concerned that this would just linger on. We have it again because, remarkably, Howard Industries has chosen to buy from a company who has no ultra-low NOx products currently available. They hopefully will be available in 8 weeks. However, we had this big conversations about hearsay. That, to me, would be the definition of. We have no one from Nortec here. We have no idea if the supply chain is ready. We don't know if it's actually going to be certified, although we did hear perhaps in a week or two a couple of models would be. We don't know if tooling is done. We don't know if the manufacturing is coming off the line. We don't know so many other things about actually these Nortec products. So it's as if we have another situation of let's wait another 8 weeks and see if they can actually deliver what they say they can deliver. There have been some confusing testimony that seems to shed some light. We don't know the brand. We talked about, Mr. Winter talked about needing a smooth transition. There were discussions about whether Train might purchase some products, whether Train has an agreement with a vendor. It is actually we had heard from at least one distributor that Train was perhaps in discussions to purchase ultra-low NOx products from Nortec. And if that's actually the case, this seems to be the definition of a product variance and the definition of a distributor who simply wants continuity of supply to enable them to continue, whether it's American Standard, whether it's under a new Oxbrox brand, whether it's under a Nortec brand that Train is co-sponsoring, and we don't know that. I just don't know that. But it's a lot of things we don't know. The whole process here, again, comes down to an obstacle that Howard Industries puts in their own way. This is 3 weeks ago that we had this variance, this last hearing, and now it's only another 8 weeks. It just seems to be dragging on, and it's not perfect for Howard Industries, there's no doubt about it, but they could have had product in September, they could have had product in October, they could have had product, and we said, I believe it was 4 to 6 weeks as I stood here 3 weeks ago. They could have had product, frankly, next week. My time is up.
Well, basically, there you go.
Ah, there we go. Okay, Ms. Reichart, questions?
Thank
for
you.
Mr. Springer?
Can you give us any detail about the difference in pricing between ultra-low NOx and the non-compliant furnaces?
Ultra-low, well, I don't know exactly in terms of distributor pricing to dealers or dealer pricing to consumers. But in terms of our pricing, ultra-low NOx product costs more to make, and it is more expensive. It ranges depending on the exact product, but it's whether it's $300-400 to $700, $800, $900, somewhere in that range. I don't want to get into too many specifics, but it is more expensive. Yeah.
So even when the mitigation fee and an additional penalty is added, based on, the information presented in the hearing, are you aware, is there still a price difference between the ultra-low NOx and the low NOx?
I don't know.
Okay.
And I say that because we're not privy to what the penalties are, so it would be completely unfair for me to say that it's too expensive or not, because with mitigation, I believe it is, but what the penalties are, I just don't know, so I have no way of being able to say if it's on par or not.
Okay. You may have heard testimony about a market decline just based on a variety of factors. Do you have any information, either specifically as it relates to your company or through trade publications or trade talk of where the market is right now?
So we talked to our distributors in the district. They have been down since October 1. Whether or not that is attributable, whether it's specifically to Howard or whether it's because it's been abnormally warm or because of consumer confidence or anything else, I don't know. But one distributor told us he was down significantly. It was over that 50% mark. But whether that's due to any factors here today, I couldn't say.
Okay, and was that, you said one distributor said it was over 50%. Was that generally what you were hearing, or were the other?
No, that was generally what we were hearing.
Okay.
A couple of distributors just said that we're way down, but wouldn't give us actual figures.
Okay.
But yes, my understanding is generally that our distributors are down.
Okay. Okay, thank you. A technical question, because this came up. Can you mix and match furnaces and condensers between different brands?
I am not the best technical person to
Okay.
ask. My understanding is that you can, but when you get into the details, you're talking
Okay.
to the wrong person.
That's okay, thank you. No further questions.
Mr. Williamson, questions?
Same question for the previous witness. What are Carrier's average annual sales within the district?
Yeah, we'd prefer to keep that confidential, but thank you.
Okay, are they significantly larger than what you've heard from Howard Industries today?
Yes.
Okay, thank you.
Mr. Springer, were you present when Mr. Winter went through each of the manufacturers and explained why they were no longer in discussions?
Yes.
Okay, so did you hear the explanation for Carrier that the reason why they ended discussions with Carrier was to go with Nortec?
The first I heard Nortec was this morning, but the answer to your question is yes, I did hear that testimony.
Okay, did you understand a different reason why?
I didn't know the reason. I actually, until this morning, we didn't know that he had made an agreement with anyone. The last we had an exchange November 4th. I was again following up on the distribution agreement that we had sent them prior to their hearing on abatement. If you remember in the hearing, there was discussion of, well, maybe the distribution agreement will be reviewed, it'll take 1 or 2 days. I had followed up, and they said that they still had an obligation to look at 6 manufacturers, and he disagreed with my view of the abatement order. And I said on November 4th, we recognize the parties have different views of our abatement order, and that's okay. Our pricing remains the same. We will await your response.
I'm sorry. How did you understand? No, what did you understand that to mean, that you had different understandings of the abatement order?
Different understandings in terms of our view is that it wasn't warranted. And I had told Howard Industries that, look, if we're going to do this, let's go. Have we heard anything? Are we actually going to move forward? I had the email exchange if you're interested, but it wasn't in terms of interpretation of what was required. I don't want to represent that.
Okay, so it's your representation that you agree that it was Howard that stopped discussions with Carrier?
Yeah, we hadn't heard anything since November 4th.
Okay, and November 4th was when you followed up, is that correct?
Yeah, we had, yes, that's right. We had been following up. We followed up the Monday after the hearing. Jeff did respond very quickly to each of my emails, but we're still looking at it. We'll get back to you. And then there was one email that said Jeremy was looking at it. We followed up again, and that was the last we heard was on November 4th.
Okay, and then, sorry, I'm just writing. I had a question, it's escaping me at this late hour, it was an important one. Does anyone else have questions, and I will come back with that.
Mr. Springer, so the arrangement of the discussions you had would have been Howard as a sub-distributor and not?
No, so yeah, there've been some confusion on that. So we had offered Howard Industries a sub-distribution arrangement. We had told one of our distributors that we would waive the sub-distribution clause or anti-sub-distribution clause prior to his original interim variance hearing that was denied. I think, yes, that was in September, if I remember correctly. I can get the dates if need be. But it was shortly before the abatement hearing, I believe it was the 20th of October, we said to Howard Industries through an email that we would be willing to sell to him directly as a distributor through a different brand that we could sell to him direct, and that the pricing would be the same that we offer other ICP distributors. We had then sent him a distribution agreement. We then, after his interim variance hearing, had said both options were made open, that he could go either the sub-distribution route or the direct distribution route. We then had a distributor of ours come to us, I believe it was Ferguson, that said, well, we'll sell to him. Let me give him a call. Would you, we're going to essentially pass it through as opposed to have an increase in price. Can we do this? And we said, yeah, okay. Because we had already offered him sub-distribution through a different player.
So that sale or agreement with Ferguson would have been, the clause would have been as a sub-distributor, not as a because Ferguson's already a distributor.
Yeah,
so
Ferguson is one of our distributors,
so
if Ferguson is selling to Howard,
they
it would then be
their
through a sub-distribution.
And you can appreciate some of the concerns that Mr. Howard had regarding training and parts and,
Yeah,
access to.
my biggest issue is that it's not ideal. I agree with you completely. It is not ideal. We do have a handful that sell through sub-distribution and have for many years, not in this district. I don't want to represent that. But it's not ideal. But it would have enabled them to have product.
Right.
But that is one of the reasons why we actually said, prior to his interim variance hearing, that, okay, we'll actually bring a new brand into the district, and we will sell to them directly as a distributor.
And I think at the October 24th hearing, we were, I think when we approved the order, after your testimony and you're talking directly to Mr. Winters that you're willing to sell, I think we were, I think, quite encouraged, yes, thank you, that there would be some agreement and there would be some sale. But
Yeah.
we don't want to get into the business detail and why Mr. Winters did or did not go. But he did agree with somebody else, maybe the terms or whatever, it was better, and that.
Yeah, the only evidence we heard was Mr. Winters said that he had heard from a couple distributors that they didn't like the quality of the Carrier product. That was not a concern that was ever brought up to us, nor were we given an opportunity to discuss it, and that would have been the first I heard about our ultra-low NOx products. If you remember the order, it didn't allow him to decline based on price, if our price was consistent, so we didn't have, I don't know who those distributors were, nor were able to follow up.
And just, I think we also had testimony from Mr. Wang that I think Nortec has, but I think due to some issues.
Yeah, that
the
was
model
brand new to
number-
me.
Yeah.
We all kind of freaked out when we heard
Yeah,
that. We
but-
went, wait a minute, let's go on the website.
Right, I know.
Yeah, and so that's possible, although I heard that we've tried to buy essentially every ultra-low NOx product we can find, and we want to see what our competitors are doing. I mean, I'm not aware of this product in the market at all from Nortec, but I mean.
But you don't distribute Mr. Wang's testimony maybe by the end of the.
Oh, no,
week.
I have no reason to doubt that it'll be certified.
Certified and-
I just have no way really of knowing other than through a single statement that it'll be available by mid-January.
Okay, appreciate it. Thank you.
I found my question. If Howard had chosen to follow up on the distribution agreement and make an agreement with Carrier, would you have compliant units available in the amounts that were discussed today?
Yeah, we had said, I think it was 4 to 6 weeks, and that was 3 weeks ago. And yeah, we would have had products available. Primarily the 80s versus the 90s. We have fewer 90s, 90% versus 80% units available, but that was the same what we heard from Nortec, where they were 80s units, if you will.
Would you have it in, let's just use the number that's in the order. Let's use historic sales of 565 units a month?
I don't know that. I know that when prior to when we were recently convened on this same issue, it was Carrier's view, and after talking to some others at Carrier, that we would have more than enough products to satisfy his needs. Whether or not those needs were 500 or 300, I don't want to represent it because I just don't know.
But would you say it was a significant amount?
Yes.
Okay, and ongoing?
Yes. Yeah, one of Mr. Winter's big things was he wanted a long-term relationship.
Of course.
And we had indicated that we were willing to sign him up as a distributor and that we weren't willing to have, sign a 10-year agreement. We only do 2 at this point. Plus, we've never worked together before. But that was the goal.
Okay. Thank you. Any other questions for Mr. Springer? Senator, did you have a question?
It's your contention that if Howard is continuing to be in business for a short period of time, that would be a threat to your business?
No, that would be an unfair statement in terms of threatening Carrier's viability. No.
So what's the problem?
We think it's frankly patently unfair to our other distributors and dealers. Our distributors have had to get ready for this ultra-low NOx rule for a long time. We requested a sell-through, we were denied. We had distributors who had to get rid of their inventory. We had distributors who had to buy different products and mix and match and figure out how they were going to handle it. And to me and to Carrier, this provides Howard an opportunity that all of our current distributors just simply didn't have.
These distributors are aware of this hearing, aren't they?
They are.
But they're not here.
Well, there was. And I know at least one or two have made comment, but they've certainly commented to me, and we did make them aware of the hearing, yes.
Howard has about 2,000 in the inventory,
Okay.
No, they had 3,300.
according to,
No, 2,000 is what was required to be, to come down to by
come
November
down to by
23rd.
reducing 5%.
We're hearing that's not going to happen.
How many, did you hear how many they have in storage?
Well, if they have 3,000 in inventory, it would be around 3,000 if I heard it correctly.
And they're reduced 5% until they get down to about 2,000? Did you hear the testimony they would dump those?
That misstates the order. The order was to have the inventory come down to 2,000 units by November 23rd, and then a 565 cap on monthly sales. That would decrease 5% every month.
I'll get to the order in a minute. Did you hear them say how many they've sold the past month, 3 weeks?
It was in the 60s, 63, 65, I think, if I got it right.
And that's about 3 weeks. And well, that's not 500.
That's correct.
So they're depleting the inventory by a small number. Did you also hear them say that once they are able to sign an agreement, that the surplus they have on hand, they will sell outside of the district?
I don't believe that was the testimony. I believe the testimony was that once they received sufficient product, that they would stop selling the non-compliant products, but I did hear that.
Once they had a signed agreement.
That was not my understanding, because they have a signed agreement already.
Once they have a signed agreement and have the product on hand,
Okay,
they would stop selling.
I did hear that.
Outside of the district.
I did hear that, yes.
And that's not a lot of numbers, less than 100 per month.
That also misstates.
I know we sold.
We heard testimony from Mr. Winter that, well, we heard a number of different numbers, so we're not exactly sure what the sales have been. It might be as much as 200, I don't know, because I heard double. However, Mr. Winter also said that he plans to go up to
I think
500.
the district is saying, let's set it at 100. And they gave evidence as to why they're saying 100, because they haven't been sold 100 in the past 3 weeks.
I'm sorry. We heard testimony from Mr. Winter that he does not have final numbers yet.
I don't mean Mr. Winters, I mean from the district.
The district only knows from what Mr. Winter tells them.
Well, then I haven't heard anything more than 100.
Again, we heard from Mr. Winter. The highest number we heard was 74, but we also heard that a significant additional number have not been accounted for because they are credit card sales, and there's a large lag in the accounting. So the answer is we don't know the number.
No more questions of you, sir.
Okay, thank you.
Anyone else have questions for Mr.? Okay. Thank you, Mr. Springer. I think we have two more. Let's see if they're here. The next card we had was Sean Monty. Italy. Is he gone for the day, do you know? That's too bad. Okay. Mr. Doug McLeish. And Mr. McLeish, with JCI, you have also 3 minutes, and if you could state your name, spell it, and indicate that you took the oath this morning.
Doug McLeish with Johnson Controls, and I took the oath this morning.
Can you just spell your name for the record?
I'm sorry, M-C-L-E-I-S-H.
Thank you.
Okay, there was 3 topics that Madam Board Member brought up earlier. First, I'm going to talk about the Nortex, then I'll talk about the monthly inventory of sales, and then I'll talk about the sell-through. I like Mike from Carrier Corporation, was not aware of Nortec having a product on the market at the beginning of the month, but we like all of our competitors, try to keep up on the competition. But one of the things on that one topic I'm concerned about is, because I have been involved in the York and JCI product rollouts, and it sounds like it's the first product rollout for the Nordyne or Nortec. I'm concerned about the timing because I don't think any manufacturer, whether it's automobiles or heating and air conditioning equipment, ever hits that date properly. So I'm concerned. I think you guys ought to be aware of that's a concern. And then that would be tied to any adjustment you make in the agreement if you decide to tweak it on what that other date is, because when the industry says January 15th, that can slide. On the next topic of limit of sales, Howard Industries has been a great competitor in this market for a long time. The only concern I have there, I just came out of another meeting regarding the change of another topic you guys are very much involved in, and they have had some competitors, some contractors there that are selling a train product line, and they're complaining they don't have a product available. They do have a product available. They could be buying it from Howard Industries because they have sales in desert they need a gas furnace on, so they could be paying a higher price. And that leads me to the point of the higher prices. I don't complain at all about being able to, they've kind of got caught with the manufacturers and have a product line available to them, but I am very, very concerned that whatever that delta you guys calculated was calculated properly, because that can be a definite negative, and there is contractors and homeowners out there that would much rather have the non-approved hypothetical product line and pay more money for that. So that's something I know you try to take in consideration, but in some cases, no matter what the delta is, people are going to pay the higher price anyways. That's a concern. As far as the sell-through, every manufacturer, and the gentleman from Carrier alluded to that, every manufacturer and distributor has had to go through that. We weren't allowed a 6-month sell-through period like we've had in all instances this industry has gone through with efficiency change in the past. This is the first time we've never been able to do that. That's been a problem for everybody. They do have 2 locations, one in San Diego and one in Ventura, which was stated earlier, so they have an opportunity. It's not like taking whatever the balance of furnaces is and throwing it away. They do have a source to sell those. With that's the top. Those are the 3 topics I wanted to make sure I gave you my 2 cents worth in.
Thank you very much. Ms. Reichard, questions?
Thank you. Do you have a concept of the difference in price from Johnson Controls compliant units and the non-compliant units that Howard is selling?
Yeah, when I originally looked into this and you had set the mitigation fee, I felt, and then you also had set the rebate amount. I thought the rebate amount day one was not going to be enough to wash the difference. And anytime you roll out, I don't care what it is, refrigerator, car, everybody's going to hesitate, and a lot of contractors are going to hesitate to buy their first round of that. And 80% of the decision that the homeowner is going to be involved in is made by the contractor. And I think, the gentleman of the board, and we had a couple instances this early in the week where you've experienced that. The contractor plays brain dead, and a lot of them, I shouldn't say but they're really hesitant to promote the new product line because they really don't, haven't been properly trained on it, or really want to wait till there's a learning curve that flattens out.
Okay.
So. And here again, we can't really get into price because it all depends on what the contractor wants to sell it for and how he wants to make that presentation to the homeowner too. In a lot of cases, I think that a lot of contractors are holding off doing that. Now they don't have a choice though.
Right. Did you hear the testimony about the decline in the market due to various influences?
Yes.
Do you have any information either specifically to your company or from information from trade publications or other sources?
I was kind of shocked. I'm sorry I interrupted you.
That's okay.
I was shocked with the 50% number. I do agree with the gentleman from Howard Industries that our business fluctuates 17 to 20% around numbers on heat or air conditioning. but the industry is not down that much. I think if looking back on my representative, my numbers in the West, I think a 9 to 10% delta between year over year would be in line. Anytime you make a transition, like we have a major transition, there's going to be a bump in the road. There's going to be a spike in sales of the older furnace, and then you're going to have a slow ramp up. So I thought those numbers were a little inflated.
Okay. And are you aware if you can mix and match furnaces and condensing units among?
Yes, it's done. I wouldn't, your top tier contractors are not going to do that. And the shame on them if they do, because the homeowner really wants to buy a match system. It's not necessarily a concern on the heating side as much as the coil needs to match the outdoor unit on the air conditioning side. But you do need to make sure, because the furnace, in this case, it produces the air, you need to make sure it's putting out enough air to properly give you on the air conditioning side, but that's not going to affect the heating side. But a lot of, I shouldn't say a lot, but, as this board's probably aware of, in the past, we had the consolidated furnace, which was a manufacturer that multiple manufacturers sold with their logo on it in the past, and that was mainly in the residential new construction because of pricing point and availability of horizontal furnaces. So yes, that is done.
Is there, what about the AHRI certification that?
Good question. But that is concerning, like I said, the air conditioning side. So, you have an outdoor unit and you have your coil, but to get an ARI number, you really need to match system with the furnace, to your point. So you really.
Can you install without having that AHRI number?
I think you should request, redo that question.
Oh.
Yes, you can.
Okay.
But I don't think that's the question you really want to ask me. Anybody can
What's
put it.
the question I want to ask
What I'm
you?
saying is that a contractor can buy the components and put it in, but is that going to meet an ARI matched system matchup? No.
Okay.
For instance, like a lot of utilities will require the HRI number to give a utility rebate, but if it's not required, there would be your weekend type contractor that will take the different components, and because there's cost advantages of shopping one versus the other, and put a system together. That's definitely not beneficial to the homeowner.
Okay, thank you.
Mr. Williamson, questions?
Just a couple questions. You have no personal knowledge about what the per unit fee is that Howard Industry is paying under the abatement order, correct?
No, I do not.
Okay, so you really don't have any personal knowledge about what the price difference is between Howard Industries units versus the competitors with compliant units, correct?
I do not.
Okay, that's it. Thank you.
Board members, Mr. Balagopalan.
Mr. McLeish, you have similar concerns as Goodman regarding the variable speed issue. You heard the representative for Goodman, Mr. Pomeroy, talk about the fact that they have an advantage in selling the variable speed unit because nobody else has it on the market currently.
Was that a ultra low NOx furnace?
No, I think it was not ultra low NOx. Yeah.
I didn't hear that testimony, but a concern that I've had all along is that when you've eliminated, you've come out with a new product line, at least the majority of the manufacturers that I'm aware of that have ultra low NOx furnaces do not have, hypothetically, they're using all standard ECM motors, but they're not using an actual ECM motor, and they don't have the two-stage heat, so they don't have the variable heat. So you've eliminated your good, better, best sell-up and comfort opportunities to a homeowner other than just giving them hot air. And I don't know if that answers your question. There's definitely a disadvantage if somebody is selling two-stage variable speed or a total ECM communicating system versus a system that only has standard ECM motor or is ultra low NOx, if that was your question.
Yeah. Okay. Thank you.
Any other questions for Mr. McLeish? Thank you, Mr. McLeish.
Thank you for guys hanging in there today.
Board members, I want to determine your pleasure. We are not going to finish today, nor I think should we, because we have three competing versions of, we haven't finished all of the testimony, but we have three competing versions of a proposed modification to an order for abatement, and I think that I, as a board member, need to spend more time with it and to see if any of those versions are going to be valid versions, or whether or not we're going to have to make changes to any of them, because they're very comprehensive. We need to finish the testimony, but also, I think we need to sit back and think about the scope of what we're considering today.
Williamson was testifying.
I'm sorry, can you put on your?
Mr. Williamson was testifying, and you asked questions.
Mr. Williamson did not testify. You mean
Winter?
Mr. Winter?
Mr.
Mr. Winter?
Mr. Winter.
Yes.
Sorry about that. And I never got a chance to ask him any questions.
Yes, no. We have more testimony to
I
come.
haven't finished my question.
And I know
Yeah,
Mr.
yeah.
Balagopalan
I
was in
think
the
before-
middle of a
then
question,
we can-
actually.
Once we finish with,
And we lost Ms. Verdugo Peralta. I'd like her to be here for the vote. But more than that, I want us to, I'd like more information. I don't know if we're going to have the information we need today, whether we exhaust all of our questions or not. And, I'm sorry.
I'm on vacation next week.
Oh, no.
I'm on vacation for the next 2 weeks. So I just want to put that out there before we get much further.
Okay. Let's continue and see where we get. I am very concerned that we are making a very far-reaching decision that's reaching way further than Howard Industries. It's the whole Rule 1111 compliance, and we have a lot to consider, and that's concerning. But Mr. Winter is back. I don't see we're going to get through all of our deliberation, and I don't know how we're going to end up on I don't know if my fellow board members have combed through the proposed, all of them. You've combed through them, and you know everything that's proposed, and you can vote on one version or another. Okay, I haven't. Okay, Mr. Balagopalan, let's try to finish up our questions.
Yes, I'm trying to see where I think I asked, my question was, once you have those compliant unit in mid-January from Northrop, that's not Northrop.
Nortec.
Nortec, sorry. Then you will see selling non-compliant units. And my question was, and you will have an excess inventory, and where, so the inventory, then you will, what would you plan to sell that outside the district?
That would be the case, yes, sir.
Now, my other follow-up too is you were aware of the amendment to Rule 1111 that's going on today
For high altitude,
for altitude?
there's not enough volume there to make up the difference.
Not enough volume, okay. What kind of volume do you think you don't see any high volume of sales for that?
I don't think so.
Okay, I think you mentioned that last time too, you had 1 or 2 units at that, during that period, okay. Now, let me ask you this question. Now that you have somebody lined up, do you see a need to continue to look for somebody else?
No, I don't.
Okay,
I don't feel like we do.
okay, thank you.
Senator has a question.
Very last meeting, you talked about a manufacturer offering you some products and per month, and you told them what you needed for the next 3 months. I don't remember all the details, but you say, give me that supply up front, and by the time it's done, I'll be in compliance. My manufacturer will have the product that will be in compliance. Will you restate that?
I think that was Lennox at the time. And Lennox was able to provide us with 1,000, said they were able to provide us with 1,000 units. But then when we took them up on the offer, they became quiet.
Right, and in the order, it was stated that you would talk to Carrier,
Yes,
Lennox,
yes,
Goodman.
yes,
You testified you spoke to all of them, is that correct?
that's correct.
And no agreement was reached.
No agreement was reached, that's correct. We set up with Nordtech there, the last name I believe on the list.
You comply with the order, yes or no?
Yes,
That's all we ask that you do. Then you also talked about the companies that had not responded at that time with RIM, JCI, and Nortec. You said in the order, at that discussion that we had on 10/24/19, I'm just telling you, it's in the record. It's on page 4 of what I have. Line 6, 8, section B. That's,
You want Exhibit 7?
1B. Anyway, you said you have not at that point in time got a response from JCI, Nortex, or RIM.
I'm not sure why Nortec is on there because the first I heard of it was the last meeting, so,
I'm reading it right here, maybe somebody got it wrong.
yeah, I understand. We had never contacted Nortec previously, JCI and RIM, yes. And Nortec we contacted for the first time. They were brought to our attention, and we contacted them immediately
And you contacted them when it brought to your attention.
at the same day as the meeting, the 24th.
And you have signed an agreement with them, is that correct?
We have.
No disclosure agreement, yes or no?
We have, yes, oh, yes, we have.
So you are in compliance with the order. Therefore, do you consider your action to date to be in compliance with the order that was adopted 10/24/19?
We do.
That's all we ask that you do. Also, in the order, we talked about the number of units to be sold. And we've been picking between 100 units and less than 100. It's defined in the order. 3A, 3B talks about the number of units, 565 units per month. And it says, if you do not sell that many, you roll them over for 1 month and then you don't sell them then, you lose them. But it also says, we haven't had this report a month. The order has not been in effect for 1 month.
Correct.
And so therefore, in the order, however, it still stipulate that you give a report to the district. Is that correct, yes or no?
Yes,
Have you been reporting to the district?
yes,
So the district is aware of how many you've sold because they mentioned that today, is that correct?
yes,
You are therefore in compliance with the order in every category, yes or no?
yes, except for the 3A reduction of inventory from 3,000 units to 2,000 units, roughly.
And you said you gave a low estimate, is that correct at that time? You
We didn't-
underestimated what you thought you would have on hand.
We didn't sell as many units as we thought we would sell. That's correct.
So that if you sold what you thought you'd sell, then you have 2,000 inventory.
That's
Is that
right.
correct? But how many you have in inventory now?
3,000, plus or minus.
Well, then 2,000 is accurate right here.
Well, I have more than 2,000.
Then what is it?
3,000,
3,000?
yes.
Okay. But once you sign the contract with
Nortec,
Nortec, delivery scheduled for mid-January, is that correct?
that's correct.
And once you get the delivery,
That's it.
you stop, that's it.
That's correct.
And the surplus left over, what would you do with them?
We'll have to sell it off out of the district, slowly.
Would you deplete the 2,000 by selling them where?
Outside of the district, San Diego, up north, so on.
Outside of the district.
Yes,
And that way you'd be what? In compliance, is that correct?
that's correct.
So what's the argument today then? 100 or 565, which if you can report to the district exactly how many you sell per month. This hasn't been a month yet, but when you do that, if you don't sell 565, then it's reported to the district and you roll it over for 1 month and you lose the right to, you understand? You lose the right to sell the next, beyond that point. You understand that?
Yes, that's correct.
Then what is all that, what's the problem? Do you see any problem?
I don't.
What kind of modification would you be asking for? Except to include as your provider, Nortex, whatever it is,
Correct.
Nortex.
Wait, I don't think they're asking for a modification to include Nortec as a provider.
He's saying to remove all of the other stuff and just, we've signed on with Nortec, and so,
Understood, you want to remove everything else, but are you agreeing to an end date of January 2020?
mid-January,
You don't, that's not in the proposal.
January 22nd is there.
No, I think as we discussed earlier today is that the end date we had proposed is, I'll say it's awkward clearly because you guys have questions about it, but we had put in an end date for sales under the OA because when the order arrives, we agreed that sales will stop on that day.
Okay, but that leaves a very open-ended.
I appreciate that.
But
And
what you're asking us to do is take out all provisions of dealing with any other suppliers, stick with Nortec, then come back to us after the date for which you are suggesting or stating in testimony that you'll start receiving the adequate orders, and then, leave it open-ended, so then you can come back and say at that time, you don't have adequate orders, but then there is no end date, and there was no discussions with anyone else in between.
No,
So I have a hard time. I understand they're not asking for modifications, but what they're asking for leaves very open-ended. I want you to understand that, a very open-ended order.
what they're saying, what we're saying to them based on the order, that when you get the supply on hand, you stop selling the non-compliance unit, period. And that's anticipated. That'll be the middle of January, yes or no?
Yes,
That's your delivery schedule. What if they done not delivered on time?
they're in big trouble.
What do you mean big trouble? What do you mean by that?
I'm not coming back here again, I can't take it.
Well, is there a penalty clause for non-delivery?
There's not a penalty, they'll see me in person, it's just not gonna go down that way.
So therefore, we
Can
put,
we
can't
quote
do
you,
this.
and what happens then when you come back under your proposed January 22nd, and you say they didn't deliver? What then? Where are we left? I see it very open-ended. I want to be very clear to the board. That's why I'm very concerned with rushing a decision today, because it's
Madam
very
Chair,
open-ended.
I'm still on my privilege.
I mean, we're fine putting an end date in the agreement, end of January. Gives it a 2-week buffer from what they're currently telling us. And if for some reason we have an unexpected delay, then that's going to be on us to come back in and try to convince you to extend that time. And we appreciate that would be a big ask.
For cause. Cause there'd be a reason.
Yes.
Okay, and maybe you can offer a big penalty, a big fine at that point in time, too, if you choose. But I think that if you wait 2 more weeks, because the district can't be present, they'd be selling whatever they want to sell based on the order. So you gotta, they can sell until they exhaust this supply.
No, they would still be limited. We would just not modify. So they still have a limit under
I understand
the
based on the
continuing
order,
order.
based on the order. So that's a lot. It's kind of open-ended as far as I'm concerned. Let's give them something to work with.
But wait, are you then well, we're not in deliberations yet, but you're suggesting that somehow today we're going to be adopting a further limit.
For a limit.
You're not, because that's not what's proposed by respondent. So I'm not clear that that
Respondent
makes
is
sense.
saying they want to put a timeline on when they can be delivered. And they give themselves 2 weeks.
That's different.
A 2 weeks grace period.
Do you have additional questions? Because Mr. Balagopalan says he has questions.
Well, I'll just yield to you momentarily.
Okay.
Mr. Winters, I meant to ask and I forgot. You heard the representative from Goodman, Mr. Pomeroy, talk about the concern about the variable speed units. Can you elaborate on that? And because in their letter they said that it should be how it should not be allowed to sell those.
From the product that I've seen being sold, his concern isn't a concern. What I've seen sold are baseline units. I have not seen what he's talking about to be a concern.
Okay.
He sees that as a weakness, but I think that's a weakness relative to himself and maybe Carrier and maybe Lennox, but it's.
But you're selling baseline, a base.
From what
model.
I'm seeing sold, certainly you could, and I'm not saying that there weren't any purchased, but you're talking about a single hand here that I've seen, very few. It's not a concern. I mean, the fella, Goodman, I think, is like 40% of the market share here. So really, no one asked them what their market share was. Someone should ask them, because you have 180,000 units, what's your market share? Even if they won't tell you how many they sell, market share is.
Okay, that's, I appreciate that, but that's another question. So, I did have one more question, now it's just blue. Oh, yes, you would still continue to negotiate and try to get back with American Standard and sell their, establish the ongoing relationship you had with them once they have product.
So
compliant
American
product?
Standard is a given, because that's the mothership brand that we sell. That's our existing relationship, and that's why we couldn't go with Goodman, because we weren't prepared to give up American Standard. So we would always pursue the American Standard option anyway.
But right now you don't have,
They don't have.
they don't have the product, and did your contract expired because you had a exclusive arrangement with them before with
So in 2018, they had an exclusive agreement we didn't change it. They changed it in 2019, which worked out nicely for everyone. It was a non-exclusive agreement.
Right.
So we were able to look to someone else, how fortunate that was. And so we were able to sign on with Nortec, and we're in a good place. We just need a little bit of time to get past the production issues not issues, they don't have issues, they're just getting in line. So there were folks who were there way before us. So they get theirs first, we get ours next. So that's really what it is, it's a
and
line.
once they have that, as soon as you know that they have products, then you will put an order in.
No, we placed the order already.
Already you placed
Yes,
the
sir,
order?
we
Okay.
placed the order as well. So now we are just waiting for shipment, and we believe that shipment, there's no reason for us to believe that we're not going to get that shipment at that time.
And what is the?
Around the middle of January.
Middle of
Could be
January
a little
also.
bit before.
Oh, about the same time as the other unit? I'm talking about American Standard.
Oh, right, yes.
So you're expecting, because I heard previously
Yes.
testimony, maybe it'll be February before they get the product in.
No, that's their own manufacturer. So there's two tracks that they're following. One is their own manufacturer, very good. One is their own manufacturer, and one is buying from a third party to take care of their interim needs. So we were discussing the interim needs is what the district was asking us about, where they were going to buy it from a third party. And they haven't completed an agreement with that yet. Their main track is to make their own product. That is supposed to come, somewhere around the February timeline, but that's not the one that I think district was talking about. They were talking about the interim buyout product. I believe if I was going to speculate about what they meant whatever comes sooner. That would be a fair statement.
American Standard brand.
Correct, yes.
May I?
I just had a question. Given the February timeline of Train, is that what you just said? Train is supposed to have compliant?
Their own manufacturer, as
Okay.
opposed to buying from a third party.
Can you tell us with all sincerity, you're not waiting for that to occur?
No, I'm not. I already have my deal with them. So I'm going to be selling the mismatch that the chairwoman has been talking to everyone about. I'm the guy who's going to sell the mismatch. I'm going to sell a Nortec furnace with an American Standard condensing unit.
I understood, but my question is, you're agreeing now to a January 31st deadline for this order,
Right, latest.
latest, with something from Nortec.
Nortec.
But the very next month, Train is rolling out its,
I mean, here we
It's
are
manufactured
today. They
product?
don't have any, I mean, if the district is uncomfortable with an open-ended situation, do you honestly, you want to sign on to the IR open-ended?
May I go back and be recognized?
So let's
I
not,
find it,
we're not doing open-ended. We have an order in with Nortec. They've taken the order. They've told us that they can ship in that timeline. They've committed to that, and we're going to follow with that commitment. If IR does whatever they do, whenever they do, that's beautiful. That's a lovely thing. We'll have 2 lines of furnaces. How much wonderful that is. But for now, Nortec.
But earlier today, you were not able to tell us with any kind of specificity or precise numbers what was offered to you rolling out before mid-January by Nortec, and why are we waiting till January to start bringing in compliant product from Nortec? And I'm not hearing any reason other than what I'm also hearing is that train is rolling out in February.
Well, train is, okay, so Ingersoll Rand is taking 2 tracks. They're buying out product and they're making their own. So I think what was being discussed was a little bit of mingling the two. So they're buying a third-party furnace, which they've told me they will not, if I ordered it now, they wouldn't have it till sometime in January, because they can't take orders because they don't have an agreement signed yet. I'm further along than them.
Wait a minute.
I have an order in, and I have an agreement signed and an order in. They don't have an agreement signed. That's right, that's from them buying.
I
from
take
the
back
third-
my time. Thank you. Trying to get done with this situation once and for all, finally. And when you agree to something, you got to stick to it. Okay?
I am.
And what you decided to do was to say you can sell, according to the order, 565 units per month.
Correct.
Okay? We got about 2 months left between now and the end of January. That means you're going to sell, at worst case situation, 1,130, period. Okay. What?
Somewhere between that and, well, it kicks it, theoretically, you could sell 1,500 if I was,
I'm just,
going
well,
crazy.
no, you're getting complicated. The fact of the matter, 565 a month?
565 for October till what, the first week of November, the district.
Oh, October, I was just thinking of November, December, January.
And then, right, and then November is not over yet, and then you have December, nothing carries forward. So, I mean, in theory, if I was operating at 100% and I sold every single furnace that I could, it would be about 1,500 units.
Okay, well, let's hypothetically say the numbers will change accordingly. But if you sell 565 for 2 months and then add to it for November and October, however you want to make that adjustment with the district, you will be selling like 1,100 and something. You have 2,800 left over in surplus that you didn't sell, but it's going to be less than that now when you take in October and so on. All right? At the end of that point in time, say that you want to give us 2 weeks latitude that you have your delivery middle of January. If you don't get it by the end of January, you're not going to sell any more non-compliance units in the district.
That's correct.
Will you agree to that?
That's correct,
You
yes.
stipulate to that? No more.
That's correct.
Complaint day?
Yes, sir.
Fine. So then therefore, your order will be received or not received, the one that you buy from Nortex. You give it 2 weeks grace period. And if you can find some other manufacturer beyond the end of January where you can sell a non-compliance unit, fine, so be it.
Wait, compliant. But what they're asking is to take out any requirement that they look for anyone else in the interim.
Well, Madam Chairman, we already have someone, so why would we need to find someone else?
I'm simply correcting what the senator just said.
Yeah, we can structure it in such a way where whomever is available at the time, whether it be Nortex or anyone else, that will provide you the equipment so you can sell within the district. Otherwise, you can't sell it.
Correct.
So you put yourself out of business if that comes the case, fine.
Well, I'm counting on someone, and they better not let me down.
I know, good luck. Hope it works out for you. But that's what I think should be done.
Okay, well, we're going to get into deliberations, I assume. Dr. Bernstein, did you have questions? I thought you were indicating you had questions. Okay, no other questions. Okay. Okay. Then I'll close testimony. Oh, did you have more questions, Ms. Reichert? Okay, and there were no other members of the public who wishes to be heard, right? I had Sean Monty, but he went home. Okay. Okay, then I'll have Ms. Reichert give a closing and Mr. Williamson give a closing, but I'd like to be very clear what this board is being asked by each side to adopt at this point, so we can really go through it, because I'm very concerned given the late hour. Okay. Ms. Reichart?
Thank you. What respondent is asking for is not a modification of the order. They are basically asking for permission to do whatever they want. And they're asking for perfection, they're asking for an ideal situation, and we are clearly not in an ideal situation. And an order for abatement is designed and meant to bring an entity into compliance as quickly as possible, and they are asking for a lot of leeway in that interim period. We've identified that they should have a path to compliance in January, and they want to just sell as many units as they possibly can in the interim, and that is not what an order for abatement should be. We heard a lot of testimony here today about, well, I didn't know what was in the order, and I wouldn't have agreed to that, and I think the previous order was agreed to just because they wanted to get something done, get something going. They clearly would be unable to comply with the inventory reduction, and the idea that in a 30 days time frame they were going to be able to sell or dispose of 1,300 units is absurd. I don't believe they had any intention of ever complying with that. They agreed to continue to investigate sub-distribution agreements, even though they had no intention. It was always infeasible. It was always not a viable option. They stated that they had not heard anything about Nortec. It is in the order. Nortec is mentioned in the order. They said he had never ever heard of it until the order for abatement, but we had clearly reviewed this order and stipulated to it. And in fact, I will just draw the board's attention to the interim variance hearing on September 25th at the timestamp of 2/23/49 to 2/24/18, in which I asked a number of questions regarding Nortec, and that it was brought up at that time back in September. So the fact that he is now testifying that he has never heard of it until October 24th, it's either very poor memory or a lie. And at this point, it's actually a relatively simple discussion for the board, because since we do not have a stipulation, the board has to find a finding of violation. Mr. Winter has testified that he will not violate the district rules. He will not violate an order if it sets it at 100 units, and if the order is terminated, he will not continue to sell non-compliant units. Therefore, I don't think we even have a violation. So save for a stipulation between the parties, upon which this board can find good cause to issue that stipulated order, which it seems that we are very far apart on that. I don't think that this board can make a finding of violation and can issue an order. If this board were to propose terms that the parties could consider stipulating to, we could look at that. But unless respondent is willing to stipulate to the terms that I've proposed, we have an opposed order, it's not stipulated to, and there is no violation. I think that this respondent has not shown good faith, despite what he claims, that he mysteriously says that he's been trying to not sell too many units because he doesn't want to interfere with other people's businesses. But if his business is truly at stake here, why isn't he selling as many units as he possibly can? I still don't understand about this only selling a system. I don't think we had a sufficient explanation for that. I don't buy it. I don't buy much of this testimony. I think that they, as was mentioned by one of the public commentators, they've created their own self-imposed obstacles. They want an ideal, perfect situation, and that is not what we're here to give. They have had opportunity after opportunity to have access to product immediately. They could have access today. If they had continued discussions with Carrier 3 weeks ago, they could be having product in 1 to 3 weeks from now. They could have product from Ferguson. They just want it the way they want it. And I don't think that it's up to this board to give them everything that they desire. Thank you.
Mr. Williamson?
I will start by simply stating that I, did not object during that closing. I don't think it's appropriate to interrupt somebody in their closing, but so much of what was just said is not supported by any evidence that was introduced today at this hearing. The claim that Howard Industries could have had product, immediately weeks ago, nobody has supported that testimony. The district certainly has. They have suggested that there were options for them to explore, but that just is simply not supported by the testimony today that was introduced to the board. Backing up to the issue at hand here. I first wanted to address the argument that a modification can't exist because there's been no violation. I think that is not true based on the previous position that the hearing board has taken in issuing the order to begin with, primarily because there is an order for abatement that has been issued by the hearing board. This is a modification hearing, so the presence of a violation is not required in order to modify a order. And if it is required, then the result would be that there would be no, the previously issued order would just stay in effect. Anyway, that's probably not appropriate for closing. We probably need to have a lawyer's discussion on that fact. But I want to back up to the issue at hand here, because what the district ignored in their closing is the support for the various and specific modifications that they are requesting, and specifically the changes that they are requesting that the respondents are not agreeing to. Again, we had the three main categories of disagreement. The first disagreement was this demand from the district that respondents spend time investigating stopgap sources of furnaces, compliant furnaces, between now and 8 weeks from now, when ultra-low NOx furnaces are expected to arrive into their inventory from Nortec. The district has not disputed the testimony of my client that those interim options are not viable for him as a business. They have not provided testimony that sub-distribution is something that would work. They have questioned him, but they certainly have not provided testimony that says that yes, sub-distribution would work. And they certainly haven't shown why sub-distribution would work specifically for Howard Industries. I think additionally they have, we discussed a more broad type of concept, even if it was a straight distributorship agreement that met the service and technical support requirements, the infeasibility of doing that for such a short period of time. We had testimony about the onboarding process, the requirement to do sufficient training, that it would take at least 2 weeks to get that training done, then you need to get the product. Then you're talking about a couple weeks of sales and then 10 to 15 to 20 years of support, and how challenging that would be, and that it just is not a feasible option. So I would put forth to the board that there has been no showing of good cause to make that change in the modification to the previously issued order. The second change that the district is asking the board to make is to reduce sales from the previously agreed 565 units down to 100 units. The district has provided no compelling reason for that number to be the number that the board should set. They admittedly set it off of a period where Howard Industries was recovering from being closed for almost a month, and that their sales were depressed. And to continue to keep that, to require that level of sales over the next 8 weeks would be debilitating to Howard Industries, as Mr. Winters has testified to. And I guess and then the third issue is this inventory provision. We've admitted, and Jeff admitted, and Mr. Winter admitted in his testimony, that the agreement and the stipulation to include that in the order was done based on an incorrect calculation of what was in his inventory. And while he thought that he would be able to meet that, that inventory goal through sales under the order, it turns out he's not going to make it. At the end of the day, the inventory provision was included in the agreement as a way to keep sales reduced within the district. We are already agreeing to a sales limit. And so I'm not sure we could set up an impossible situation for Howard Industries. But again, we're asking as part of our modification to recognize the reality of our current inventory numbers, set a reasonable inventory level that we can achieve based on the other provisions in the agreement. And that's what we're asking the board to do in this case. So I think the testimony has supported the modifications requested by Howard Industries. I don't think the board has put forth compelling evidence or reason to support the modifications that they're requesting. Therefore, I would ask that the board adopt the modifications as proposed by Howard Industries.
May I have a brief rebuttal?
Yes.
Thank you. I want to address briefly the point that council made that that the board does not need to find a violation. The board would need to find a violation if there is no stipulation, and in lieu of that, the order should be terminated. I briefly want to address the 3 points that council mentioned. They said that the district did not present any evidence to change the order to take out or regarding the request to continue discussions with sub-distribution or others, but in fact, it's the respondent that wants to change that requirement, and the district would like to retain that in there as it was previously. Moreover, respondent would be responsible for actually investigating all of the aspects relating to a sub-distribution agreement to find out whether Carrier or some other manufacturer would be able to fulfill those requirements, as well as what the training would be, and they testified they never even researched it. They immediately dismissed it out of hand. Secondly, in terms of reducing sales, they don't even know what their sales are or what they need to stay afloat. We have based this number on a number based on preliminary sales that they gave us, which are constantly changing. We can't believe anything they say because even in this hearing, they have changed the numbers 3 or 4 times. It was 60-something, then it was 74, but it might be double because they don't know what the numbers are. So if this board chose to proceed with an order, we would ask that their monthly sales be drastically reduced. Finally, Respondents' Counsel remembered Mr. Winter's testimony. He stated that Mr. Winter thought that the inventory he had an incorrect inventory number at the initial hearing, and in fact, Mr. Winter testified he knew what the inventory number was, and he thought he would be able to sell 565 units in October and 565 units in November, and a couple hundred in Escondido, and he would get to the point where he needed to be by November 23rd. So there was no testimony to say that it was some incorrect miscalculation. That being said, as I mentioned, I do not think there's a showing of a violation. If this board did move forward on granting the order, we would ask that it be issued with the district's requested changes, but otherwise we would ask that the board terminate the order. Thank you.
I just want to understand. So you believe, well, first of all, let me read from the order itself, because that's where we have the ability to modify or not to modify. And it is the existing order, condition number 8, which is on page 7. And it says, this is the existing order. So you would have received the minute order, and it's, okay. I know. Okay, but they all probably say this, because I don't think anyone was looking to change it. The hearing board may modify this order for abatement without stipulation of the parties upon a showing of good cause therefore, and upon making the findings required by Health and Safety Code, Section 42451A, and the South Coast AQMD Rule 806A. And both those sections, well, 806A has even more findings than the Health and Safety Code, but both do require, if it's not stipulated, a finding of violation. So I want to be clear on that. That is correct. And so any modifications that we're being asked to approve or not approve today, if they are not stipulated to, we will have to make a finding of violation.
So again, I pose, that does not then lead to the result that the current issued order from the hearing board is terminated?
That's what I wanted to ask Ms. Reichert. Ms. Reichert, where do you take from that the current order would be terminated? I mean, it does leave the board in a very bad position, because I believe the board wants to all members of the board probably want to make some modification, whether, I don't know if any of them are agreed upon. And so I don't think any of the board members feel that the current order as it stands is what we want moving forward, but that is the standing order.
Well, the district no longer stipulates to the standing order, and so therefore the order should no longer, we're here to examine the validity of the order. And so I would make a motion that we should terminate the order. Because it's, the district is the one, it's their responsibility to bring the order unless the board brings a motion of its own accord. And so the district would make the motion that if there is not a finding of violation, that the order be terminated.
This was raised once before in a long time ago by a district council who no longer is with district council's office, of pulling a stipulation after an order is already in place. I would want to see that briefed, because my understanding, or what I would believe to be the proper, is that the parties stipulated to that, presented it to this board then approved it, it became an order of the board. I don't believe that by pulling stipulation in hindsight, it can remove the order that was already granted by the board because the parties agreed at that time. But that doesn't tell me where we go from here. But if Ms. Reichart, you believe that there is authority for that, then I feel that the parties will have to brief that. And I guess what I would ask is there anyone who would be able to take over this matter while you were away? I assume the answer is no. Okay, well, I don't, unless we have authority for it, I don't believe that that is the outcome. However, what we're left with is either a finding of violation, which I agree with Ms. Reichart, I'm not sure where we can find that, since there are no furnaces being sold in violation of Rule 1111. However, then portions that respondent wishes to remove from the agreement, from the order, including the inventory, that would remain in, and you would be in violation of the order come November 23rd, which could then be enforced by the district. Board members, we have that sticky situation that we have to deal with. Senator, did you want to?
If you're selling furnaces today that are not in compliance with 1111, then it's in violation.
No, it is not. They have an order that allows it.
I understand they have an order that allows it, but it would otherwise be in violation, period. Now, we got to hold our feet to the fire, yes. And we got to come up with some kind of a modification. And what I suggested early on is that we put a timeline, dead reckoning when they have to be in compliance. Either you can buy from the text or whatever.
And that would be to terminate the order, but we don't have an agreement.
We're not terminating the order. What I'm saying that this board has a right to amend the order.
No, we don't. Not unless we can make a finding of violation. Well, first,
sorry.
I don't know if Senator is done.
We'll seek a violation, but should we find that there is a violation, here's what I'd like to suggest. That is, your deadline for being in compliance is the end of January, whether you buy it from Nortec or any other provider at that point in time, period. Failure to be able to negotiate a contract and have on hand furnaces that's in compliance with 1111, you have to truncate, discontinue, sell it to non-compliance. At that point in time, you can't sell anymore, not in the district.
Are you, I'm
Uh,
sorry.
And so therefore, up until then, but you shall be in compliance with the stipulated order. You say you have a contract, non-disclosure. You're required to show that to the district, and I think you've done that. And therefore, having done those things, you're in compliance with the existing order.
Okay, but the question is of modification of the order pending no finding of violation. And I just want to, Mr. Balagopalan, I'll go to you in just 1 second, but I want to underscore the initial, the last hearing, I definitely made comments about my concerns that this walks a little bit like a variance. And I think what we're finding right now is that when push comes to shove, it's becoming clearer that it is acting like a variance, and that is because there is no violation. Usually, orders for abatement are meant to address a respondent that we find in violation of a rule and bringing them into compliance. But if this were to terminate today, or if we were to try to modify this on our own, we can't find a violation. We have to find the violation by putting them under an order. The order allows the violation. So it just seems like a more of like a variance, and that's the problem that we're facing right now, is we can't find a violation in order to modify it. And I feel like it needs to be modified at the very least to make it end in January.
No, I agree, it has to be modified. I'm just wondering, because there is a penalty assessed, because it's considered a violation, every unit that's been sold, there's a penalty assessed, which is a determination violation. That doesn't go away because that's an agreement. I'm assuming there's a separate agreement that was signed, so I don't know how that plays into the violation, because
Can I provide my thoughts on this? If they continue to sell, even if it's under the order, it still remains a violation. If they continue to sell pursuant to the terms of the order, it will not be a violation of the order, it would be a violation of the rule. Because the
Okay.
order doesn't give them, it doesn't relieve them from complying with the rule. It just provides the conditions under which that they can sell pursuant to the board's jurisdiction, but we do still assess penalties, and it would still be a violation of that rule. My point was that if they stopped selling, they would no longer have a violation. But if they are to continue to sell, they would still be in violation of Rule 1111.
Okay, so then we can make modifications.
yeah, that's what. And I think maybe there's some point maybe both the parties can, maybe after you hear what the board thoughts are, can come to some kind of agreement on the stipulated order, and to work around this issue. Otherwise, there is a stalemate here, and so I can start, the discussion. Or do you want to?
Yeah, if you want to, I wanted to frame, if you don't mind, and then I'll step back and let you take it from there. But I just wanted to frame for all the board members, because I want us all, before we have this deliberation, to really be looking at the full picture of what we're considering here, because I think that we're very focused on Howard Industries, as we should be. They are the party here, and I do believe that the concerns expressed by Howard Industries are very viable concerns, which is why we're in this order for abatement in the first place. But there are a lot of other concerns we need to look into. First of all, I wanted to, number one, note that this is a very different matter than when it was first presented. When it was first presented in October, we were dealing with a unique situation with a distributor who had no source of compliant furnaces available to them. None, zero. Now we're looking at, it's very encouraging that they're in an agreement with Nortec, but there are also a lot of other opportunities that we have heard today that are available. We heard from Carrier Corporation saying, well, first we heard from Mr. Winter saying that it was Howard that stopped all discussions with Carrier. Then we heard from Carrier Corporation, and Mr. Springer stated that in fact that was the case, that they did have compliant units available, that they were offering a direct distributorship, and that they have not heard from Howard Industries. So there is that option available, and really what we were trying to do was make it so that the point of this was to try to eliminate violations of Rule 1111, but make sure that Howard Industries stays afloat. And I think we need to consider that those options were not taken. But I also want to say just one other thing, and then I'll turn it over to Mr. Balagopalan. I'm very concerned that we are, from what we've heard from all the manufacturers, from what we've heard of, and what we've seen in the documents that we looked at, the emails, that we're essentially creating a new market over these months for non-compliant products, that we've heard from several of the manufacturers. They're more attractive to contractors. Contractors want to go with what they know. They don't want to go with new. There's a lot of training that's involved in it. It's more attractive possibly in price. We don't know the final numbers on that because we don't know what the penalty is, and that's fine. But we are creating a more attractive market for non-compliant units, and we're giving that monopoly to Howard. And it is having an impact on competitors. But more importantly, and this is just what I wanted to say, it's having a very big effect, I think, on Rule 1111. And we heard, what we keep hearing, and in all of our other hearings too, is that manufacturers have been working very hard to come into compliance. Most of them don't have full product lines. And having one distributor out there who can, without a large restriction or any real restriction, just put into the market these non-compliant units really undermines Rule 1111. And so my concern is that we have some restriction on how much they can sell monthly, and I'm not hearing anything about a viable restriction beyond 565, which is what they were selling in 2017 to 18 and 18 to 19. Or, yeah, I think those are so those are my concerns. I just wanted to make sure that we all understand there's bigger issues here. And I'm sorry, Mr. Balagopalan.
No, I think I'll take that issue first on the sales. You know, we did hear the testimony based on an email that, the 100 units, but I think we also heard from Mr. Winter that there was, and they turned the switch on. It takes a while to build up the sales, so I think that's a reasonable explanation why they didn't have that many sales to begin with, but they're ramping up the sales. So to go back and say, okay, I think we're going to limit to 100 units, it's very unreasonable. I mean, because we agreed to the 565 based on average on the historical sales, and then put in a 5% reduction, and with the imposition of a mitigation fee and the penalty fee. So it's more hearsay. What the email we got on the fact that and to limit their sale now suddenly drastically to 100. I don't find any support for it. I don't see any strong evidence, to support that. And I can understand the onboarding issue that Howard is experiencing in trying to bring up the sale. So
I didn't want to jump in the center, but more, I'm not necessarily saying 100, because we're even hearing from Howard numbers that were higher than 100. Possibly, even though we don't have end numbers. But something between 565 and 100, which isn't going to harm as much as it seems it is, or making such an impact in the Rule 1111 market. And we're not getting that from Howard, and that's concerning.
Yeah, and I thought at one point when Ms. Peralta asked that question, they were going to go back, and I thought coming back with a number which we didn't hear. So yes, I can, if there's a number that Howard is comfortable with, which is lower than 565, we like to hear it, and I think the district would too, and that is something that we can put.
If you're open, we had opened it up to and discussed, we were prepared to reduce it below 500 to 490. Again, sorry, to cover our 5 locations within the district. And the concern that we have at the end of the day is if we go significantly lower than that, we're going to get into one of these start and stop where we're operating for the first 2 weeks of the month and stopping. And we already did that once with customers, and having lost them once, they're gonna leave again, and they're just gonna say, we're done with Howard. So we can't have situations where we get 2.5 weeks into the month. So that's why we're struggling, and we spent the entire break talking through this. But we are, because we hear the board, you guys want to see additional reductions, willing to drop it down below 500.
And with the 5% subsequent
Yes.
after that? Okay, all right.
All right, thank you for that. I'm going to close the testimony again, but go ahead. please
Yeah,
talk about it.
and I think on the other issue the onboarding process, and also in trying to get the other manufacturers to contact other manufacturers, other distributors to, they already, and I think the initial order required them, and we were skeptical, I know I was, whether, how Mr. Winters will negotiate for this, but at the end of the day, they did negotiate. They did get somebody that, and I can understand their business decision is selecting somebody. They don't have to go with whoever says, hey, we got a deal for you. They need to look what's best in the best interest of their company, and they found somebody, and they're willing to go. So I think that they've taken the step, and to continue those discussions seems pointless at this point. And if we can hold them to it, if they don't get somebody, Mr. Winters is very sure they will get it. If they don't get it, then it's on them. It's not, but I think that the fact that they have initiated it and they got the order in, and at the same time they already put in an order for American Standard, shows that they are pursuing it aggressively and trying to come into compliance and want to get out the order.
Did you mean American Standard, or did you mean Nortec?
No, Nortec is one. They already, but they also, he said they already have a order in with American Standard, and as soon as they deliver, not from the manufacturer itself, which will be late February, but from the whoever it is they're getting from, in somewhere mid-January, some point. And I think the other issue with that is, no matter who they go with, they have to go through this contracts and negotiations and so forth. Will take some time, and then you have to set up training with the manufacturer and everything. Everything now has been set into place. They got December 3rd, we heard, as the training date for their staff, and then they will go forward with that. So I think they're moving in that direction. So in that respect, I think the order that that we had issued before, I think with the modification that we reduce the quantity, which if the district agrees, and then I think it's not unreasonable to we could put it back on there that they still negotiate, but I see it as pointless. But if that district feels that it needs it to be there, that still continue discussion, maybe, and that's why I'm saying maybe there can be a compromise, they can still look into it. But I feel it's a pointless exercise if you have already an agreement. But maybe you can, put it back there. But the one information that the district wanted, which Mr. Winters said it's a lot of work, maybe within 7 days, I think the district wanted to know which distributor is selling it, I think. And they, within 7 days, maybe,
No, it was which warehouse they were
which
selling.
warehouse, okay, I'm sorry, yeah. So
have
that, but he said, and maybe that, again, maybe, 7 days, we could change it to 2 weeks if that's reasonable, because it'll take them some time if they agreed. I think that's one area, again, you could look at compromise, on that particular aspect of getting which warehouse, because there is some challenge because it doesn't look like they're very automated in that respect, but I could be wrong,
Well, to be fair, I didn't ask questions on that because I was trying to expedite things.
Sure,
but-
yeah. And so I think those are the areas that are sort of in the district and respondent are in sort of disagreement on, and maybe they can discuss it and come into some compromise, and we can have a stipulated order.
Senator.
Just last week, we implicated ourselves in a competition issue. We find good cause did not address the issue of competition.
I'm not sure
Did-
what you're
Please,
trying
let
to-
me finish. It did not address the competition, but due to extenuating circumstances, and we talked about those circumstances, people in the cold weather need to have a furnace above 5,000 feet. we allowed that to happen after we had already provided that privilege to some of the other manufacturers. You said, okay, well, if you let them get away with it, let's let the other manufacturer.
I have to stop us there. That is a whole nother matter.
I
and
know, but-
other, and it's a high altitude market,
Madam
not
Chairman,
this, which is all
Madam
markets.
Chairperson, the similarity is the same. The opponents to this issue before us today talked about competition. And therefore, hopefully they would persuade us to go no based on we giving an advantage to Howard. That's what, I got that from that discussion, from the witnesses. So what I'm saying to you is that at some point in time, we'll employ the fairness doctrine to Howard as well, in my view. We can set the conditions, first of all, the stipulated order that's approved November 24th is ironclad, it's good, well thought out. They tell you the number of units you can sell per month, and you have to report it. They also tell you to go out and get yourself a contract for those who can comply with 1111, period, and notify their district. In those cases where you could not come to an agreement, notify the district why you've been unable to have an agreement with these other providers.
We need to take a short bathroom break. One of our members
Sorry, I had
needs
too much
to
to
leave.
What'd you say?
One of our members needs to go and visit facilities. I'm sorry, let's just take a 5-minute
5 minutes. Okay, thank you.
bathroom. Too little time. Okay, we're back on the record, and I think we interrupted the senator.
Sorry about that.
Once again, I almost got my voice back, but I lost it again. I would say that we still should make some change, even though it's the ironclad order that was stipulated to, in my view. That does some good and provides some protection. We still should tighten up even more than what it is right now.
I have to, oh, go.
For example, as I said early on, that we give Howard a deadline to receive the compliance order from Nortec. Although they say middle of January, we say if you don't receive them and be operational by the end of January, you still have to stop selling the non-compliance unit unless you have another provider that can sell you units that would be in compliance, period.
That's not part of the order, though.
I know, we're going to amend it to hold their feet to the fire. If they say they can do it, if they can't do it, if they can do it, fine. But the other disadvantage,
Just to be clear, we agreed to an end of January termination date on the petition or on respondent's proposed order.
I haven't heard if there's a stipulation from the district.
Our proposal was January 22nd. Is that not?
January 22nd was the date of the return, and January 22nd, I believe, would be a better date. if
Sorry,
that's-
I'm saying is that the proposal from, we don't have a stipulated order, so I was saying that we are modifying our proposal to the board to include a termination date for the order of abatement of January 30th.
Would you agree?
31st.
Would you agree and stipulate to the 22nd?
I think we wanted to get the 2 weeks just to have that cushion in case their orders are a little bit late.
that's how.
And we don't have a stipulation anyway. I don't-
But I'm just saying.
Maybe
you
we're
might-
trying to do
you
is
might-
build a stipulation.
I'm back with you.
You might have
guys.
one. If you can hold your feet to the fire, fine, why not?
I'd like incentive to push this forward. I'm not seeing, and Senator, you raised that this was an ironclad agreement or order, but unfortunately, today, I think we were all assuming that there would be an agreement. Well, I think we put this status and modification in the agreement because of when Carrier, Mr. Springer, had gotten up and had testified, and we thought, we were all encouraged that that would occur. There's a different agreement, but that agreement is going to take a lot longer. And so it's concerning that the order as it stands is not.
The time frame you put in the existing order, give us a status report within a month. But the order has not been in effect in a month.
I'm sorry?
The order has not been in effect a month, and yet you're having a report within a month.
Yes, and that's because, as Carrier re-testified today, they were already in discussions. A distribution agreement had already been sent to Howard Industries. As of November 4th, that was the last attempt at communication, and here we are on the
testified to that?
Here we are on the 14th, and
You testified to
Mr.
that.
Springer. And here we are on the 14th, and Carrier still had not heard until today
Mr.
that they were no
Springer.
longer, let me finish, that they were no longer in discussions. And so my concern is there is a dragging of the feet.
No, just a
My
minute.
concern is this order is not strong enough and that more incentives need to be built into it because, again, we're supposed to be bringing them into compliance quickly.
You voted no last time until you saw 3 votes. So what's the
That is not what happened. Well, it got amended, and I was happier with
But
it.
that's, the amendment was have a status report, so this guy can come back and say the same thing he said last time.
No, I just got through saying, we were encouraged by testimony that a distribution agreement had already been sent to Howard Industries, and we expected and hoped that there would be an agreement and that there would be compliant products coming soon. not in January. But, okay, we have in January.
I didn't hope-
I'm concerned, I would like that not to drag even further, and I would like to see more incentives in
And I
here.
would like to see it approved and done with and out of here. You like one thing and I like another.
Well, okay, I'd like to not see Rule 1111 completely torn apart
We just did
by
that
our
with
decisions.
the above 5,000 you tore. You have about 6 companies you signed off on. Come on.
6 companies who are now going to be struggling to compete, even though they put compliant into the market. Now, again,
This
this
is
was a unique
microscopic.
situation because this is a distributor, not a manufacturer.
microscopic.
That's why we're here.
When I asked him the question, Mr.
No, well, we closed testimony, but
Last time, the gentleman in the back.
what,
He said, well, that's I said, why are you selling the equipment? Well, it's competition. We decided not to sell it. What are you talking about? It's all competition.
what do you mean? What are you saying?
Mr. Springer, is that his name?
Mr. Springer testified he did not end discussions. Mr. Winter testified that Howard ended discussions.
No, I'm talking about when he testified last time, when they asked him to give us a certain number of units to sell that would be in compliance. He's saying, well, that's not my decision, that's a business decision.
Okay, those discussions were ongoing, and we heard about them today ending. Anyway,
I don't know, I just don't understand where we're coming from sometime.
I'm very concerned about the effects
Okay,
on the world.
let's-
And you mentioned,
Let's tighten it up, then. Let's tighten it up.
that's what I'm hoping to do, and I was hoping to go below 490 a month.
You hoping to do what?
I was hoping to go below 490 a month.
Well,
My hope was to
Not with my
create
vote,
an
you're not gonna-
incentive to ensure that compliant units were in place and being sold as quickly as possible.
with my vote, you're not going before.
Dr. Bernstein, you haven't been heard.
Thank you, Madam Chair. So in looking at the orders and conditions and looking to tighten up the sales per month so that in deference to Rule 1111 is what we're here for. That is the centerpiece of what we're trying to do here, is coming into compliance with that particular rule. So I have sales numbers that have been shot around, and so I just want to, out loud, I'm thinking out loud. So we have somewhere between 67 and 70-some units that were sold between 10/24 and today, which is 10 days short of a month. So let's say that number becomes 100, all right?
Because it might be much, much more.
We started out with 565, right? The market conditions are changing. There's a bunch of factors there for sales coming down, ramping up, business being off. We've had a whole Harvard Business Review regarding this particular industry. And so it seems to me that we need to, for lack of a better mathematical formula, to look at the number that has been stipulated previously, which was 556, right? That's what I said, 565. I have a little bit of dyslexia, and 100. So to split that, looking what realistically, thinking that things are going to ramp up to come somewhere around 300, a number somewhere around 300 to start for discussions, to be the maximum number sold. With regards to the inventory, obviously the order condition was such that there was supposed to be no less than 2,000, right, non-ultra-low NOx furnaces, and we have somewhere around 3,300, I believe, that are still in stock. So how we move forward with that, I guess somewhere we need to have an incentive to expedite getting rid of more of the non-compliant sort of out of the district as opposed to into the district, because again, we're not trying to dump product. And I think that there's been statements, to my recollection, that have been made by Mr. Winter with regards to not looking to dump those units into the marketplace and trying to be careful. Now, that could be argumentative. There are people, it's interesting to sit here for hours and listen to someone speak and someone right across the room hear something totally different than what I heard. So having said that, we still need to deal with a number, or at least incentivize Howard Industries to do something with that inventory not in the district, apparently, it's because we're not looking to increase sales in the district. So perhaps there can be some verbiage that we utilize to come into compliance with that and feel more comfortable with the number of units that are non-compliant that are in your inventory. Just a comment, because you may or may not recall, I haven't been all that boisterous this particular meeting, and so I'll take one more minute. This is a very, all business is interesting to me, and this particular industry is very interesting to me because of the situation that occurs where most of the distribution models are sole source. Not all, but most. And so you're relying on that manufacturer for your livelihood and your product, and therefore, and whether because you feel it's the best brand, whether it's the easiest to get, predominantly it's because your customers are happy with the product that you're selling to them. I would think that's the major motivation. And so it becomes very interesting to then have to turn and look to deal with a competitor to help you maintain your business. In my mind, the fact that Howard Industries has not had to go and take loans out, has not had to lay people off, it really owes to the way that the business is managed. Not anything more than that. That's what it is. And so there is hardship, there's no question about it, with regards to what's been happening and what happened and why people weren't compliant, why manufacturers, there's one or two or three that have product, and the bottom line is it is what it is. And so each one of those people in that supply chain are having to deal with the reality. And this is how Howard Industries is, in my mind, is attempting to do that appropriately. Whether they're able to get rid of their inventory is fast enough or not and calculations made, I don't think anybody's trying to get over on anybody here. I don't get that impression at all. And I don't think anybody's coming in here and lying to anybody either. And so my impression is there's a way and a model. We have basic elements of a stipulation that we could stipulate to that are in front of us. Let's try to play with the numbers a bit to try to go forward, understanding that this should have a termination date somewhere around the middle of January, okay? Given that there's possible, well, at least for sure, one opportunity to enter into an agreement that an order will be there so that you could satisfy and move forward and sell compliant furnaces within the district by a certain time date in January. So let's try, in my mind, we have to tweak a few things. Let's try to do that so that we spent this day and came out with a positive result as best as possible that everyone could feel comfortable with. And so I guess I just need a little bit of help with the inventory piece. I've recommended a number with regards to sales per month and a time date that is somewhere around January the 22nd. I believe that people feel comfortable with that. Again, I forget the date that, let me just look and see when you thought that, Mr. Winter, when you thought you might get the delivery of the product. It was sometime around, does anybody have that?
I'm looking.
Sorry.
It was middle of January.
Okay, so to me, the middle of January is the 15th. Boom, you got another week. Let's rock and roll. The numbers should be amenable to everyone. At least I think that I'd like to propose that.
Thank you, Dr. Bernstein. Go
And
ahead, you're not done.
Just one last thing. Everybody's kind of summed up. I haven't said anything new really, but I think that what we're trying to do, it seems to me that the job of this hearing board is typically trying to take a round peg into a square hole as best as we can and get the best result possible, looking through the prism of keeping the air clean. And I think that's what we're trying to do today. No one's trying to shut any businesses down, and I'm not looking to punish anybody, at least that's not my perspective. What we're trying to do is take into consideration people's pulmonary health and at the same time work within those parameters. And I think everybody's motivated by that, particularly those that are about to leave on a 2-week vacation. But anyway, so thank you, everybody. Appreciate that.
Dr. Bernstein, thank you. That was very well stated. I want to say, I think Mr. Balagopalan said this. If there is an end date, I like January 22nd personally. If there is more of a limitation, I like the thought of 300 units or something along those lines. I don't believe we need to keep in the inventory reduction. I don't see a reason, because they would still be limited in their sales. So whether they hold it or they don't, they can't sell it in the district.
going to say.
And I also don't believe then that there would be a need. I think they have a vendor, they'll have incentive to go with that vendor or train American Standard, whoever has it available for them. I don't know that they need to continue to speak with vendors. I think I heard loud and clear, I think we all did, that this is a very specialized market with a lot of competition. And there's something to be said for, I think, what Ms. Verdugo-Peralta was trying to say is these narrow columns where it kind of just dribbles down from manufacturer through a particular distributor or a few distributors down to that level and having everything go through. Yes, please.
I came up with my own number, so it's 375, so it's 75 per store. I don't know, I've floated that out there. But the other thing is, I think one of the comments we got from Goodman was on the issue of variable speed units, and Mr. Winter didn't express any reservations on that. Maybe we can also, they were concerned about the variable speeds unit, being sold, so maybe we can put that as a condition also, if that's.
And what would that look like?
That was based on the comment letter we got from Goodman's attorney.
Yes, and what's the proposal that you would?
That they should not be allowed to sell non-compliant variable speed furnaces.
What period of time?
During the.
During the order of payment.
Yeah, and Mr. Winter indicated, maybe it's one, they don't really do much in that.
There's a cap on that, isn't there?
No, period, no variable speed unit furnaces to be sold.
What period?
During the duration of the order.
Variable speed.
Can we just clarify that piece, Mr. B, about that variable speed?
Yeah, let's do that in a moment. We can reopen for that.
Yes, that's what I said.
But I think, I know there's probably not going to be stipulation, but I want to be very clear that even for variances where it's beyond the reasonable control of, and I understand that you're in a position that perhaps it's beyond your reasonable control regardless, even for variances where we find there's no fault on the side of the petitioner, we still will limit throughput, sales, to less than what is normal so that we can limit excess emissions, we can limit non-compliance. And so it's completely, it makes a lot of sense in order for abatement. And I'm hearing that there are a number of us who would like to see that further limit. But if we want to open to understand the idea of variable speed furnaces.
Yeah, and I think, and I'm just referring to the letter, that from Goodman's attorney. And I did believe I asked Mr. Winter about it.
We actually don't have a copy of that letter. Could we?
Oh, you don't?
See the
Okay.
letter?
Okay,
No.
I mean, you can have mine if you want. Yeah.
Yeah, we're going to leave, Sarah.
Let me give oh, you give them a copy, okay.
Let me, Ms. Reichert, are you hearing the thoughts that,
I am. I'm trying to take notes of everything to.
I think right now on the table, and let's have you look at that variable speed, that Goodman submission. So, I'm sorry that you do not have it, should have had it because it was filed. But I think the thought is to have a January 22nd cutoff, to limit, so far proposed has been 300 units. Mr. Balagopalan says 375, somewhere in that amount, which would give an incentive. No.
He said,
No,
his
he said
average would have led to
300.
322.
Be, I guess, to split it up amongst each one of the warehouses.
Right, yeah.
And Mr. Balagopalan.
I said 375, so 75 per, because there are 5 warehouses, 75 each.
And again, understanding that this is a compromise to make sure that Howard Industries stays viable and keeps, as the business that you are for the short period of time in between, but does not completely unravel or undo Rule 1111. And I think it's a good compromise. Wait, let me just go through. No longer have the inventory restriction, because it's really just what they sell that's important. And based on the modification that's requested, no longer have a need to speak with other vendors with regard to this stopgap.
So if we look at the order, number 7, you would be, do you want to go one by one and we can look at the conditions and talk
Talking
about
about exhibit number 7?
exhibit number 7?
Yeah, and then maybe.
I'm just trying to understand your proposal.
yeah,
I'm
yeah,
not,
yeah,
I'm
yeah.
just so we know.
I have to find it. Is this it? No. No, that's A.
Are you paused? May I ask a question? Does that number choke you out?
Oh, yeah. Yes?
What's reasonable and feasible with you?
Okay, we already heard 490 was the number that they would go down to.
420?
Okay, so
We'll get to that.
number 1 in the conditions, right? I think we both agreed that we could leave those changes in, right? That's just working with American Standard, so that one we're not looking at.
Yeah, because they already have a
Yeah.
Okay.
purchase order, yeah.
So number 2, you're proposing to get rid of that whole thing,
Yes,
right? And number 3 would be the same.
right.
Okay, so I'm just marking so I know what your changes are. And then,
Number 4, you wanted where the warehouse with units sold. I think we
Right.
could keep it, but maybe give some time, a little bit more time. He expressed 7 days is too little for him to gather the information. Somewhere else it says within 7 days, so.
well, I'm just looking at what your suggestions
Oh,
are
okay,
right
yeah,
now.
sure.
So-
Yeah, so on number 4, I'd say keep your suggestion where you need to know which warehouse sold this unit, but give them a little bit more time to report that.
All right, so I'll make a note of that. And then, okay, so we're getting rid of 5, the part of 5A that talks about inventory reduction.
That's just removing the entire paragraph, right?
No, because there's also
Right,
Oh,
B.
Shall not
sorry, you're right.
place in
The
order.
From moreover,
that part, and then shall retain records would stay, reflecting,
Okay.
so we can adjust that based on what you're saying, but just that
we have
portion.
records of the sales, so we don't need records of the inventory, right? Because there's no inventory under the order.
Right.
Well, you had said, respondent shall retain records reflecting its inventory of non-compliant units. That's your language.
We would want this because it also is going to show at the end of this that no additional non-compliant units were added. So there's no reason not to have record.
That's fine.
Okay. And then for B, 5B, whatever number we put in there, right?
Right.
Okay. And 6.
So that'll go away.
So, well, the question would be is that we still have outstanding potential from American Standard, right? So, because they're saying they don't yet have, but so in order to potentially keep that in, so that if additional units are available, they would also place that order. But
Well, I mean, one of the problems is that condition would require us to then place an order for furnaces that we're already getting from Nortec via American Standard. So it's kind of nonsensical in the American Standard context.
unless American Standard has
Yeah,
their-
no, but I'm saying as drafted, it would obligate Howard Industries to do something that would make no sense.
So we could say, okay, so we could possibly amend that to just say, like, actual I don't know how we'd say that, but something about,
Yeah,
like, actually,
Sure, I mean, they're not gonna have a furnace by the termination date
well,
of the
maybe.
order, so.
Yeah, okay.
Can we just take that out?
So if that's not
Okay.
even a possibility.
That's fine, we can take it
Take
out.
that out, okay.
Well, I'm half agreeing. I'm not thinking through all my agreements, but yes, I'm trying to make notes.
We get 3 agreements today?
Okay, and then, so for number 7, obviously, I'm guessing that the board wants to change that last clause. I think we should have I hope this is okay for me to just posit. Something that's clear about receipt of furnaces, because, you know, it's like, how many furnaces are they getting? And once they get, like, I want it to be clear, like, when they stop selling based on whatever
Well-
happens with the delivery from.
Well, we'd like to see a drop dead date of January 22nd.
Right, we've got that, but then.
But we'd also like to see, or earlier,
Yeah.
based
If they
upon
order- yes,
what?
Yes.
So I think the number was 760 furnaces or January 22nd, whichever comes earlier.
Well, but what if they get a truckload, which he said could, if he gets a truckload a week, that would sustain him. So what if he gets a truckload of 110 furnaces or 2 truckloads, sorry, 2 truckloads? So it might not be that he has to get all 760 to cease.
Right.
So maybe we could come up with once he has received X number of units with some other potential thing, then he will stop. Because I don't want to say, oh, well, we didn't get all 760 today, but they can survive off of it. So maybe we can find something.
We
that-
could come up with some more specific language.
But
to
see,
deal
guys,
with
I
that.
mean, sure couldn't sell them according to the existing order.
These are compliant.
Oh, compliant, well, yeah, you sell compliance, then you forget about the other.
We're trying to figure out when the order would cease, and they would no longer be able to sell any
There's an edit, I
non-compliant.
should have gotten rid of 8C, there should be no
So it's
and.
about 110 per truckload, so 2 truckloads, about 220 approximately,
So 220?
220.
And then we
That's
need to-
right.
And then you'd need to add somewhere the no variable speed, so I don't know where you want to put that.
I think. Have you had a chance to read the letter and?
No, I'm paying attention to this discussion.
Oh, okay. It's on this back,
Multitasking.
second page on the third paragraph, I mean, on the backside of the letter.
Oh, I'm gonna have to excuse myself
Oh, you're not going to be here for the vote?
if you don't hurry up and do it.
Okay, well, we need,
But we have to draft the,
We're doing it now, right? Draft.
Look at it.
we could do everything but the variable speed and address that in 2 weeks when,
If I may speak, there are many models of variable speed. There's variable speed communicating, there's variable speed not communicating, it goes on and on and on and on. So I really think that's, I mean, I don't foot my business in that, but that's really pushing, you know, levels of, because
What do you recommend?
I don't think it should be in there.
And say it,
I don't think it should be in there.
and say why.
Because that's pushing it way too far, because if let's say I'm not bringing any furnaces, so if I run out of, by example, 2-stage furnaces and someone wants a 2-stage furnace, they're gonna have to take a 2-stage variable speed, and that's life. See what I'm trying to say? So at some point, even if it's within the quantity, but and the size, but remember, there were so many different models. Someone's going to have to move, if I don't have what they want, they're going to have to move up to the next one. If you don't allow me to sell them the next one, then I basically lose a sale.
but that's the breaks. I think you indicated that you hardly sell any of this, or,
Well, that's because they've been buying the cheaper one.
right. And
So
then
at
we are
some
talking only during the duration of the order, so.
Correct, yeah.
okay, so,
So can we leave that out, please?
well, we can determine, I mean, we'll discuss it amongst
Okay,
ourselves, but
okay.
but but you don't sell that many, is that?
Well, at this point, because they're buying the cheaper model, but I need to get rid of the inventory to the extent that I don't want to lose a sale, that makes this all moot. I mean, to not be able to take care of the customer makes no sense. So if, by example, they wanted, I'll throw you a capacity, 120,000 BTU, and I don't have any 120,000 BTU anything, right? So, but I do have a variable speed 120,000 BTU, they would have to move up to that model.
But we heard from other manufacturers that they have very limited product lines, some of them. So how is that different? How is that different? And the request from other manufacturers was at least limit their product lines so that we're competitive. So why is that different? Why is that different? I think, again, you're trying to go to what is ideal,
Yeah.
as opposed to what we should be looking at under an order for abatement.
I'm honestly not looking for ideal. There's not much here that's very ideal.
Okay, but, okay, well,
That's good.
I think,
Discuss it, yeah.
I think we should go back, thank you. I think we should go back to discussing, but I don't know what that looks like because I'm not the technical person, and I don't know if you understand
Honestly,
that.
I'm not all that familiar with it either, so, so I,
High-efficiency motor.
yeah,
That's what
I assume that's the case, and, so,
Not
but
familiar, like, just yield on it.
I just wanted to point out, the district did consider putting in that limitation, and I do think it's a good idea to keep so that the competition is on the same footing, whether, if they don't have product that's available that's different from the compliant product. So then the consumer, the contractor has to just choose between the two models that are available amongst perhaps a non-compliant and a compliant version, but then they're not forced to go to the non-compliant version because that's the only one available.
So you agree with,
With
okay.
no variable, with restricting their
Their
to
sale
no
of
variable speed.
But if I could, the difference is that the competitors who are claiming that they don't have a variable speed can go out in the market and buy that same comparable model, non-variable speed. And our problem is a limitation like that is just going to take a whole sliver of our inventory and make it unsaleable, and it's just going to sit there and be a money loss. And then we can't place orders. We've agreed to not place order for new units. So when we run out of a particular size where we would have a dual speed motor, we can't then sell that. So this is just another big hit for us. And as Mr. Winter testified to, it's not like we're selling a whole bunch of these into the market as dual speed. They would be a replacement once we run out of the single speed.
Okay, so
I'm
then
just not
place a
clear what
limitation
issue
that,
is that we're addressing is really, or what the issue that we're trying to address, we're actually addressing with this condition, I guess is what I'm
maybe
saying.
place a limit that they have to sell out of the single speed of that same product before you get to variable speed? I mean, he testified that's not the market, that's not what he's selling. You've got 3,300 units. The fact that you're going to possibly lose one or two sales of variable speed. An order for abatement's meant to be a punishment. This is an enforcement tool. You can't just get everything you want.
Hey, I make a motion that we hold this over until tomorrow.
We can't. Tomorrow's Friday.
I mean, I can come back tomorrow,
What
but
about Tuesday?
I'm on vacation.
Tuesday, that's the restriction.
Somebody got to sit in your place Tuesday.
No, I think Ms.
we
Reichert
can't
would
get a-
say she's involved in this
If you can't
case.
get a vote today, what you want, so you better wait.
Well, we can get a vote today. Well,
Oh, 'cause
let's
you
put
keep-
it to vote.
Just threw a monkey in the wrench.
It's not, it's just this tiny sliver. When we've received a letter about it, and we received testimony about it. And we'll make a motion, and either we'll include it or we won't, and we'll vote on it.
We can make a motion, but don't pluck the guy's eyeballs out.
Okay. Okay. Is there more deliberation
No,
we'd like to make?
that
I would like, it's very hard. I don't want to, I'm going to make a loose motion, let's say that, which will then have to be cleaned up. There's no other way to say
we're
it.
looking at number 7.
Okay.
We're looking at exhibit number 7.
Yes.
Okay.
So we're looking at exhibit number 7, and what I'd like to propose to the board is to make a motion. We don't have stipulation, and so as a result, we need to make some findings.
But you stipulated, she agreed to some of that thing.
Yeah, but it's not stipulated on both sides.
I think we can get to a stipulation if we take 5 or 10 minutes and go discuss.
We don't have it, we're about to lose our board members. I think that what is remaining is the date of January 22nd, 375 units. Is this something that there'll be stipulation on?
No.
I think we would ask for 400. And we could completely live with 400.
I think we'll be fine, yeah.
400.
80 per store, yeah.
Or 60 per store at 300. I mean, if you're going per store, I mean, you don't have to.
No, but I think you do have to have, a certain amount of sales too. So we agree, I mean, we're dropping significantly from 565 to 400. That's a big reduction.
This is not an auction,
No, it's not, but,
but you're acting like it.
okay, well, we're asking for whether the parties stipulate. And I'm not hearing
I
whether.
will not stipulate to 400.
400,
400, okay.
okay. So again, I'll go back to, we don't have stipulation. I think we can make a finding of violation based on the fact that the order is in place. It's not a violation of the order, but the order allows the sale, and the sale continues to be a violation. So even as we speak, violations of Rule 1111 are occurring right now, under penalties, yes. This is not, this order for abatement that I'm going to propose is not going to constitute a taking of property without the due process of law. We've had a very long hearing on this. The order of abatement results in the closing or elimination of an otherwise lawful business. That is not going to happen here. I think that's why we're trying to strike that balance. And so I think all the findings can be made for this board to modify without a stipulation. My proposal or my motion will be that in the matter of South Coast Air Quality Management District versus Climate Industries, Inc., doing business as Howard Industries, case number 6153-2, that we modify the current order as is in Exhibit 7 with several changes. Condition number 1 would be left as is, meaning with the strike-through, with the additions. Condition number 2 would be stricken. Condition number 3 would be stricken. Condition number 4, we need to give a 2-week, were you proposing a 2-week?
Yeah.
What is it currently?
At the very end, no later than the 7th day of each month.
Okay. So I will say, no later than the 7th day of each month, and the 14th day with regard to which warehouse. Each unit was sold. With regard to condition 5, numbering will all change, but 5 on Exhibit 7, A, taking out the word that begins moreover and goes to the next page and ends in November 23rd, 2019. My motion would be with B, to change 100 units per month to 375 units per month.
I thought you said 400.
My motion is 375.
So we'll amend your motion.
Okay, we'll see what the vote is. Number 6, condition number 6, I would strike. Condition number 7, we would, I'm sorry, 220?
20, yeah.
Yes, sorry, line 26. 100 would go to 220 ULN furnaces, or January 22nd, whichever occurs first. And, oops, sorry. I would add, I don't know where it will go, but I will add a condition, respondent shall not sell variable speed, non-compliant
Variable speed furnaces.
client variable speed furnaces unless it has run out of single speed furnaces. Does that make sense? at, I'm hearing it, and that would be fine, at
I
each,
think the request is that we have it location specific so that we're not having to shuffle inventory between each unit
At-
or each location.
at the particular location. And I'll figure out a number for that, and that would complete my motion.
Oh, do we have to change put the date,
sorry.
the order expiring on?
I think actually, it looks like
The
we
March
just
sale.
did that,
Yeah,
and then we said we have jurisdiction until January 22nd.
And there's a hearings,
Oh,
paragraph 9, it should get taken out as well, I believe.
thank you
Yeah.
for that. Okay, and we would delete paragraph 9. However, of course, there's always the opportunity to come back for a modification, further modification, if necessary on either side. But is there a second?
I'll second it.
I just want
Okay.
to do a quick cleanup on 8C to delete the "and" at the end. That was just,
Thank you. 8C, then we are deleting the word and putting a period. And is that acceptable, Mr.
Yes,
Valencourt?
yes, it is.
Okay. So we have a motion, we have a second discussion on the motion.
I don't see anything magical about 375. You talked about 400 plus, you talked about almost 400. Why not give the guy the benefit of the doubt and give him 400? I'd like to make the motion. I don't see any rationale for that.
Well, I think Dr. Bernstein wanted the average between 100 and 555, which would actually be about 330.
Let me ask him, Mr. Burnt, would you accept 400? Because that's what he wants.
Well, wait, there's a motion, and we will vote on the motion. The question is whether there's a discussion on that motion.
Okay, go ahead.
But the reason why 375 in my mind is because I personally would like to see a very strong incentive towards making sure that compliant units are brought in and distributed as quickly as possible. And also, I don't want to see a huge disruption in Rule 1111 rollout. And I feel we've heard significant testimony today and evidence that there is quite a disruption in the Rule 1111 rollout, and the governing board did not want to give any further extensions, and all the manufacturers have been working very hard to be in compliance. We want compliance as quickly as
They're
possible.
not manufacturers,
Okay.
they're distributors.
Okay.
Just one
Well-
point, I'm sorry.
I just wanted to bring it to a vote, and
Oh,
then we
yeah.
could.
Just one point. This won't preclude Howard from selling it. Once the board amends the rule, this won't affect that because it applies to anybody can sell at the high altitude if they have it, right?
Yeah, the variance is an exemption
Yeah.
Right. So that will no longer,
Not the variance.
it will
It's the
no,
order.
it will no longer be a non-compliant furnace. It will have an exception, so it will no longer be a non-compliant. So that's a very good question,
So the
but it
variance
won't.
was not even necessary. That, for high altitude, there was no need for variance at this point.
Well, they can't get a variance, but,
But the board is amending the rule.
the
to-
board-
I know the amendment of the rules, so it's not required.
Right, right,
well,
right.
we'll see, hopefully, but,
You heard all the arguments and they changed their mind. And we heard all the arguments here now and we become more restrictive.
I don't know what you're talking about. It's a totally
God,
different
it's
issue.
Howard.
Okay, I'm going to call for a vote, and then we can, and then
What
we
about
can-
putting the 400 limit in?
Well, let's
Okay.
vote on the 375
We're going to vote on
first.
the 375, that's the motion that's been made.
can amend it.
How do you vote, Senator?
No, you have to vote the amendment before the most.
No,
Before you
that's
call for the
not, that's
vote.
not how the hearing board works. We vote on a motion.
You have to make a motion to amend the that from 375 to 4, and then you can vote on it. You can turn down the amendment.
Are you saying that we can't vote on the motion that's been seconded? We have to first amend it by motion and then vote on it? That's not how it works in the hearing board. Can you tell us how you vote?
Robert rules, that's how it votes.
We don't follow Robert rules.
You know, I know, I'm trying to find out what rules you follow.
Okay, we follow the rules of the hearing board as they have been always.
I pass.
Do you vote? You don't vote? You're abstaining? Okay. How do you vote? Then it's going to pass. no matter how Dr. Bernstein votes. Do you really want to abstain, or do you want to vote no?
I pass for now.
Once you pass, and it carries, then there's no for now.
Don't call on me first, call on.
Okay, Dr. Bernstein, how do you vote? Okay. How do you vote?
I join Mr. Bernstein, Dr. Bernstein.
You vote yes?
Yeah, go ahead.
Okay. Motion passes 4-0. And again, thank you to the clerk for staying past 5. No, she's still here. Again, we will hear from the parties should we need to, if there's a request for modification, and let's hope that we get where we need to get quickly.
Would you like for one of the parties to prepare a modified order so we can get a final?
That sounds like an offer to me.
I'm happy to do it.
Please, that would be wonderful. And before we adjourn, I want to again, and I'm sorry that Ms. Verdugo-Peralta had to leave, but I want to adjourn in honor of Mr. Hank Weida and in the memory, thank you, in memory of Mr. Hank Weida and all of his phenomenal work on behalf of all of us for breathing clean air. So with that, we will adjourn for the day.
Sad days, you do your job and then you leave. It's one of those things.